Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm definitely not late. What are you talking about? Don't be racist. Let's go. Let's go. No more intro needed. I'm going to pull up the screen here. We're here just in time. Closing arguments have not started. I feel like I laid on a knife or something. I don't know why.
Noted, sir. All right, then with that, I will have.
Sorry, it took so long to get started up. Odyssey and Odyssey in particular was really slow.
I have permission to
get
put
started.
the easel up and display some of the poster boards. I did confer with Captain Dussault as far as security.
Also, what's up to the live chat over on Locals? How you guys doing?
Where would it be displayed?
It's gonna put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here.
Um,
And I don't have to
Don't
leave
talk
it
to
up
me
to
about
the whole
positions.
thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as,
Yeah, I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
So
All right.
Odyssey's having
What is
trouble.
that? What is supposed to be put up?
Hold on. Let's see if I can find this thing.
They were previously admitted, Your Honor, it's exhibit 15 and 130, I believe.
So are they exhibits?
No, that's
I'm
not what I want.
confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask to object and ask what.
Okay, Ken,
it is
everything's
that's
good then.
Actually going to be shown.
No, I am on
State's
Rumble.
put on the record what it is. It's a.
Rumble
it
is on,
They,
I
or should say,
believe.
they are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing
Oh, yeah.
argument.
Yeah, thank you for
so-
reminding
Making
me.
a request, the same request. May I be able to put up?
Well, I guess it
exhibits?
depends on what it is.
Can I be
sir.
putting up
So
exhibits?
I'm not going to take up any more time because what I intend to do is, once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular,
Nick
what are
sounds
you
like hell. I don't know
willing to
why.
Tell me what it is. As long as it's an exhibit from this case,
Why would that be?
then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part
They're,
of my filings that you filed.
Filings that you
Filings
filed.
have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and
I
ruling.
was specific, my other filings that
That's
was
not
filed.
specific enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
Are you done? Are you done, Judge? You finished, Your Honor?
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What
Your
filing
Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir. So when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
My statement of
The
particulars.
request to display those to the jury is denied. It's not relevant.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
explain
you are
why
not
that's
going
not
to
relevant?
be
Back when
able
Brooks was
to
rapping
raise
for the
those
hell of
types
it.
issues
Nowadays,
and
he's
present
rapping
a
to stay
closing
relevant.
argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights.
truth
They
in
should
their
know that at
duties?
least.
Mr. Brooks, I'm putting you on notice that if you continue with this,
Mr. Brooks's
insistence
closing
upon
argument is going to
presenting
get cut off.
information that's not properly
The over-under
before
is
the
how long
jury
it
as
takes.
evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles.
They absolutely
No.
do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
It's the truth.
Mr. Brooks, your custodial status is not on trial here.
I will
No,
argue that it
your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing.
is
the
no
jury
peril.
Let him bring
It's
it
my
up.
right, though.
Let me go.
Let her.
Okay.
Yeah. Now you're
It's my
getting to it.
constitutional
There
You're
right.
protecting him. So let him say that he's shackled.
Just
I'm
like under the
shackled.
First
Yes, sir.
Amendment, which I preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks.
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
they're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460.
I'm
which will be
going
read the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform
homie.
them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't.
Okay, we're
No
over
state law
10,000
can
live on
override
Rumble.
Mr.
Any
Brooks,
law-
do you intend
hit
to
that
bring this
Rumble
up when the
Plus
jury
button,
comes out?
y'all.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
I'm not-
they come out. That's why I'm trying to address this before they come out. So
He's
it
got a
doesn't
point
become
here.
an issue once they're in here.
The problem is
But
his
under
point
the
is
First
ultimately
Amendment
stupid.
And under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when
I
this
preserved those
proceedings
rights.
started. I preserved those rights.
You didn't need
for
to
the record.
preserve your rights.
And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that.
We know.
But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument.
Give
In
Andrew some
appropriate
love.
circumstances, the right to
Do I-
present a closing
how am I
argument,
not-
no different than the right to testify.
much love
may
to
be subject
Andrew.
forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout
D.
this
Hirsch says, let's
proceeding
get this party started. You missed the majority of
multifaceted
jury
and
instructions, you
multifold.
lucky fook.
Number one, I do have an obligation.
Bring
and I've
on
done
legal
my
mindset.
best to ensure that this is a
I mean,
fair
he's
trial.
welcome on.
However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as
I think
jury
mindset
nullification,
and
subject matter jurisdiction, the court's oath or lack thereof, if that's what you
mindset
need,
and vices
whether
are
this
also
court
streaming.
is a
No
court of
shade to
common
them.
law, admiralty,
They're fucking awesome.
All of those things relate to your claim
And
as
anybody
being
who
sovereign,
wants
which are
to
frankly
should
baseless.
definitely watch
They're
them.
meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument.
No, I don't.
This court
I don't know if
has the
Sean is.
authority under 906.11.
Oh,
under the
Sean is also
various
streaming.
cases, including Illinois versus Allen.
I should join
including
everyone's
Rock
stream.
versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with
Except
the
I would
right
hear their.
to testify.
I would hear their trial on all of them.
There is a decision. I looked it up earlier. I'll just pull it up and tell
They
you
didn't
the case
steal
site
any
so that
grift.
so that you have it.
I drank enough to
We
be
would
singing
direct your
90s songs
attention
last
to
night. That
Herring
was my
versus
own
New
damn
York, found at
fault.
422 U.S. 853, a 1975 case, although in a footnote, it does stand
Herring
for the
versus New
proposition
York.
that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows. And that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not.
You go to all my
The
homies
arguments
out
must be
there
based
in the
on
chat.
the law.
If you want to
Not
send
as
me a
you
super chat,
interpret the
strongly
law, but as the
consider
law
sending it to
is,
Legal Vices
you
or Legal
must
Mindset
base your
instead.
closing arguments on the facts
My Korean
that have
boys, they need
been
some love.
established during this
Or wait, no,
case, meaning
I'll
the
do it.
evidence, the testimony.
I'll do it.
As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury.
I got to pull them up. I got to pull them up muted. Here we go.
It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses.
Up, Steve?
You may not convey
Hello,
the idea that you have undisclosed
my Pope. I
information.
respond to the summons.
Either party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record.
Isn't that nice of him?
With all due respect, when will I be able to make the record?
You've
I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So,
not,
I'm not allowed to make the
required to give
record
you
at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
Sir.
to make the record at all. As I just let you did, because some of the
Sir,
issues
I
has
have,
been some
you
of the
have
issues
told me
has
what
been
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown
Unlawful law.
one time that is lawful for you to do what you've been doing as
Mr.
far
Boyce,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court.
But
There's
she
not
is by saying that.
point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue.
No. Fix it. Fix it now.
I'm going to inform you the, whoops,
Point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree
go.
with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
Are we
inform
loading?
the
raise
jury.
every issue.
It's happening everywhere. How you doing, Steve?
good. Thank you for the invite. You are my Pope, and I bow to your authority. I just want to let that be clear for the record.
For the record.
For the record.
Oh
No,
my God.
No, I owe you a whole lot, and I really thank you very much. And all other rumblers will be second in my heart.
Point for you to make an
Honor.
offer of proof regarding my prior rulings.
I don't know, this thing might
or
be down.
decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue.
Yeah, it's that's locked down for now. I gotta see. Do we have another stream than Law and Crime that's going? Does anybody know? I'm out here. I'm trying to give money to my man Andrew. Legal Mindset.
Oops.
Oh, I conveniently slept through jury instructions.
I hear that you had quite a night last night. So I was actually over on Legal Vices. I don't know if you know, but we've been covering it for a long time this morning. So I've caught a lot of the intros. Believe me, you didn't miss much. Basically just readings of endless jury instructions while he was in the other room being scolded.
Yeah, I figured. Okay, let me pull up a different trial stream. See, Andrew has a different one up. Oh no, get that off there. Okay, here we go. Oh, TMJ4 news. We'll use them.
Parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
All of
Sir,
them.
I've
You
made my
can hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments, but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was
Bye.
it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this.
sir, and
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right,
but-
I will wait and see.
Your Honor, it's
But I
still,
need to get going.
it's
still
still
law. And I'm
going to,
unconstitutional for
sir.
you to
So
tell me that I
You
don't
need to
have
be
the First
quiet.
Amendment right that I preserve, or the Sixth
Sounds
Mr.
Amendment
good.
Brooks,
right
I'm
that I
going to have
preserve.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held
when
in
the door
contempt.
opens,
Or I'll be
They have
held in
their-
if you
contempt.
insist on making
They have their court
remarks,
stream turned up really loud.
then I will excuse everyone from this
Holy
courtroom
shit.
and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my-
haven't been
Only under the
dishonorable to
unlawful
court.
law.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not
Okay, bye.
to override
You're there.
my constitutional rights
Me to the
just
next
because you feel like
courtroom
you can,
over
and
on
you
this
don't have no lawful law to do
lonely
that.
day.
We
You should
all have
just take him up
constitutional
on
rights.
that.
You cannot-
Okay, bailiff, remove him.
What
Boom.
you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor.
out.
Does Illinois versus Allen say that you can utilize the mute button?
Yes.
It does not.
Literally is
Mr.
a,
Brooks,
a
So you're-
physical
Opens,
mute
I
button
expect
called
you
a
to be
gag.
quiet. You will forfeit
And I
your right
expect
to
for
be
you to
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public
The
servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom.
She is.
Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt.
She walks off the bench.
Hold me in contempt.
I'm gonna turn this
I
part
have, I have
down
constitutional rights that are
because
being
I'm getting some
trampled on,
distortion.
and you're coming up with ways to make a lawful law where
There
it
we
doesn't
go.
say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to
No.
be respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not,
the way
I'm
that
not
you have through
disrupting
the
the
course
proceedings.
of
You just
three
You're
told me
kinda
you don't have to
disrupting the
honor my
proceedings.
constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury.
asking
I'm informed
you
that the jury
To
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you agree
present.
with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you
Always
going
about
to
satisfaction.
Are you going
Follow
to
the
answer
court's
questions as a public
ruling.
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized
The
the
jury
mute button
can
and
go
never
back
said
to the
anything
jury.
She should
about
just
the
say,
mute button.
take it up on appeal.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
Just say it.
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury
How can you
out.
make
How
it?
can
you
You're
utilize
proving her
He
point, homie.
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not
argument.
Your Honor,
You will
can
be
you answer
taken
this
to the
question?
courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
This is
closing
the right
invite
arguments.
me back over. I can
He would be
reclaim my right.
so disruptive
So how
during
can
their
you invite
close.
me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom.
Oh,
and I'll
legal
make
vices,
appropriate
you
findings,
scumbag.
findings when he's in the other
Yeah,
courtroom, when I
and
can
you'll
do so
mute me, which you
without
can't lawfully do.
We're just giving
interruption.
these
You can't lawfully
platforms
mute me.
percentages now.
So now you're trampling over my First Amendment.
Legal Vices comes in as a bro with a big donation. Says, back at you, brother. Love you, man. Enjoy the shit show. You too. You too. Keep killing it over on the YouTubery. Have fun with that. Oh my gosh. So the problem with this proceeding is that
The problem one.
I think it is the overarching problem. She's finally said it out loud. She said the quiet part out loud. It will not be resolved to your satisfaction. And he has no interest in resolving it to a satisfaction. There's no benefit to him to say, okay, Your Honor, I agree. Ever. I mean, there just can't be, because everything is about stalling, delaying, and trying to force an error that's some unnecessary error. And so she should have just removed him from the courtroom for the state, because he is going to be wildly disruptive. They're not saying the truth, Your Honor. They're not telling the jury the truth, Your Honor. That'd be the whole time. Objection, hearsay, objection, hearsay. It's like hearsay objections are not appropriate during closing arguments, Mr. Brooks. Well, why not?
He would be objecting on every sentence. So I'm really happy that he's out for the state's closing. Then the next thing, he's going to come in and he's going to keep testing and testing and testing on his closing. She's going to overrule him. Now, how far will she let him go until she shuts him down? Now she's done a time limit of an hour each.
22 minutes.
So
I'm going to give it 22 minutes before it's shut down. That's my over under is 22 minutes.
And you know what I've saved, because I've been over on Legal Vices all morning.
Yeah.
I've saved just for you my honorable Pope.
Oh no. Oh, what do you got there? Let's see. Hold on. Let me make your let me make you a little bigger here. Oh, some courage and conviction whiskey. Cool.
Is this good?
Never had it.
Never had it.
Seen it.
And then I have, but as option 2, and you've got to come up with the right thing that will allow me to enter into this sin, because you are the Pope and I need to know what forgiveness I get. Is this one here?
What is this? Hold on.
Copper bottom, single barrel rum.
Okay.
And this is from Daytona Beach, Florida.
Okay.
Made in, it's not just bottled, created. And this is a real special thing. And see, it hasn't even been opened yet. The other one has been drained. So I'm just giving you the option. If you wish to utilize this in any way, I am at your humble service.
Enter that sin. I didn't know her name was Sin, frankly. Dang. Shoot. I don't know. I had a lot to drink last night.
I know you did. I've heard this, and I've heard there was some, it was all the talk of the town. Like, where's Nick? I think he's on the floor.
Pretty close.
but he did say, Legal Vices did say that the last half hour of your show the other night was like the best half hour that you've ever done. So maybe you're one of those people that gets better with alcohol consumption. I don't know.
Some would disagree.
Maybe it was sardonic. Maybe it was not right.
No, I know exactly which half hour he's talking about.
Okay.
And it was lit.
Okay.
It was lit up. That's for sure. Last night was a little more mellow. It was a lot of fun. I was on Twitch where I watch movies during the month of October. I watch whatchamacallit, horror movies. And we watched the remake of Night of the Demons. Did you ever see 1988 Night of the Demons? Okay. Well, it was a schlocky, silly horror movie. And then the remake stars Edward Furlong. If you remember Edward Furlong, the kid from Terminator 2.
Oh, yeah. I remember him.
Yeah.
He did something after Terminator 2. Well,
he did a couple things. He did American History X, which he was actually really good in. But then, yeah, he did this movie, which is like, okay, Ed. That was fun movie. And then we followed that up with My Bloody Valentine, the remake of My Bloody Valentine from like 2009, I think it was. And gosh, that movie was fine, but it wasn't like good, you know.
Okay.
But
Yeah,
then
none of
after
those-
that.
Yeah, go
After
ahead.
that, I dropped into the chat got me on 90s music from my like last, my years of high school. And I had drank enough to be singing all night. So that was dumb. Very, very,
Oh yeah,
very,
karaoke. That's what it was mentioned. It was karaoke.
very breaded.
Yeah.
High gluten content last night, but I didn't care. It didn't matter. Come on. Where's our volume? Put him on.
I don't know. This is so I don't know. I don't quite know how to take this. This isn't really law, where I'm in here, I'm supposed to be the legal commentator, but this is so unusual, this case. I guess that's what makes it entertaining. That it's kind of like watching a car wreck. This is such a car wreck of a trial. Although the state's putting it on, they're going through methodically, they're getting it to the jury, but watching the judge and this defendant go back like an old married couple who have had a poisonous marriage counseling going wrong, I don't know. It's a strange thing to behold.
Yeah. Let's see. Oh my gosh, I have a lot of emails.
You look a little stunned. I must say your normal self is
I'm still waking up. We're going to get there. By the way, guys, I don't have the stream muted. There's just no sound right now. In case anyone's curious.
She's made her ruling. She needs to stick with it. If she invites him back for the state's closing, that will be a huge mistake. He's already forfeited his right to be present during the state's opening. That will allow the state's opening to go. And then he can act up like he wants, create the record that he's being disruptive and not obeying court orders and forfeiting his right to closing, which he could do. But they need to let the state let the state make their closing to the argument unfettered. If she comes back and says, now I'm giving you one more chance in which I'll ask you 3 more questions, that's going to be a big mistake here.
Brad Pitt. So let's say he actually had a legitimate objection. I know Latches says if you sleep on your rights, you're fucked. Is there a similar doctrine for those who literally shit on their rights, no rational cause? He can still object from the other courtroom.
Yes, that's true.
Object.
But that's what I'm saying. The state also needs to be on its game because there's no reason for them to do anything untoward here.
He's gonna You have a right to object to anything that is objectionable. However, if you sit and object constantly to nonsense, a judge can kind of admonish you quite a bit. The problem is, but
let's talk about appeals, because for appellate purposes, if the state does not make any improper closing arguments, then there's no appellate issue.
Right, that's true.
So, for example, if the state stays clean, his inability to object would not have affected the outcome of the trial, so it would be harmless. So his inability to object to nothing is not an appealable issue. So it's only if the state goes overboard and says something that would dramatically affect the outcome of the trial, and then he is unable to object, would it ever become an issue. And the state better be smart. But I think this is why I'm very interested in how the state conducts their closing, because they've been doing it right. They've been the star of the trial, is the state attorney's office. Now, whether they can stick with it, it's hard.
Please. We are back on the record.
Yeah, that's the trick.
Appearances are as they were before.
There has to be an error for you to have missed your objection too.
The court did that because we came out on the record at 2:00 following the lunch break. Mr. Brooks,
do you love anything in the world as much as this judge loves hearing her own voice?
And during that almost 35 minutes or so, He was insistent on raising a variety of legal issues with which this
That's
court
sound.
has either previously addressed or which are meritless and do not
Evil Bun Bun says,
warrant any
Jesus, giving you
further
money
response.
is hard.
He is insistent
easy.
on making
do
a
it whenever
record
you
and an
want.
offer of proof. This would not be the appropriate procedural mechanism, meaning
Man,
an
the
offer
audio
of
on
proof
here
at this time. We are
sucks.
not in the midst of a trial where the court's made an evidentiary
You can try
ruling
switching
that
before.
require
Yeah,
the
give me a second.
preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions,
Law and Crime's
to get to
back.
the point where the parties make their
I'm going to pull theirs up.
closing arguments and ultimately to put this case in the jury's
Better.
hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times
Big ups to
he
Law and
may
Crime. They have
wait for me to,
107,000
make my
people
ruling.
watching.
He continues
It's really
to
too bad.
not respect the fact that a ruling has been made, and he wants to argue.
11
and
Bravo Crunchy
re-argue
says,
and
Rackets, your grift is weak
re-argue
and you should feel
points
weak.
that
Do the
this
stuff and
court
things
has
with the things and
already
stuff.
gone
Do it,
over.
meow.
And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of
Fair and
resistance
balanced. You knew what
and
this
repeated
was.
statements by
You knew what
Mr.
this
Brooks
was.
that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute, but those rights do not come in a vacuum when we are in a court proceeding and a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent.
She's talking way too much. This is all.
Probably about
she does not
35
need to be
minutes.
doing this.
I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope
rip
that he follows
Darrell
some of those
Brooks.
same things
It wasn't
here
overly
when he does
lengthy. The
his
words you
closing
never want to
argument,
hear
but
from a
he
woman.
has been removed from
Oh.
this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the court.
How much of this is because the cameras are on her, do you think?
Conduct should not
I
and
have
cannot
no
be
idea.
tolerated.
I don't know what she's.
And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case.
By the way, guys,
No one formula for
Daily
maintaining
Shill,
the
if you're not on the
appropriate
Rekieta
courtroom
Law
atmosphere will be best in
Locals
all
chat, you are
situations.
missing.
They
You are
noted
missing
3
a real
constitutionally
experience.
permissible
You're
ways
missing
to
something
handle
beautiful.
such a
The
stubbornly
exclusive
defiant
Locals
defendant.
live chat.
But they also indicated that no one formula for maintaining the appropriate court atmosphere will be best in all situations.
It can only be
Noted this
spoken about
before.
in
This is a
legend.
case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear
Maybe
from
Kate
the other
says you're
courtroom
missing
by
me.
way of audio and visual means.
We have real
We
pretend
can
women
see
in
him.
the
He can see
locals
us. I
live chat.
confirmed
It's
prior
amazing.
to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom. There's 4 cameras in his courtroom. However, it is
I
set to
love this
one
picture
camera since
so
he's
much.
the only individual there. Other than the bailiffs, but I'm talking about as a party to the litigation.
That's
So
an amazing, amazing
courtroom,
picture.
the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. And she is still present with it, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make
Red Blur
an adequate
8351
record
says, Nick,
if I
can't
am
seem to get
in
a
a
hold of your gay
constant,
ass. Vic is
back
coming
and
to
forth
Krypton
with him
Comics
and
in
trying to
Omaha,
talk
Nebraska
over
on
him.
November
And so
5th.
I, yes, made
Thank
the
you for keeping me
decision
entertained
to
at
utilize
work.
the
It
mute
helps pass the
function
time.
on
Keep
the
up the great work.
incoming audio. I know he
I'll
disagrees
mention
with
it on
my
the night
ability
stream tonight
to do
too.
that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the
Your Honor says she's making a
couple
great
of final
argument to
jury
repeal the
instructions I
19th
need
Amendment.
to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking their head right down. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability.
They just ruined their
so
mics.
that is displayed not only here, but in the neighboring courtroom. if you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the
Did you
bailiff
see him
over
make
there
the-
not
The fort out of
being
boxes
properly
yesterday.
Yes, I did.
if it's not viewable, that we can stop.
Fort grounds.
Okay. Thank you. If you would like, before the jury comes out, we could do a test.
These memers are awesome. Are there's the best part. I mean, keep doing that. It like really is great.
The locals chat, man. The stuff that they keep coming up with and posting is killing me.
Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable? They can see it. All right, and it should be similarly to what we see. So the monitors will.
Looks like we'll start closing
display,
arguments sometime tomorrow,
the camera
guys.
that Mr.
By the
Brooks
time this
is
judge is
appearing,
finished explaining
that is on
everything
Mr.
that she's
Brooks
ever
on the
thought in her
left-hand
life.
side of the TV, and then the 4 cameras for
Just
this
to
courtroom
repeat
are on the right-hand side, but it's
for the
probably
record.
maybe a quarter to a third of the screen, and then the remainder of the screen.
When
is
do I
the
get to make
PowerPoint.
my offer, Your Honor, for the
The-
record?
Monitors in the courtroom that Mr. Brooks is in are no different than what they are here. You would have one at the table. There would also be the very, very large
That was great.
monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if you were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen
business.
from a camera, but it's really no different than what I'm looking at the moment.
Who's that?
That's me
So-
and Darrell Brooks.
I
Oh, that's
appreciate
Hanging
from
out.
his rap
you
video,
asking
right?
that I make a
Yeah.
record of that. I would further make a record that there
I
are headphones on the table where
greatly
Mr. Brooks
object
is currently
this.
standing. He is not
I
put them
object
on,
to this.
but they are available should he want them.
Chat, that is not acceptable.
All right, then are you turning off the, all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to.
His mean mug
make
stare was
that
something to
viewable
behold,
in both
though.
courtrooms.
That was
Very good,
great.
thank you.
He's got every manipulator, abuser trick in the book, doesn't he?
Yeah. She should not have said, "I'm scared," though.
That was
That-
stupid. And then
She's-
and then she also says, "Now, Mr. Brooks, I'm going to bring you out here, and when I do, I'm going to ask you 3 more times, and then I might take action." Remember when she said, like, "I'm going to come bring." You don't ask 3 times. You come and
Yeah.
say, "I'm going to ask you once." This, okay, hearing no answer, boom, you're out. But this like constant, like, okay, I'm going to ask you again if I explain it to me. I mean, it's ridiculous. He's playing a strategy right out of the Sovereign Citizen playbook, and she's playing into it by mouthing and mouthing and mouthing. It's irrelevant. She's not when he says, "I want to be moved in the other
All rise
room."
for the jury, please.
Okay, bye. Bailiff, take him out. Accept his offer.
Yep.
Because that's what it'll read in the transcript. It'll say, "I want to be taken out." Okay, bailiff, remove him to the other courtroom. He agreed. It's consensual.
Oh my gosh, what is happening here?
This is just a crazy case. I've been defending her for the last while, and I'm sure she may be a very good judge.
This is not acceptable. This is not acceptable, chat. I gotta avoid Darrell.
Thank you, everyone. Please be seated.
Oh my gosh.
Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most recent.
What the business?
I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
Thank you. And Madam Clerk, if you would please turn on the PowerPoint.
Yes. Oh, hold on one second.
I'm glad they have a PowerPoint.
Mr. Brooks, do you have an objection?
Oh, come on.
I thought I was supposed to be unmuted.
You are now.
They haven't started yet, buddy,
Right.
so it doesn't matter if you're muted.
Attorney Opper, you may
Frankly,
start.
it doesn't matter anyway.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you.
Ooh.
Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff.
I'm a third-party intervener. I do not
It's
consent
really
to be calling that name.
simple. And it's consistent with any other criminal case you've ever heard about at any other time.
They should
in
have
any
a
other jurisdiction. It runs the same.
Brooks aneurysm
No
cam
matter
for
what
when he's
state-
trying to object
or
constantly
federal.
throughout this.
I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Grounds.
Mischaracterization of who I am and the way it was said.
There it
I
is.
feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
This is going to be a persistent
You
issue.
must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Whoa.
What is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills.
They're
68 through
numbered.
73,
How did you get that wrong?
74 and 75 are bail jumping, and 76 is battery. I apologize for that mistake.
Boy, how on top of it is Brooks, though, to catch that error?
Counts 1 through 67.
Yeah.
You know, he's competent.
Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping.
Oh, they dropped the
He's
charge.
out on
That's
bail
why.
For 2 files in Milwaukee County.
Thanks for
facing
reminding me,
felony
chat.
charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've
Homicide.
seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got.
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people.
There's no
And
proof
he
of
did
that.
so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the
If you
deliberation
choose.
room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so every everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we
Fatality.
presented this case to you in much the same fashion that is presented here on
I heard a
Exhibit
magic word.
15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see.
Left-handed Luck says, I
Pretty
can't wait to hear his
easily
statement prior to sentencing.
who
Going to
was
be such a good
located
time.
where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies. State's Exhibit 54. The formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't.
So in the locals chat, it says, Rekieta Law, you're the lawyer. What are we
Now,
missing? Did we just
one of
watch
the
too
big
many
things in this
episodes of The
case has
Practice and
always
expect
been,
all lawyers to be
why did this
extemporaneously
happen?
eloquent?
What was
Most
he
are not.
thinking? Why did he do this?
It's not about the eloquence.
Again,
It's
those are
about
things I don't
delivering a clear
necessarily have
narrative,
to prove
clear
to you.
facts, and clear law.
His intent, I do have to prove, and I submit without any doubt,
This is not
overwhelming
a
evidence.
thrilling closing,
Intentional act by
but
Darrell
Doesn't
she
need
needs,
Brooks,
to be.
she
and
just
an
needs to get it to the jury.
utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
But I couldn't stop.
Attorney Offer, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
Intent is a jury question.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars.
Squad.
How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around,
Drive
see
through a
the
barricade.
floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers.
Woman just
The
saying he
barricades
drove over a barricade.
Help us prove it was intentional.
Okay,
The
there we
police
go.
presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Alpha. Your objection, sir?
Speculation as to what
It's
the
argument.
defendant said he saw. It
Sir,
was never.
Your objection's
Did
noted.
you
It's
see that-
overruled. This is closing
That
arguments.
subtitle,
not the evidentiary
it said
case.
what that delicious idiot said.
Go
So
ahead.
how can, so how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Alpha.
Honking
See,
the horn.
The problem is he doesn't.
Quite
He's not going to
interesting
realize,
that Mr. Brooks asked
probably
so many
intentionally,
witnesses
that this
if
is
they heard
closing
the horn
argument.
Right.
These are. He's going to make
Some of them
evidentiary
said they
objections
did
during it,
at the
and
beginning of the parade.
evidence is over.
I heard a horn honk. Most of them.
This is to explain to
did-
the jury how to integrate the evidence with the law. That's what the
the
intent
horn
here is.
honking cuts both ways, folks.
So she has to prove
He's
intent,
honking his
mens rea.
horn. That means he can
She's
see
pointing to
something.
why it's mens rea. This is almost
That
unnecessary,
means he
but she's
knows there's
doing
an
it.
object in the road.
She's got to do it. There she is, right?
she wants to
You
nail
can
down the
rely on
intent.
your common
I mean, that's what she wants to do.
experience
That's the
in your
key.
affairs
Yeah,
of
but
everyday life.
I don't know. Get it to the jury as quick as possible.
If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We
You
heard
can actually buy
testimony
silhouette
from
shooting
four
targets of
different
Darrell
police
Brooks.
officers
Really?
standing
Yeah.
in 4 different spots.
I don't know. I don't know if anybody is loving on him right now.
4 different efforts to stop him. Intentional. Sergeant Warner's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street. Gets
This
in
is nice
area
and
of
good
East Avenue.
preparation when she's
to the
calling
south
back to
and Buckley
specific
Street to the north.
testimony of the different
This is where
witnesses,
he
but putting it in
encounters
chronological
Officer
order.
Schneider and Officer
That's good.
Buttrin.
That's good
They
stuff.
each
Yeah,
take a step
That demonstrative aid, which is
Stop him.
great,
and he
is
keeps
going to be the
going.
guidepost for that
police
she's following. So that's what she's doing, and that's the right move. She just needs to get to it, get in,
That's
get
when
out.
the opportunity to just stop.
Is
Anywhere
she the
along
elected
the-
official or is she
one
a
of the officers
hired prosecutor?
tried to do it. I think
She
it was
is the
Officer
elected
Schneider.
one.
Okay, that makes
This was
sense.
an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't phase him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
That was a good argument there. She's getting stronger here.
Characterization of the evidence.
Noted, overruled.
His conduct when he left
He's wearing
the parade
his
route, we'll get
headphone on
into
his
this.
cheek. It's not the right
Flight,
place.
his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I didn't
stopped.
even state the objection.
There wasn't a valid
Closing
objection.
argument. You may continue.
I'm going to play.
See, this will be the
slide,
judge's
which is a
power move
snippet from
against him
safety
here.
exhibit number 53.
Because like Steve said, if there is no actual
play
valid
the sound.
objection, she doesn't have to recognize it. And particularly during closing. Well, the actual music just overrode the song in my head, so that was nice.
Yeah, the audio is painful. Could you imagine watching a video of this thing?
I can, Steve, because I've watched videos of so much worse.
Really? Worse than this? This is pretty
Oh,
bad. This
man.
is on the high end of the scale of bad.
It's
That was just a
bad,
snippet
but
that I
yeah,
selected because
I've
I
been on the
thought it
internet
really
too long.
captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opera.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we gonna mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted, it's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going.
Yeah, see, this is his problem.
Over by the steaming cup.
Even if you can
testify
somehow get past the intent of the first person he hits,
that were standing there
it's
outside
every
the
other
steaming cup,
person after that.
they were struck by the
This is
red
a really great demonstrative aid, and this is the key to their whole strategy
going.
prosecution. And
Close to the
she's just
brain.
hammered it home. It doesn't need to be hammered home. It could be done summarily, but she's a
Most of
politician. She's going to play it for the hilt. This is
injuring
her
them,
moment in the sun.
hurting them, keeps
No
going.
harm. She's making proper arguments.
Gets down here
Yep.
to the end and goes through the Catholic community.
And also,
The
that
witness,
elected part is probably why she's
remember
doing
Holly
closing
Birch
arguments.
Oh,
testified
absolutely it
that,
is. She
mobile
has the
taxi
discretion to hand it off, but she
said
wants
she's
this as her
standing down
moment.
here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd.
William F. Buckley
And there's
Street.
Officer Schneider in her yellow
Buckley Street.
fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, first thing you're going to see, if you direct your attention to the left side of the screen, is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play.
Yeah, I don't think they're going to show any of these videos. They had said that at the beginning, that they weren't going to show them on TV. Which I have mixed feelings on. Nothing relevant to the law. The Dragon's Treasure says, looks like my shilling is going to end soon. Use code DINDONOTHIN at thedragonstreasure.com. If you think you don't like tea, you're wrong. Message us from the website and talk to us. Plus, receive nudes. There you go.
Oh my God. Oh my fucking God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt.
Yeah, the videos are out there, by the way.
I
They're
can
just
tell the jury what they supposed to think.
Proper argument. Your objection's noted. It's overruled. You may
It's, I would
continue.
argue that it's,
Attorney Hopper.
I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to mute you if you don't follow the rules.
I
Exhibit
move for a
one.
mistrial.
Exhibit 152.
denied.
Denied.
Clearly.
That's proper argument.
intentional.
Intent is an element the state must prove. So she's arguing and showing how the evidence shows that, how you can deduce intent from the
Clearly
scene.
intentional conduct. States Exhibit 93.
Yeah, there's actually
asked the
you
court
can
to
even
take
say something
time
completely
to
wrong
have you go
about
look
what
at
the
this
fact,
car
like as
in
long as you
person.
accurately
because
represent
it's
the facts and try and tie them to
remarkably
law, you
amazing
can be wrong.
that
Say
this damage was caused
his
by
buying a
human beings.
Coke is evidence of intent. The jury
That's
doesn't have to
intent.
believe you. That's not improper. So long as you don't misstate the law.
And you also can misstate the facts.
States
But
Exhibit
if your
154.
conclusion of the facts
Yeah,
is a
no
misstatement, it's a wrong conclusion. You could be wrong, but you can't mistake the facts for the law. But she's
Right.
arguing, she's connecting them. This is proper argument.
Remember what Dr. Vidritsky said about the shoes?
The jet ski said.
Feet, the scuff marks on the toes and the ankles. Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent.
It's not funny today, but it is funny all the other times on the internet when I see
The
someone's
flight,
shoot like
hiding,
get blown out of their shoes
changing his appearance.
off a skateboard or
He had
something.
to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance.
This is an issue called flight is evidence of guilt. And there's a jury instruction on that, actually. The fact that he's fleeing from the scene shows his culpable mental state.
Intent. What's he running from? What's he running from if he's
Why you running?
just a lost guy with no ride back to Milwaukee? What's he running from
His past,
as there's
his bad
cops,
decisions,
sirens wailing in the background?
his obligations.
Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Thank you.
What was the sandwich evidence of?
I'm not going to go through this whole thing, folks.
That his appetite was
Suffice it to
sated
say,
and he
after
didn't need it,
Officer
so he
Skolton
shoved it in his
tried to
pocket.
stop the
His
threat at
appetite
that
for blood
intersection at the top,
and
Johnson
murder.
Avenue. And he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some
What
of
was
them
funny there? I
tried to
didn't get
help,
that.
some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled him from keep running, kept him in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car.
Boy, that's good.
Plate.
Objection, Your Honor. It's actually the other guy's car.
There's the key to the Ford that was found in Darrell Brooks' pocket.
Excellent.
There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade.
Oh,
That
he
is
was
also
in the
Darrell Brooks
parade.
driving in the parade. And so is that.
This is tight. This is really
kept
good.
asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., dated 2/21/1982.
It's in all caps, not
on
him.
his identification card issued
Oh,
by
no.
the state of
This
Wisconsin.
is not a driver's license. That man couldn't be driving.
In all
You
capital
must have
letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well,
That actually is called disparaging the defense.
That was me. If I would have said
Mr.
something
Brooks,
like
your
that, it would've been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir.
The real problem is that the
So I
state
can-
actually
I can rebuttal.
doctored his driver's license
Go ahead.
or
Attorney
his
Alford. Thank you.
identification card. This is the real
I'm
one.
going to conclude my
They're
comments
covering
with
up.
this, folks.
They're covering up for the true
I'm
identity
going to show you the video,
of the perpetrator.
a stitched together video of all the carnage caused by Darrell Brooks. And I apologize.
Stitched together.
Stitched
This is
together.
important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine?
That's an objection.
He drove right through them without a care in
That's
the
a
world.
That's a golden rule violation.
The grannies dancing their way down the street. Perfect step. Every one of them.
The one time he doesn't
Catholic
object.
community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying,
She's bringing it home.
held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade,
Objection. I did it with courage.
killing and injuring so many people. I'm going to stop talking and play this video. But please, I ask you to add up the evidence.
When the video plays, since we're not
Use
going to be able
the
to
map.
watch it or anything, can
That's
you
right,
explain the
15.
golden rule
We
violation
can
you're
check
talking
all
about?
the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please.
Yeah, a golden rule violation is when you say, how would you feel if you were at the end of this gun? Okay,
I see what
so
you're saying. Yeah.
it's an appeal to emotion to place you're asking the jury to put themselves in the shoes of the person who's the victim. So that's an improper appeal to emotion. It's called a golden rule violation. So anything that you could characterize as how would you feel if you were being walked, dancing in the road and plowed down by a car? You're asking the jury to put themselves in the shoes of the victim. That's an improper argument. But he didn't object to that, so it's waived. Not that it, but it would also be harmless in the context of what she's done here. She's done a very good job, I'd say, overall. The other argument, she disparaged the defense, which it wildly needed disparaging. But you can't say, like, what he did make that objection, but again, it's harmless. She passed it over. She said, and she clarified it. She said all of his actions. Then she said, by the questioning that he did of the witnesses, right? Mm-hmm. Theoretically, that's a disparaging defense, but this is just nitpicky brain lawyer. I'm trained to object at trial level things like this. So that's when I'm listening to this. Those are places that I would object. That doesn't mean that they're appellate. That doesn't mean they're harmful. Doesn't mean anything. I'm just pointing out for the community that there is some law here to be learned. But overall, she started slow, but I think she rocked it there at the end. What do you think?
No, she brought it back really well. It was, yeah. And not everybody's a great immediate speaker. Some people they need to get warmed up. I actually feel that a lot when I do live appearances. It's like I could get on stream and talk just fine, but in front of like 10,000 people, a live appearance in front of like 100. And I'm like, okay, got to get worked up for this a little bit. But once you get going, you kind of settle into it. And I mean, this is for her, this is her campaign speech. Right. I mean, this is her career. She will make it on Darrell Brooks, and deservedly so. Putting away a monster like this is where I want DAs to make their career.
But that's just the luck of the draw on who commits the crime. What I would say, and I don't know, and I'd like to talk to the public defender's office, because does this level of prosecution reach down to all of their trials? Because it seems to me they're playing very fair, they're being very clean, and it's a high stakes game. The key to a good prosecutor is does that fall down into the misdemeanor level and the felony level, and is that the way they conduct their office? If it is, thumbs up to this prosecutor. If they're just doing that because this is a high stakes trial and they cheat on the lower level cases, then bad on her. But I don't have any knowledge regarding that. But I will say in this trial, I think the prosecution to date has done a great job and is the star of the trial. What are they showing? They're showing this is that stitched together video.
Yeah. Yeah. It's objection stitched together. So you can stitch together the video that has been introduced as evidence in I don't know what to call it, but a stitched together video, so long as all of the video that's in there was introduced as evidence by the court and accepted, and that it's not in some way deceptively stitched together to create a false representation of the facts. So if they put it in chronological order or explain the order of the videos for whatever reason, that's fine.
Here's the Brooks closing argument. They're going to take a short break. They're going to inquire of him. This is going to be the drama of the day. The poisonous, toxic relationship that is the judge and Darrell Brooks. So she's going to get into this. Do you want to come back? Or are you going to obey the rules? You can't go into this. And she's going to, I'm going to ask you for a third time. Okay, for the record, he didn't answer me. See, his failure to answer is the record. She doesn't need to make a factual finding that her opinion of his thing, her opinion doesn't really matter from the appellate standpoint. The fact is she asks him a direct question. He doesn't answer. He obfuscates, right? That is the record. She doesn't need me to make some factual finding and talk all about what her feelings are. That's a problem. And she does that over and over again. And she could talk. I mean, not that no appellate court is going to touch that, but really this is a bad habit of this judge to talk. And well, as an appellate lawyer, I love it when judges talk. I mean, talk yourself right into appeal. On cases in which we've got really injustice in, I like it when the judges talk because they lay out all their improper thoughts on the record. and then I've got that as fodder for my appeal. That's not in this case. Again, I'm trying to draw larger lessons.
Oh my goodness. So overall, decent closing argument.
Started out slow, too much thanking the jury and all that stuff in the
I don't
beginning.
like when they do that much.
And we
personally.
represent the people of Wisconsin and all. They bought into his little garbage argument. Keep your eye on the ball. Say, she should have opened with something really strong and dramatic, which is the theme. She's got to come in, and this is for most cases, not this case, but you come in with something like, this case is about the murder of 6 people who are run down by a vehicle on a Christmas parade in Waukesha, and the 60 people that were injured by Darrell Brooks in his vehicle, mowed down in the cold of night on what should have been a happy day. I'm going to show you, then go through the facts and bring that out. That should be her opening theme. It should hit hard. This coming in like talking about, well, he's identity, that's playing into his game. They're responding to all this because they've been sitting over there not being able to respond, and she just can't help it. I recognize why, but that's not the way you lead in a strong closing. But once she got out of the way and she got back into her game, I think it was much better, and it was clean pretty much for the most part. I would have had 2 objections. Other than that, good job, prosecutor.
Let's see. There's the interesting thing about opening and closing arguments is there's so many ways to go with it. I mean, she could have gone really dramatic, right? Like the dramatic opening that's completely unnecessary in this case, but in other cases you might want to try would be to just start by reading the names of the victims. Like just cold open, like I can't remember all the people's names, but just name 1, name 2. The first 6, hit those.
But she did do later on. She went through and she talked about all the people, and I think that's important for the community to hear the names of the people that were killed, and not just Darrell Brooks. Instead, it's like, what about the grannies and the Catholic group and and she named all those people, and she is serving for the voice of the community and getting their names remembered and out there. So I liked that, but she didn't get to it till later. And I'm a big fan of drama. I love drama in court, but it's got to be done correctly and precisely and on the issues that are before the court. Oh, I want to bring up one other thing that she did that was really good. She put up a slide that said the state does not need to prove motive, only intent. And that is a brilliant slide that I thought was really important. And it's an important thing for people to understand.
Yes.
Most of the cases, I said, I do a lot of first-degree murder and murder charges. 9 times out of 10, even after all the trials, I've read everything in the case and everything in the trial, I couldn't tell you the motive. It's incredible. It's like, why is this being done? Right? It's so crazy. But the thing is it doesn't matter. What matters is the intent that was in his head. Did he intend to kill? And that's why that graphic design, and he hit and he kept going, and he hit and he kept going. All that's great because that goes to motive. I mean, goes to intent, not motive.
The motive thing comes from TV, right? The police are always trying to find a motive in the law shows and the cop shows. That's different. That's different than what you have to prove in court. The reason they're trying to find a motive is to try and find which they'll never have to prove, and so they don't need actual evidence of. They're just trying to justify why they're looking into this particular person, why the investigation should go farther. Does the crime make some sort of sense? Can we stitch these things together to help us get through our investigation of gathering evidence? But motive isn't a legal standard for proof. Now, it may be, if you have evidence, helpful to the jury to show they're motivated to do something. There's an insurance contract that would benefit them. Like, why would this wife kill her husband, for example? Like, why would that happen? This is so far out of our normal understanding of a particular relationship. Let me tell you, though, what thing is there and why that would change something. So those can be helpful for the jury in reconciling facts, but they're not elements of the crime themselves.
Here's another one. I don't know if you want me to keep going, but it's your show. But here's the intent informed in an instant. This was an interesting slide. Intent formed in an instant. I will tell you that there's a problem with this bit of law. What it does is it erases the difference between heat of passion, second-degree murder, and first-degree murder. Now, it may well be that that is the law in Wisconsin, but as a general matter, intent formed in an instant is a problem because you can't distinguish between heat of passion killings and first-degree murder. Prosecutors love to say that. He pulled the trigger. He pointed the gun and pulled the trigger, and all he had to take was enough to pull the trigger, right? But then when could it ever be a heat of passion killing? So I don't like that bit of law as a general matter because it abolishes that distinction. In fact, I'm in my law class, I'm doing the homicide module coming up tomorrow night, and we're going into that very issue. However, that is probably that may be the correct statement of law. It's in the jury instructions. So I'm just pointing out a problem generally.
Yeah, and so the distinction you're talking about, a lot of people misunderstand what first-degree murder is. Premeditation. People think that premeditation means that you took like some elaborate plan. You cooked up a scheme to kill someone. But I can't remember the Supreme Court case, but basically the court says premeditation can happen within an instant. It's the moment someone decides that the other person should die. And that's the premeditation that's necessary. They've decided prior to their act that the other person needs to die from their act. So you can show premeditation by someone pointing a gun at someone's head and pulling a trigger. Is kind of the concept behind that. But yeah, there are issues with that because, like you said, heat of passion. If you're kind of overtaken by raw emotion, you may want the person to die, but that's not the same as, I guess, the intent to kill in a different context. So there's
here's
a motivator.
Here's the hard law on that.
Okay.
Is the traditional view under first-degree murder is that there's no substantial need to time for a lapse between formation of the intent to kill and the killing. So if sufficient time it's from Commonwealth v. Drum, which is 58 PA 9, 1868. That's the traditional view. All right. The modern view is under State v. Guthrie, which is 461 Southern 2nd 163 West Virginia 1995, and that if, like, for example, the time it takes to draw a knife and stab is not sufficient to form premeditation under the modern view. So there has to be sufficient time to form premeditation. Now, this is sort of one of those jurisdictional questions of whether they conform to the traditional view or the modern view. But I tend to like the modern view because everything becomes first-degree murder, and it requires deliberation and premeditation. There's a similar concept in death penalty law, which we don't need to get into, but it involves cold, dispassionate killing as opposed to one that's done in the heat of passion, and how much time needs to elapse before that is an aggravator, cold and deliberative killing. And that's for a first-degree murder aggravation charge. I had that very case in my death penalty case appeal that I did, that when the person was in the heat and he's angry and he shoots out of anger, that is not cold and deliberative. So
people are asking about this, and I'll address it. A lot of people have asked, but Matt P7705 asked my thoughts on this Reddit post alleging to be a juror from the Darrell Brooks case. Almost guarantee that anything alleging to be a juror during the pendency of the trial is fake and gay.
What's the allegation?
No, it's I'm a juror in the Darrell Brooks trial. Here are my thoughts on the trial, posted on Reddit.
No, that's not gonna. Come on, the internet. You're gonna believe. Oh, I believe everything that's on the internet.
Yeah, that juror would be risking everything on that. Like the idea that they couldn't wait to do this because they could. Tomorrow, when he's convicted, they can tell their story.
It's probably Darrell Brooks back there on his illegal cell phone on Reddit. I'm a Darrell Brooks juror. Here's what I think.
Yeah, the reason people post those is because it gets them a ton of updates or whatever on Reddit. So,
well, even you say like the guy that's always the mass shooting comedian.
Oh yeah, Sam Hyde.
Right. Yeah.
Yeah. But other people did that to Sam Hyde. They just memed him into every mass shooting. But The mods think they've given enough proof. Oh, well, if it's a Reddit mod, I automatically disregard their opinion personally.
Who?
Oh, the mods on Reddit think that the person's
I'm
given
sorry.
enough.
I'm such a clueless internet guy. I'm
Yeah.
just here. I'm just a sheep in the flock right here. So
Here, well, we can take a peek at it real quick while we wait for the thing. I won't disregard it out of hand. Let's take a look. I'm a member of the jury on this case. Here are my thoughts on the trial on this subreddit. So to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about this trial or really have any connection with the internet, but nobody actually follows sequestering rules anyway.
yeah, this is garbage. That's immediately that's garbage. No, I'm sorry.
Hence, I am obviously posting anonymously. I accidentally wandered into here a few days ago from the r/subreddit drama thread on my main Reddit account. Here's my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks, and he did do it. However, I've had throughout this trial doubts about various aspects
Come on,
of the
are you
case.
serious?
The judge is clearly biased against Mr. Brooks. I got that feeling from when we were in the room and my eyes have been opened to how she acted towards him when the jury was out of the room. Clearly, she is not an impartial judge and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. This is so fake.
What you need to do is you need to get them to mention the Pope in here. You need to say, Nick Rekieta says,
Yeah.
and I follow everything. Then you get some promotional tools in the fake gifting.
Mr. Brooks has clearly not been given the chance to plead his case in court. He has been silenced and mocked at almost every turn. While he may be a bit loud or crass at times, I still believe his side deserves to be heard. Yeah, there's no way that this was written by a juror. I'm telling you. Okay. So what evidence do the mods think that this person provided? The user has submitted proof that he is a juror on the case. For reasons of anonymity and the integrity of this trial, we will not disclose details on this process, but we are very confident to the authenticity of the user's claims. Okay, yeah, I don't buy it for a second. That's from the mod Black Justice Forever.
Yeah.
Guys, I mean, come on.
And I love how it's like point by point, all of the things that Brooks would love him to say, right?
Yeah,
What was this one down here? Number 3. Read number 3.
I do have significant doubts about subject matter jurisdiction.
Yeah,
I
come
didn't
on.
understand it when discussed in court because the defendant was repeatedly silenced, but I do understand now thanks to this sub, and I agree that subject matter jurisdiction is a great concern here.
No, it's not.
This subreddit has made me aware of jury nullification, and I'm very grateful for that. Yeah, this will play out really obviously. If there's a mistrial in Brooks, then maybe there's credibility to this. There won't be. Look, r/justice for Darrell. That whoever posted this, that's quality trolling, right
That
there.
is you got to admit that they're making their points, right?
Yeah.
Well, we could go in. I've got a whole case. There's a really good case in talking about jury nullification and about ability of a lawyer or any party to address jury nullification in closing arguments. And that's 163 Wisconsin 2nd, 949 State versus Bridgerkis.
Bridgerkis.
Bridgerkis Lurkis. It's 1991. On the third point on that case, there's a whole section and outlines about. I gave you the first paragraph and last paragraph, but it's basically a whole page that talks about the history of jury nullification in Wisconsin and the differences and what distinguishes, and basically saying that you cannot argue for that. No lawyer can argue for that. No body can argue it because it's contrary to law. But ultimately, the problem is that the state cannot appeal from a not guilty verdict of a jury. So
Right.
ultimately, the state is the ultimate finder in fact, and they do not have to give their reasons. They can completely disregard the law and just say not guilty based on any reason they come up with at all. That's called jury nullification when they are not following the law. But there's no check on that because there's no state appeal to a not guilty verdict. But that doesn't mean that you can argue for it because it is the jury must be instructed to follow the law.
Right. And that's why
Yeah.
you can't mention it But I think jury nullification is actually an extremely important right that Americans hold. But the idea of the ability to taint a jury into the idea that they have a duty to nullify things is kind of a problem, because we want juries to apply law. But what jury nullification organically is, to me, is a manifestation, or should be, it's a manifestation of a communal sense of injustice, either in a law that exists or in a particular circumstance that exists. So,
But see, you could argue that without asking for jury nullification. What you can say is, you can say the state is here holding my client and they want to make him a criminal. The state of Florida or the state of Wisconsin, right? And this whole machinery is designed. And what did my client do? They're saying he violated this law. I mean, you can argue jury nullification without arguing jury nullification, right? You don't say disregard the law. You say you are the finder of fact. They can say what they want. They've got the law. You've read the law. You've got it. But you're ultimately the finder of fact. That's in the jury instructions too. And that's your responsibility. They can't put him away without your cooperation. See? So you can argue that. And I'm not arguing jury nullification. I'm just arguing to the jury that they have power. And not to let the state say, you must follow the law, therefore you have to find that we're right. You see? So you can, it's
right.
there. And ultimately the jury's, I mean, where it really comes in is misdemeanor, because so many misdemeanors are stupid. And the state's pushing these stupid cases. And the jury looks at it and says, this is stupid. This is why we're here. And they vote not guilty, even if technically they are. And all power to the good jurors that do that.
Yeah, and the other the places where I kind of see jury nullification having really, really important impact, and where I would like to see more juries to proactively nullify potential verdicts, are gun laws that I think people believe infringe on Second Amendment rights. I mean, to me, like when the New York State Pistol and Rifle Association or whatever, the law that was being challenged there, had that been enforced on anybody, I would pray a jury would go, this is stupid. Like, this is a dumb law that this violates Second Amendment rights. That's what I would want to happen, for jury nullification. Marijuana, drug laws, personally, I think, like, just possession charges for marijuana, if the state's people believe that it should be a legal substance, I think that's a place where nullification comes in. We don't have any violence. We don't have distribution. You just got somebody tagged for possession of weed. That's where I would be like,
but on the other hand, and I will put the shoe on the other foot, because I agree with you. But the other problem is, what about all these DC juries that are letting people that are guilty of felonies for violating laws off because they're of the right political stripe? So that's a problem too, is juries nullifying what is very bad behavior when it's of their own ilk.
Right.
So,
that's true. That's true.
So so he's in the courtroom.
Yep, he's back to deliver his closing arguments. I'm going to put the over under at 22 minutes. I don't know that his closing's actually going to go that long, but I think the judge will stop him. I think he'll transgress.
The judge is going to stop him. He's going to get removed. I'll put money on it. He's going to get removed at some point, because he's going to talk about all kinds of things he shouldn't. She's going to scold him over and over, and eventually she'll have enough, and he'll forfeit his right to close at the end. I think that's what's going to happen, but maybe I'm wrong. That's just a prediction, but prediction from past behavior is sometimes the way to go.
I'm going to start reading some of these chats that we've got here.
Or the record should reflect that Mr. Brooks is now present in the main courtroom.
John Christian says, I accept for value in return for value on subject matter jurisdiction, and ask you a question under lawful law. Under law, what is my name? Math Boy Fly.
Closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
The request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you.
Dear Lord.
Did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There is no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
You
My
ripped up her
my
written decision, you dummy.
Has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
A volume's a little low on it.
Objection to the lack of jurisdiction has been noted repeatedly on the record.
I can bring it up here.
It is a meritless argument. I've indicated
Again?
that in
Okay, here we
my
go.
written decision as to why there is subject matter jurisdiction. And I will continue forward with
Good.
the final stages
By the
of
way,
this trial,
Fuck you, YouTube,
which I
for
hope
doing this
includes
to
your
me.
closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to
I
the
accept
defendant.
for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All right.
So that is a tacit agreement.
Oh, he said tacit. My man has grown. Huh. Our math
Mr.
boy
Jury,
has
the
become a
jury's
math
coming out.
man. Huh. He's finally. Oh, by the way, almost 22,000 people watching on Rumble. Hit that plus, hit that thumbs up if you're on a browser or your mobile app. I know many of you watch on your TV apps, but if you can hit that thumbs up, it really does help boost the show into the stratosphere. And like I said, I came to Rumble to take it over.
Thank you, everyone. Please be seated.
Here it comes. Strap yourselves in.
Go ahead.
Drink them if you got them.
You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity
gonna-
to provide
He
your
might not
closing
even make it
argument
to 0
the
minutes.
Jury,
He
please
might
start.
forfeit his
I have,
closing
started
argument
the
if he won't
timer,
do it.
of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury
He's going
needs
to try and
understand
get
the
him-
truth, their rights,
get his
and their
closing
duties
arguments
as
cut
they have
off.
not been informed of.
Oh,
that.
yeah, sure.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you
They
inform
will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time,
Move the
this is
jury.
your opportunity to provide your closing argument.
end
Please
it.
begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
Oh,
Brooks,
there it
you
is.
have
They
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All
He's
right,
making
I'm
the
going to
argument right
excuse
now,
the
Judge.
jury.
You're allowing
They
him to
should,
do
they
this.
should know that they have the power.
Please rise for the jury.
Oh, wait, they're not in there. Okay, good.
No,
I
no,
thought the
but-
jury was in there.
Oh, really? I don't know. I thought the jury was in there too.
I mean, that's what it seemed like, but no, she just said, please rise for the jury. So
Okay, yeah.
he's gonna say it again immediately.
State versus Barakis is the jury nullification arguments cannot be made to the jury. I just posted it in chat.
Baracus was the car. I was the accident.
Thank
Train
you.
wreck.
Please be seated.
Best of the best
Mr.
too.
Brooks, you do not have a right to request jury nullification directly from this
no, the jury
I
was in
direct
there.
your
Yeah, so they
attention
just excuse the jury so she can shut him
to
down.
Jerkis case, BJERKA.
Boom.
That's state versus 163,
Nice.
Wisconsin
Nailed it.
2nd, 549. Well, you are not incorrect that the jury has the power to nullify. They don't have the right to do so, and no party has the right to instruct or to request an
that lawful
instruction
law?
or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time. And then, of course, you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice.
You will
So
choose by
you
your
can't
conduct.
Coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not
You don't
made
have
a
much
choice.
ability
Sir,
to
the
not
time
allow
has
that.
come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record
determination as of yet, but you can forfeit your constitutional rights
under
by
what lawful
conduct.
law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of
the
those that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how is that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are 2 examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular
And
defendant.
that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third
3
time.
times.
Okay, now you can say
So, Mr. Brooks,
4.
I'm advising you yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
It's
you are
not trying
going
to
to
give.
He's
let
going to
me ask
forfeit
you
it
a
before he
question.
gets to
I'm
deliver
not
his
gonna
argument.
give
Yeah.
Sir, you're
jury
interrupting
instruction.
me and you haven't let me.
She should let him talk right
Or are you
there
telling
and
me
let him say, I'm going to
that
tell
you are
this
going
jury to nullify.
disregard my very
And then he
That's what she's
says,
gonna do
directive
right
to
now.
you to not bring up the topic of jury nullification.
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what
See,
I said.
Sir, you may
Sovereign
not
Citizen Playbook.
argue jury
I don't understand
nullification
anything.
I'm going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
You
attention.
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury,
instruct them.
the jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're
Power.
interrupting me once again.
So I'm going to inform them that they have the power.
No,
Are
you're
you
not.
telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I just
disregard
told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkas says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
He
I just
can't
want them
inform
really to be
them.
You
informed.
can
That's it.
call it informing, making them aware.
Yeah,
Whether
they should be aware
You
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have,
have? I'm not giving a new jury instruction.
You,
That's not what I'm
There is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not-
because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm
Yes, it is.
advising you one more time.
yeah, it's specifically
You
against
may
the law.
not
That's what she's
raise
telling
the
you.
issue of
I'm
jury
going
nullification before
to
this
inform
jury.
them of the power that they have.
Then you
Okay,
will.
then
You
you
are
forfeited your
telling
right.
me
Right
that
there,
you
take
are
it.
Jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you
See,
saying.
that's
She
not what I
argues
said.
right past it.
Don't
He
mischaracterize.
just
what
said it. He made an affirmative
you
statement.
just
He's
read
going to
and
do
said
that.
that they have the power.
Accept it.
They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware
She just
that they have
synthesized
the
that on the
power
fly.
to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
If
Your
you
Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say
then you
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
the record should
What you meant.
accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding
the
a jury instruction that was not there.
76 verdict forms, and it's times 2 because there's a guilty and a not guilty.
Okay.
For each, no, let me finish.
So
or
how
you've
did
interrupted me
I have why did I
repeatedly.
have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end
Brooks.
of last night before you called
I'm
recess.
not going to debate
We had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court.
Here we
you
go
can
with this.
roll your eyes
Here
at me
because
all you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said-
read this to you, sir. The
Don't do
part of the
that.
case that's important, but you're not
Jeez.
letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom.
No, do it.
That is oftentimes what I need to do in order for this court to make a full record
You
without
have-
you interrupting
You have
me.
enough of a record to
But
end
you
this.
need to
He
be
just
fully
said he's-
aware.
He
That
gave
you
it to her on
may
a silver platter, and she let it go.
Raise
Yeah.
the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction,
Don't say
you
that.
will
Just say you're
forfeit your
going
right
to
to
inform the
present
jury
a closing
about jury
argument.
Under what
nullification.
lawful law?
Under State versus Anthony.
That it doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't change
general
the law, Your
Watch
Honor.
her.
You can't change the law. That's
I'm
practicing
not
law
changing
from
the
the
law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate
This is so
case
painful.
pertain to something here that doesn't even
Just
pertain to it. It has nothing to do with a closing argument.
Just end it.
Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I would
Allen.
like to make a record. Would you
No,
please
don't make a
show the
record.
courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it.
She doesn't
We
need. She can
recognize
just cite
two
it.
distinct ways in which a defendant may give up his rights: waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture: doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture or conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor.
Okay.
Object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power.
Okay, boom, right there.
Again, I never stated
Rule.
End it.
that
You forfeited your right to do closing
End it,
argument.
end it.
Instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
That would never go over in court if
And
you're a
case law
lawyer.
that you just cited made any reference whatsoever
It doesn't
to a closing
matter.
argument.
It-
Not one. So how is me merely
I am kind of
informing
surprised she
the
doesn't
jury
have a
of the
forfeiture
power
of closing argument
and the
case
rights that
somewhere.
they
She
have?
does. She just cited it. It was the one I was telling you about.
How is
And
that?
she cited that early on, but she went back
being
to this
able to
Allen
get the
case. But
closing argument?
she should stick with the other case.
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkis, 163
That's it.
Wisconsin
Boom.
2nd at
Stop it.
549.
That's
That's
a
Goes
lot
me
of
the
cases.
profit.
case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now.
Oh God, this is like
I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that
Hold
fair?
up.
How's that balanced?
Hold up.
Mr. Brooks, I'm squarely
Hold up.
faced with your defiance
Hold
regarding
up.
the issue of jury nullification.
It's
That
not
is
defiance.
requiring
It's not
me
defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently,
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
vehement. Oh well, in that
Objection is
case,
noted
I've
for the
reconsidered.
record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
No.
That request is denied.
May I respectfully ask for matter of fact, I reject that ruling and take exception to that ruling.
Okay. Take it to the appeals court.
Your
For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically
Look at the
talks
guy
about
behind him. What's this guy up to?
a closing argument.
He's very interesting. I'm shocked that they let him have that puffy jacket.
all of those requests
In Minnesota
are
courts,
noted.
you cannot wear a
I
jacket
will
into a
not
courtroom.
reconsider. I've put my findings and my reasoning.
Bring the jury in. Stop engaging
On the
with it. Say, okay,
record.
bring the jury in. If he does it again,
For the
you
record, may I
forfeited your right.
You request a written judicial finding of facts and conclusion of law.
No.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
Yeah, but she's not the
You
forum.
would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your Honor,
a court of
because
appeals, not this court.
No.
She is
I'm supposed to
engaging.
be
She
in
she
this
doesn't resolve it.
because you haven't.
She's by sitting there engaging with him. She's allowing him to continue this dialogue.
Common law court, that hasn't even been addressed. If we're in a common law court or an admiralty court,
It's
That's
the
a
admiralty
basic
court.
argument, sir. I don't even need
and
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the
Prosecution's
same
under the
rules.
same
the
rule. They can't
circumstances
mention
of
jury
this
nullification
case
either.
And your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this
I haven't
rule.
argued it. I said that I wanted to inform the jury of
You're
their power.
informing
I
during
never once
argument,
said,
which is
I'm going
arguing.
to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why not?
jury
Why can't they be
nullification,
informed of their power?
because it would violate the Bajirkas decision, sir.
Violate what decision?
The
All right,
Bajirkas.
sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based
Then
upon.
I make a
how
oral,
I've
I make
outlined
an
that
oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to
Don't
see
bring
what
the
you will
jury
do.
out. Just
But
forfeit
if you
it
raise
because
the
he's
issue of
going
jury
to raise it to
nullification,
the
I will
jury.
immediately dismiss the jury. You will forfeit your right
You're going to give
can't
him
do that.
again what he wants.
present a closing
Under what
argument.
lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
Your
All
Honor,
right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative? And I
No.
really respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Yep.
That's insanity.
Proper
Saying the
thing
quiet
to
part
do,
out
I
loud.
think, Your Honor.
Stop interrupting
I don't
Attorney
think I
Hocker,
should be
please.
talked down to.
Allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or
No.
not he's forfeited his right to a closing argument. But we
No,
could at
that's
least
silly.
try
That's a terrible
to-
plan.
by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to
Just
move on to the
give a
next
corrective
topic,
instruction
we
on
could
jury
try
nullification over
to
and
allow
over and
him
over.
his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this
I don't agree.
next step, or else we will continue at this pace forever.
No, you don't have to continue at all.
She's trying to interrupt the bickering here.
I'm certainly willing to try that.
No.
Control your own
Jeez.
That's about all we
courtroom.
could come up with, Your Honor.
It's what we
I'm
can
certainly
come
willing
up
to
with.
try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the
Why?
second step, and then third.
No, this is terrible.
Why would you have him present from the other
Your Honor, I
courtroom?
object to that.
Him being in this courtroom or in that courtroom doesn't have any impact on what he will say
Your
during
objection is
closing
noted
argument.
for the record. That will be the course of action that this court takes.
Stupid.
So stupid.
Time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
He's going to
All right,
immediately
with that, let's bring the
inform the
jury
For the
jury
out.
of
record,
jury
may I
nullification.
respectfully request the legal reconsideration of your ruling?
Denied. No,
Boy,
request
he
accepted.
has really studied
Denied.
this sovereign citizen document
My objection.
to the T, and he is sticking to it like a matter of biblical faith.
Yep.
And
He's
decline
just
to
got the
reconsider.
talking points right in front of him. He keeps reading
I
right
reject
off.
that
them.
ruling and take exception to that ruling.
He's reading from that document, right?
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
I take exception to that
For the
ruling.
record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
No.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
Not with me.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction,
Denied.
which this court has no subject matter jurisdiction.
Denied.
He even misunderstands.
Based on what law or fact?
Advice for the jury, please.
Based on what law or fact?
That's a motion to stay during the pendency of the interlocutory appeal, which would be proper if he had
Going
actually
to
filed an interlocutory
Inform the
appeal.
jury of their power. They deserve to know.
Just don't
terrible.
let him give the argument.
If he says it, she needs to just remove the jury and say, you forfeited your right to the jury. I'm submitting it to the jury. You're going to the other courtroom. I'm going to read the final
He
instructions.
just said he's going to do it. So
I know,
Just end it now.
but she doesn't want to accept his statements that he's going to do it. So he's got to do it yet again.
Thank you, everyone. Please be seated.
And then he'll have already informed the jury of their power,
Go ahead, Mr. Brooks, your
and
closing
it
arguments,
will have
please.
defeated the purpose of all of this bickering.
Will it take
Like-
one sentences or two?
Good afternoon. It's been a long day.
Okay. 2, it looks like.
First off, I'd just like to start by letting you guys know that
You have the power.
it's a lot of information that you guys should be privy to, I believe.
Here it comes. 3 sentences, I guess.
And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot
He
of
dances around it.
theatrics.
Credit to him.
Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth.
Okay, this is fine.
You should be informed that you have the power
Oh.
to nullify any law that you
There
want to
goes.
do.
Done.
Objection, strike the statement.
Sustained. I
Objection.
will strike from the record the last statement made
Shut
by.
him down. You have the power.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law.
Color of law, color of law, color of law.
The fact of the matter is, just like I did with my opening statements, I don't have a well prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart.
It took 1 minute, 26.76
What you
seconds.
won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not gonna waste your time doing that.
Okay, thanks. What are you gonna do? Just say you did it on purpose. Make it easy for everybody.
It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year for the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone.
Jeez, what an abuser.
Which you've been hearing from the prosecution, not to take anything away from them, but let's call it what it is. You've been hearing a lot of
Rerunning.
same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing?
You know what song I don't hate? What the business?
That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives.
Narratives. Oh, I like that. That was good. If the dude behind him starts dropping a beat,
Sitting back helpless while other people paint a picture that has zero truth. Zero.
and then he started rapping his closing, that would
I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing.
This is this is manipulator abuse
Man, with
number one.
children myself.
The judge is going to say, "Oh, I forgive you," and she's going to come running across the bench, give him a hug.
get married.
Yes.
I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
You haven't? Oh, I have.
I remember there was a guy that ran some people down in a parade that did that.
Attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection.
Facts not in evidence.
Facts not in evidence.
Was in fact-
Argument, Your Honor.
Sustained.
Was in fact recalled.
Objection.
Was in fact a class action lawsuit against Ford
Objection.
Objection.
Facts
for
not in
those model
evidence.
for those model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to,
You didn't raise
that
it.
you weren't allowed to be privy to.
Objection.
Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks.
Throttle
move on.
bodies.
it's information that you should have been privy to.
You could have had an expert come in.
Vehicles that
Hey, if you
malfunction
had
and
a lawyer.
accelerate, not being able to be stopped.
Objection. That is.
It's
completely
information.
inaccurate,
It's
Your Honor.
There's an
information.
objection. Hold on. Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
C.
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know.
The judge is asking for this.
Yep. She could have stopped this at any
Information that
time.
was
Yeah.
taken away.
All the
from
grounds to stop it. She still does. He's still misstating
you. Why? To prove the
facts and
case.
law.
It's pointless. It's pointless to even object because she's not going to
Information that you
enforce it.
definitely should have been privy to.
So let him say whatever he wants and did covered on rebuttal for the state.
DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did it. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is, where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill. And it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding.
There you go. There's a good fact. That's good.
So where does this rage kick in? Where does
Finally, he's connected some evidence.
Insatiable intent to kill kick in?
So he's admitting he's in the car.
They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
What if it couldn't?
In fact, not in evidence.
What if
The facts are actually the opposite
driver
of
of the
that.
vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? That make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people?
Dog's going nuts back there.
I'm sorry, he's nuts. He is
They
nuts.
played a exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people.
Isn't that kind of what happened?
Reference was
That's
made
what
to
the jury's thinking.
this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. For her testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that.
Didn't sure prosecutors.
They're gonna cut back in 10 minutes. They're here now. They're gonna be here.
I go back to trying to wrap my head around everything that's happened in the last year.
Gosh.
Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded.
I think he thinks like
Makes me
this
wonder,
labor delivery is like dramatic,
does the DA even
or maybe
care
it's
about
just
those
natural. I don't know, but it makes it really hard to listen to a word he says. It's disjointed. There doesn't seem to be a narrative arc that's useful.
Well, it's pathological.
There's been prayers going up every day.
He's a master manipulator. This is a short-term pathological manipulator who is completely self-centered child.
Been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss.
None of this is relevant to the trial. None of this is relevant to the
Having to
trial.
navigate
But there's no point in objecting.
everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, with you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer.
Wait, what? Those aren't the hardest questions all the time, actually. Some of the hardest questions have very definite answers.
That may be, but he may genuinely not be able to understand. He's so self-centered.
Look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love. Still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once.
This is not helping you.
Because I know it wasn't.
Oh boy. I know.
As a matter of fact, it never even crossed my mind to even attempt to ask myself that because I know it wasn't.
Okay, but the jury has to ask because you're not them. They're not you.
Gosh,
And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
this is textbook.
So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial.
Oh my God.
And
Spit it
again, I
out.
say the same thing that I said earlier.
I think he's going to make the over on the 22
Same
minutes.
thing
Though.
I said.
I think he's going to do it.
Opening statements. I'm
But I
not
don't know
reading
how
from
long he's been
any
going yet.
paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here.
I feel you. You
Everything.
feel me? That's the whole street thing.
You have the decision. You and you alone, all of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others.
Some pauses are
A
longer
lot
than
of
others.
movement in and out of the courtroom for various reasons.
just really one root cause and all that one. All that.
A lot of things have been said this way and that. Let's not get into who killed who. This is
Remember the power.
be a happy occasion.
You can really ruin a good friendship
Don't
by
for
being
one
on
second let it
trial
be
for
taken away
murdering
from you.
6 people.
We need to heal the wounds.
I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made.
We agree. So do I.
The right decision.
Did you say the white decision?
Yeah. Careful there, Brooks. Not sure you want that one.
Yeah, that's what did he say?
It's almost like that message. Well, not message, but that writing when we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses.
What passages did you read?
This is not something that started at the beginning of this incident. This is something that
Oh, really?
has been instilled in me since I came out of the womb.
This is so evil. He is manipulating. He's been his
It's how my
plan.
family lives their life. This is how we was raised.
Again, like, you still have to run through the fact that you ran through a crowd of people. Like, just saying I've been reading the Bible my whole life doesn't stop that. Lots of horrific people read the Bible while being murderers.
This is unbelievable.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
Oh my God.
Oh, you're gonna cry now? Come on.
His
My conscience is clear. Even if it was an accident, your conscience wouldn't be clear, weirdo.
A real human being would have.
Because I believe I trust him with my life.
Somebody who had any compassion at all, even if it was an accident, would be feeling horrific about killing one person.
I mean, look at Kim Potter, the difference.
Nobody will ever know why.
That perfect, exactly.
For this to happen.
I'm going to go for number 2, by the way.
Uh-oh.
A lot of lives were changed that day, mine included.
Strongly debating starting.
This is unbearable. The self-centeredness.
Not our own. And no matter how much sometimes we want to question, we have to have faith.
God.
Passion of the grounds. Oh, come on.
Passion of the grounds.
Oh man, I got chats to read. Disband the EU says this is why females shouldn't be judges. A complete clown show
yourself.
full of bickering and arguing in a circle. Also tell me any white person would get this much leeway.
Well, with this judge, I don't think race is the issue.
Decide yourself and make the right decision.
Yeah, I think this judge in general is just not
capable of handling this kind of level of self-centered, narcissistic, sovereign citizen BS.
Yep.
They're used to good. I want every prosecutor and judge in the country to thank their public defender and defense attorneys next time they walk in the courtroom.
Look inside your heart. You have everything in your hands now.
Command is in your hand. What was that? Ring Raiders? Anybody remember Ring Raiders? I do.
Everything.
I was down with Ring Raiders.
I prefer the Lemmy Kilmister quote that I sent you. Motorhead, just because you got the power doesn't mean you got the right.
Oh, there it is.
Do what's right.
Unbelievable.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision.
Sit down. Thank you.
That's right.
Sit down. Boom.
Make the right decision.
Sit down. That's it. That's
You're
your
done.
conclusion. You're done. That's it.
Yeah,
What else you got to say?
It's hard
It's
to
an
think
okay
about.
place to end, too.
But no, we
He's
need to
got
have
an
the
hour,
second one.
Steve.
I know,
He's got an hour.
but it takes me not only 15 minutes to
Kids
get
getting older and at some point having to explain everything to them. Kids don't stay kids forever.
Some do.
You're gonna cut me off if I get goofy.
Nowadays, kids is frankly a lot smarter than we were when we were kids.
What about the one
Say
you
that
killed,
much.
Brooks? I wouldn't talk about kids, man.
Feel free to kick me off if I'm going off the
I got a letter.
You get
the
white
other
girl
day.
wasted so fast. It's hilarious.
My youngest daughter. And she's still learning cursive right now, so that's
Jeez.
writer when it comes to cursive. She's got it flipped. She said, "Dad," this is from the letter. She said, "Dad,
Jeez.
why are people saying all these mean things about you?" I haven't read the rest of that letter yet.
Alexa, play Despacito.
This guy is such an idiot.
The rest of that sentence said,
Steve's not gonna make it.
"That's not the dad I know." Throughout this year, I've been called a lot of things.
Like murderer.
And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be.
What an idiot. You're such an idiot.
Oh, guys, he's doing it again. He just had the snot line come out. Oh, it's gross.
Oh, jeez.
He's gonna use that same tissue to wipe his eyes again. Oh,
Who, me?
no, Brooks.
Oh,
He
okay.
just wiped away a big snot thing. He did this the other day. Oh, so gross.
Before I close my statement,
Dude, you need a defense attorney.
He's just gonna say. He's just gonna say, "Ooga booga, nullify this jury."
I just want to say, open your hearts.
Open your hearts.
He's so stupid.
Go massage yourself when making this decision. I have no fear.
What an idiot.
Pray and do what you know is right. What you know is right.
Finish the argument.
Sit down, man.
Think
Ugh.
about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture.
I would love to have a picture of the jury right here. Their expressions back there. Look at his stare down.
Yeah.
Whatever you decide, make sure you yourself can live with it.
I'm sure they'll have no trouble.
That's right. We have the power to put you away for life. How quick can I do this? Holy cow.
That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything.
This is everything.
Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a long lot of living ahead of us.
Man, 6 people would have really liked that privilege.
Lord willing.
This guy makes me want to be a prosecutor again.
This guy makes me want some extrajudicial remedy.
It's been about 3 weeks with you. Took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot.
I don't have a running timer on how long he's been going, guys. All I know is
it was
too
like
long.
Too long.
You should be commended because it took courage to do this.
It's both longer than you think and shorter.
I don't know, but I would bet a lot of people wouldn't want to be
That's what she
sitting in your
said.
position right now.
I got that one.
And you guys had the guts to do it.
Someone said 15 minutes left. Oh,
Painful. This is painful. I mean, he could have sat down a long time
Thank
ago.
you for that. Thank you for taking pretty much a month and setting it to the side.
what should have been a 5-minute
for
case.
this.
Narcissistic control freak. See, he's a control freak. He wants to bully and control and beat down everybody around him.
I know it's probably not proper, but you guys deserve a round of applause if you could get one.
I'd love to see the jury's faces right now. Look the way he's looking at him.
Yeah.
But I know they can't show that.
Thank
They're
you
not.
guys sincerely, and I know, and I have faith, and I trust that you guys know what's right.
I know it's
Ladies and gentlemen, I don't think it's fair to just say guys, but
Hey, Steve, can you DM me a link to your, or private chat, send me a link to your Rumble page so I can let people know
believe
where
in your
to
heart, you know
check out your Rumble
what's right.
channel?
Thank you.
Hey!
Oh.
Hey! Woohoo!
He got through it, only violating the judge's order
Before I
about
give
4
the state an
times.
opportunity,
Now this is the danger zone
present
for the
rebuttal.
state. Rebuttal closing argument.
Yeah.
The rebuttal argument should be simple.
She is. I don't even know. I'm sort of
I
forgotten.
can do it. I can do it. Here, it's really simple. You've heard Mr. Brooks. His entire closing argument can be summarized as you having the power.
All right, have a seat,
And we agree
please.
that you do.
Attorney Apparai.
You have the
Your time
power
both
to bring
closing, you have
justice
13:28 left.
to 6 murdered
Thank you, Judge. I
people
don't think that'll
and
be
over
an issue.
60 more injured. You have a power to bring civility back to the state of Wisconsin.
Look at the look. She's licking her chops with like anticipation of the prey. And be careful because she can go overboard on this rebuttal.
Speaks to you from his heart. He plays on your sympathy.
Ah,
Talks about
stop.
his children.
I don't know.
Talks about the
Just stick with it.
hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family,
Good.
and family, the Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones.
There you go.
This is very good.
I don't know why he did this. I told
Right
you.
on.
But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known.
It is known. Yes. Game of Thrones.
Perfect.
You don't
Exactly.
have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane
That's the
Kulik
kid.
fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You
Oh,
murdered.
Boom. Boom.
You
damn.
endangered the safety of 61 others. There are 68 victims in this case, folks.
That's that
That's
exclamation
not an
point you need.
accident.
Bam.
That's not a gee, I woke up one day and don't know how I found myself in this position.
Sit down, man.
Explain
Perfect.
to your children, Mr. Brooks. I recommend you do it.
All right, baby. That
Oh
was
yeah,
it.
there it is.
That was
Thank
great.
you.
I salute you, baby. Woohoo. Hire me,
Now,
man.
members of the jury,
I'm ready.
the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the
This
rules
is
of
the
law.
final jury
to govern
instructions.
you
She's
in
going to
your
give it to the jury, and they're going to go out and
The
declare
time
the
has
verdict.
now come when the great burden of reaching a just, fair, and
1 second.
conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following
What are you
76
doing?
forms of verdict will be submitted to you
Monster.
concerning the charges
What are you
against the
doing?
defendant,
Got a refill.
Brooks. Count one.
That's like a bad
One
plan.
reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count one of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count one of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count two. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count two of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count two of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon?
This is going to be very
Count
long,
three.
by the way.
One reading,
is,
we the
all the
jury find the
charges.
defendant, Darrell E. Brooks, not guilty of
70-some
first-degree
charges.
intentional homicide as charged in count three of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count three of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon?
She's got to go through
Excuse me.
70 charges and their lessers on the verdict form.
Sorry,
is
count
what she's
four.
reading
One
through.
reading, we the
But
jury
she's
She's
got
on
30
count
pages.
4. She's got
Darrell E. Brooks,
70
not
some
guilty of first-degree
charges.
intentional homicide as charged in count four of the information.
Cheers, my
Third
friend.
reading, we the jury find the
Cheers.
defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count four of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count five. One reading, we the jury find the defendant, Darrell E. Brooks,
I'll
not
join you in
guilty
one,
of first-degree intentional
but I think I'm gonna
homicide
keep
as
it to
charged in
one.
count five of the information.
How many did you have last
Another
night?
reading, we the jury find the defendant,
You know,
Darrell E.
Steve,
Brooks, guilty of
they're hard
first-degree intentional
questions.
homicide as charged.
You
in
don't remember
But
after
don't have
5?
answers.
You find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count six. One reading, we the jury find the defendant, Darrell
This
E.
is going to get
Brooks,
really long and draggy.
first-degree intentional homicide as charged in count
That's
six
what I tell
of the
all my dates.
information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree
You
intentional
know, I was in a
homicide.
fraternity in college, so this is not foreign to my
You
ears.
find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count seven. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count seven of the information. Another reading, we the jury find the
I
defendant.
want to
Darrell
toast
E.
the
Brooks,
chat
guilty of first-degree
to
recklessly
get
endangering
to
safety.
making getting it
Count
through
7
this
of the
trial
information.
and getting it to
Find
the
defendant
jury.
guilty of first degree recklessly
Thank
endangering
God
safety.
this
Answer
is
the following
over.
question, yes or no.
Cheers.
Cheers.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 8. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 8 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 8 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 9. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 9 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first degree recklessly
Oh, okay.
endangering safety, answer the following question.
I had a
yes
line
or
from
no.
a Heart song
Did the
stuck in my
defendant
head.
commit first
It was
degree
What About
recklessly
Love? I couldn't think of the
endangering safety
song.
while
What
using a
about
dangerous
that's 80s Heart? I
Yeah.
prefer 70s Heart.
One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree.
Yeah, I don't know how much you want to
endangering
listen to
safety
this.
as
This
charged
is
in count 10 of the
just
information.
redundancy. It's over
Another
and over. She's reading the
Find the defendant, Darrell E.
reading
Brooks,
the
guilty
verdict
of
forms
first
back.
degree recklessly endangering safety as charged
So,
in count 10 of the information.
but I'm down with whatever the Pope,
Find the defendant guilty of first
whatever the
degree
Pope
recklessly
deems. I'm here.
Answer the following.
I might
I
in
will
a
say
minute
I will
turn it
pledge my
down a bit.
undying loyalty to the
First degree
Pope.
recklessly endangering safety while using a dangerous weapon.
I will never go on that other show, nor
Well,
will I
what?
ever enter into that other channel.
Not guilty.
You know, that
What are you
other
talking about?
non-rumble
Safety as
zone.
charged in count 11 of the
No, no,
information.
no. You definitely
Another
go on
reading.
Jeff's show.
We,
Jeff's
the jury,
amazing.
find
No,
the defendant,
Jeff, which one's
Darrell E.
Jeff?
Brooks, guilty
Legal
of
Vices?
Vices.
first degree
Oh no,
Yeah.
I love Jeff. No, I'm not talking about Jeff. I'm talking about
of the
the
information.
one that's on the bottom
Find
tier of the
defendant
Andrew
guilty of
Bronco
first
writings.
degree recklessly endangering safety. Answer the following question, yes or no.
Or any other that you
First
deem
degree recklessly
unworthy.
endangering safety while using a dangerous weapon.
No, I've
Count 12.
broken.
One
I've
reading.
broken him.
We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering
I've
safety.
made 10 cents on Rumble.
12 of the
Cheers, Rumble.
Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 13. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 13 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree?
No, I'm
recklessly
not going to
endangering
listen to
safety
him.
while using a
Don't
dangerous
you people
weapon?
understand? I have oppositional
Count
defiant
14.
disorder.
One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 14 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks.
It's too
guilty
bad
of
we can't
first
drink
degree
actually
recklessly
in
endangering
trial.
safety as charged in count 14 of the information. If you find the defendant guilty of first degree recklessly endangering
Drink every time the
safety,
judge
answer
says
following
guilty,
question,
go.
yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 15. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 15 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 16. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering
What
safety.
number are we on?
Count 16 of the information.
16. Holy
Another
cow.
reading.
We've got
We, the jury,
76
find
of
the
these.
defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 17, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 17 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 18, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty.
So what she's doing here is she's reading through the verdict forms. So the verdict forms for each count, there's a page, and it says on the top, guilty first degree murder. Yes. If you answer yes, then did you use a dangerous weapon? Yes. And then they'll have the lessers, and then at the bottom, not guilty. So for every charge, there's a verdict form with these choices on it for the jury. So she's reading through every verdict form for the jury because the oral governs over the written.
Find the defendant.
So this is required for every charge, and she's got 76 charges.
Charged in count 19.
So the reason this is so long is because this idiot mowed down 76 people.
First degree recklessly endangering safety as charged.
That's what she's doing, and that's why you're going. It sounds like it's repetitious, which it is, but every one of these readings represents a victim, somebody that he hit and injured with his car. So just to get a context there.
Count 20.
That was beautiful. By the way, the chat was on punishment from me.
Not guilty of first degree
They told me to talk. They told me to talk more, and I have oppositional disorder.
No,
No, I know why. The reasoning was valid, but I don't listen to people as a rule. So I was giving them the silent treatment like they
If
deserve.
you find the defendant guilty of first degree
Like a
recklessly
battered
endangering
woman.
safety, answer the following question, yes or
Sit there
no.
and take it.
Did the defendant commit first degree?
If at any time I'm out of control, you cut me off, all right? You got to protect me, Pope.
One reading.
The
We,
only
jury, find the
reason
defendant,
at
Darrell
all
E.
that I will
Brooks,
give you
not
any
guilty of
protection is
first-degree
because you
recklessly
are a
endangering
diligent
safety
and
as
useful
charged in
public
count
servant
21 of the
Shit.
information.
of the highest
Another
order.
reading.
If
We,
you
the
were
jury,
anyone
find the
else, I
defendant,
would leave you
Darrell
to
E.
your own
Brooks, guilty
demise.
of first
All right,
degree
thank you.
recklessly endangering safety as charged in count 21 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety? while
Yeah, I had to
using
turn it
a
down because I can't sit here.
Count
These are all
22,
very
one
important, but it's
reading.
very
We,
dry
the jury,
reading.
find the defendant,
And
Darrell E.
Steve
Brooks,
explained
not
exactly
guilty of
why
first degree
this is
recklessly
done.
endangering safety
This is a
as charged in count
critical element
20.
of
2 of the
the
information.
American legal
Another reading.
system
We, the
is
jury,
completing
find
a
the defendant,
record.
Darrell E. Brooks guilty of first degree
How do I
recklessly
phrase
endangering
this?
safety as charged in count
Oral test, the oral statements of the judge are what govern,
guilty of first
not the
degree
written.
recklessly
So the
endangering
oral governs over the written. It's in Florida now. It may be different in different jurisdictions, but
safety.
basically, and I think that's what's going on here is that the written document that she submits is not the authority. If there's a contradiction between the written document and the oral pronouncement governs. So therefore, she has to be correct in the oral pronouncement. She's reading the documents, so it should be the same thing. But the basic idea here is that she is orally pronouncing everything on the record, and then the written document follows. So that's kind of the ground rules of why that she has to read everything, because the oral governs over the written.
First degree recklessly endangering safety while using a dangerous weapon. Count 24. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty.
There's contradictory things of whether I should drink more or less.
Is charged in count 24.
I just find stupidity entertaining. It just makes me laugh. I can't help it. It's funny. It's like this guy is such an idiot. Oh my goodness.
Oh, he's terrible.
24 of the information.
Ugh.
He's
If
terrible.
you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did
See,
the
we can get to the reason behind factual findings in Apprendi
dangerous
and about what the power of the jury is and what the power of the judge is, because that's very important
weapon?
in a
25
real normal
reading.
case
Jury
and
find
why they're doing what they're
Darrell
doing.
E. Brooks, not
Puddle
guilty
Puddle
of
says,
first
"Tell me more
degree
about the
recklessly
importance of
endangering
oral,
safety
Steve."
is charged in count 25 of the
Well,
information. Another reading.
Okay,
We,
no,
the jury, find the
I will.
defendant,
No, this
Darrell
is
E. Brooks
actually,
guilty
but
of
this
first-degree
goes down to
recklessly
how our
endangering
court
safety
system
as
was
charged in
built
count
and our
25 of the
justice system
information.
as a
If you find the
reactionary
defendant
response
guilty
of the
of first-degree
injustice
recklessly
of
endangering
the
safety,
common law
answer the
system that
following
existed
question,
that
yes
they were
or no.
under.
Did the defendant commit
Transparency,
first-degree
a clear
recklessly endangering
record.
safety while using a
These
dangerous weapon?
ensure that the rights of the
Count
defendant
26.
were honored
One
to the
reading.
maximum
We, the
because
jury,
the
find
presumption of
defendant, Darrell
innocence
E.
was
Brooks,
so
not guilty
critical
of
to the
first-degree
founders,
recklessly endangering
and
safety as
making
charged in
sure
count
that
26
the
of the
public would
information.
always have
Another
a
reading.
record
We,
of
the
what
jury, find the
happened
defendant,
specifically.
Darrell E. Brooks,
Nothing would be
guilty
filed
of
under
first-degree
under
recklessly
the color
endangering
of
safety as
darkness.
charged in count
Everything would
26
be
of the
exposed to the
information.
light. And
If you find
Robert
the
Barnes
defendant
brought up
guilty
a,
of
hold on, I'm going to
first-degree
turn her down
recklessly
more.
endangering
Judge, you
safety,
shut your mouth,
answer the following
dirty
question,
judge,
yes or no.
dirty girl.
Did the
Uh,
defendant commit first-degree
Robert Barnes
recklessly endangering
and I
safety
talked
while
about
using
this on a
a
stream a
dangerous
while
weapon?
ago, and he brought up just this really great point
One
that
reading.
courts in the United States, the
The
reason it was called a circuit court was because judge literally got in a wagon and rode a circuit around their jurisdiction, and they would go and stop at towns and hear all the cases in the town, then they'd move to the next one and the next one and the next one, and they would ride the circuit. The courts in lots of those towns weren't held in a courthouse. They didn't have one. They had an open air place where the public would gather. And again, the critical nature of transparency of the courts to ensure the rights of the defendant is paramount in the criminal system. And we've got to always remember that, especially with monsters like Darrell Brooks. Every single thing must be done in the light and exposed to the open on the most guilty to ensure that it may be done to the most innocent as well. And that it's a foundational point of our legal system that the rest of the world that doesn't adopt that strategy lacks. And it comes from people whose family, friends, ancestry were persecuted by a court system that was closed, that there was no review, where injustice was left to fester in the dark.
Another reading, we the jury find the defendant.
Right on.
Anyway.
Say it.
of
That's
first
right.
degree
Exactly.
recklessly
Thank you,
endangering
God.
safety is charged in count 29 of the information.
Sometimes I say
If you
some
find the
things.
defendant guilty of first degree recklessly endangering safety,
Right.
answer
On
the
it.
following
I have
That
good
was great.
words.
Now that was
Have great
beautiful.
words from time to time, beautiful words.
Beautiful. It's
Wonderful.
Your Trump impression is awesome, man.
I've seen lots of defendants in my life, lots of them, but none of them quite as beautiful as Mr. Brooks. He has a certain eloquence about him, a certain swagger in the courtroom. I think it'll serve him well. Go.
It's the best. It's the best defense. There's no better defense than what we have here.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant
Okay.
commit first
All right,
degree
here we go.
recklessly endangering safety while using
Cubby225 says he could have saved everyone a lot of time with just a shoelace.
one reading, we the
Shit.
jury find the defendant, Darrell
Oh.
E. Brooks, not guilty of first degree
That's a
recklessly
tough
endangering
one.
This guy is, my analysis. He's not dumb.
Another reading,
He's not insane.
find the defendant,
He
Darrell
is
guilty
basically
of first
completely 100% self-centered.
count 31.
He's basically a 2-year-old.
If you find the
He
defendant
kicks and screams. The only thing that matters is himself. He has no empathy for anybody else in the world, and he is basically, the world revolves around him, and he can't look into the mirror. So he's not insane. He's not stupid, and he's not crazy. He's not any of those things. He is self-centered, narcissistic, and that's what you're seeing here, which is a criminal to the ends of the earth. Right here is what you're seeing: criminal.
Reading, we the jury find the defendant Darrell E. Brooks
Let's
guilty
see.
of first-degree recklessly endangering
Roman
safety
5
as
says, for all
charged
this
in
talk
count
about forgiveness and how difficult it has been for him, not once has he
32.
said sorry or asked for forgiveness. Such a liar. It makes me
of
sick.
the information.
Yep.
If you find the defendant guilty of first-degree recklessly endangering,
And because he's so self-centered, he may actually believe that he had no intent to do anything.
did the defendant
When he got up there, he was being honest.
recklessly endangering
You can't look into my mind. I didn't intend, because the world revolves around him. These people that he ran over aren't even people. They're just actors within his little stage play in his head. So he didn't care about them. He has no empathy. They're not people. They're just figures. The only thing that matters is his whole little world. That is a narcissist to the nth degree, and that is where he's coming from. So screw him.
No, okay, I see you, chat. No, I'm not going to invite Peter Tragos on. I am still cleaning up the chat after that mess. How dare you? I cannot abide. I don't have a mop big enough. TMF Squid says, God, I hope the state's entire rebuttal is just playing the clip from My Cousin Vinny.
I'll tell you, and that state rebuttal was epic.
It was perfectly done.
Epic, perfect. That was perfect. I salute that prosecutor.
But here's what they wanted.
Everything that guy just said is bullshit. Thank you.
That's what the chat thirsted for.
When you're ready, have a seat.
They're going to give the stuff to the jury, and they're going to go back and start deliberating. Thank God.
The jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety.
Oh, I left the echo on. I know. I don't like that StreamYard does that. It should mute the stream feed.
Guilty of first degree recklessly endangering safety as charged in count 33.
Well, I got to tell you about what I've got coming up on my Rumble channel too, when we get a chance, because I got some great interviews coming up, and you got to teach me how to do this live streaming thing, because I've only made 10 cents on Rumble.
One reading, we the jury find the Darrell E. Brooks not guilty of first degree recklessly endangering safety as charged in count 34 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count.
What number are they on?
Information.
34.
Find the defendant guilty of first degree recklessly endangering
40 more to go.
Answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 35. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 35 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty.
And this is the thing, it's terrible. I mean, we're laughing and we're talking, we're commenting, we're trying to make this digestible. And the jury has to hear this, the courtroom has to hear this, but we really don't. However, every one of these counts is somebody that was hurt or killed by Darrell Brooks. So, it's a very serious thing. I mean, we're laughing it up and all, and it's easy to take it out of context. We're living our lives, but every one of these counts that judge is reading is a life that's been impacted by this guy.
Guilty of first degree recklessly endangering safety as charged in count 36 of the.
Speaking of ignoring the counts of all the injured people that I clearly don't care about, Eric Speculas says he is guilty and gets a free ride on Old Sparky without the sponge. Ooh.
Without the sponge.
You don't want to be without the sponge.
The jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 37 of the information. Another reading, we, the jury, find the defendant.
Let's see. The Drover says, was waiting for Brooks to start reciting lyrics from Heat of the Moment by Asia. Stop it, chat. I have not drank enough. It was the heat of the moment.
Oh, Asia. I love that song. John Wetton.
Great song.
Holy cow.
Great song. But I've not drank enough to sit and sing all day.
Count 38. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 38 of the information. Another reading, we, the jury, find the
Almanac says, can you ask Gosney if he thinks Brooks was telling the truth about having faith in Jesus?
If you find the defendant
See, it's a mystery. I mean, looking into somebody's head is a strange thing. I think he's a master manipulator, and he is using these things as tools. He is not subservient to God. He is trying to use God as a tool to serve his ego and his self. And that is not the proper role of a Christian. But I'm not one to judge. God is to judge. But he's on trial for the murder of 6 people and the injuries of 70. That's a different thing. That's render unto Caesar what is Caesar's, and he is dealing with Caesar, and Caesar's going to render a judgment.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 40. One reading, we the jury find the defendant, Darrell E. Brooks, for first degree reckless
What?
safety as charged in count
My
40 of the
my
information.
locals chat. It's
Another
it's
reading,
just a
we the jury find the
catastrophe
defendant, Darrell
of
E.
humanity, and I
Brooks,
love it. It's
for
the
first
best
degree
place.
reckless
It's so
endangering
funny.
safety as charged in count 40 of the information.
Oh,
I'm just reading the regular chat. I like the regular chat. I came from the regular chat. I used to be just a regular chatter, and I'd come in a regular chat, and of course Bronca and I knew Bronca because I dealt with him on self-defense stuff. And so he saw me in the chat one time. He's like, Gosney, come on to my show, right? That's how I got sucked into this whole LawTube thing. Although I know I recognize that LawTube is not an actual entity,
We the jury find the
but I got
defendant,
sucked into this from the chat, so I respect the chatters. That's why I love the chat. The chat's like the mosh pit of the law grifting community.
oh, I love the chat too. I'm just saying my locals chat it's something else. It is. Rumble hopefully will get their chat, their actual chat interface up to par with some of the other platforms, because it's really hard to follow the Rumble live like chat, in my opinion, especially when we have 22,000 people. It just doesn't break it out as well as like YouTube, Odyssey, or whatever. It gets hard
The other
to
thing
follow.
that Rumble really needs to do is they need to have like channels, like for when I have a channel that I can break out like playlists, because I have on my Rumble channel, I've got all these different playlists. Like I've got my rock and roll music where I'm playing the bass. I've got my life hacks where I'm talking about life advice.
You can do separate channels.
But I know I don't want to do,
sub-channels.
I want to have it all under the channel, but I want to have like playlists, like this
Sure.
this
Yeah,
is
yeah.
just that, and that's what they should have in Rumble too.
Recklessly endangering safety as charged in count 43 of the information. Another reading, we the jury find the defendant.
See, I'm a member. The chat likes me, but I'm a member. I am the chat. This is the thing. I relate. All I am is a chatter. I just got, somehow you guys picked me up for us.
Steve's over here. He's like, you just look at the chat. I was born in the chat.
I was born. I am the chat.
You're a visitor in the chat. The chat is inside of me.
I'm the embodiment of chat.
Oh. Yeah, chat box over on Rumble. I have mentioned specifically pop out chat, tagging people. That needs to happen.
Just to have it to replay, like when you replay the Rumble run, to have the chat replayed also. That's the thing you need to have.
I think they may have some motivation for not doing that, but I can't comment if that's actually true.
I don't care if they think it's actually true. It needs to be done.
Oh, let's see. We got some of these over on, no, they're on count 45, so we're getting through. No Guard says, if I were on the jury, I would write a question to the judge. Can we issue a verdict of, I would like to personally execute this man with a razor blade dildo. Jeez.
Oh, God, that's painful.
Oh, goodness. Amazing Wireless 2 says, I'm not sure why the fuck I wasted my fucking life watching this trial. This binger should be dragged through town attached to the Red Escape until he is dead. Prison is too lenient to sentence for him. Some strong emotions related to Darrell Brooks out there. Strong emotions.
I'm with you. Like I said, this guy is a walking, talking. He is something pathological. But the system, this judge really showed her weakness. He tested her. Now she is getting it to the jury and all of it, but it could have been done a lot more. The thing is that she ultimately did resort to the ultimate weapon. And so the fact is she could have done that way earlier and saved us a lot of time.
What is this shit?
What is that?
Another reading.
This is an affront. This is an offense and an affront to me. That's what this is.
I don't know. I think it's pretty respectful.
Oh, Steve, there's so much you don't know.
I don't know. I do. That's true.
Did the defendant commit first degree recklessly endangering safety?
Let's see. What do we got next? Matt P. 7705 says his kids, who he doesn't pay child support for, his nephew he shot at, his baby mama, who he ran over with a car, his sex offender registration, pity me, not the 61
Another reading.
or not the
we,
6
the
I
jury,
killed,
find the
not the
defendant,
60
Darrell
plus I
Brooks,
injured.
guilty,
Well, and
Yep.
the thing is, this isn't like his first offense.
charged in count
I mean, this guy has got a huge record.
If you
So
find
he's
the
been
defendant
before the court
guilty,
and dealing with this criminal stuff. I mean, if that all that stuff, if you didn't know his history, it's like, oh, okay. But I mean, this guy has a history. I mean, it's not like this is his first offense. So I mean, he is a classic abuser, which like slaps the woman and then says, "Oh, baby, let's make up." That's exactly what you saw right there. It's a classic manipulation. Oh, painful.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. If you find the defendant guilty of first degree recklessly
People are
endangering
asking,
safety, answer the
so
following question, yes or no. Did the defendant
they're
commit
asking if I'm
first
going to
degree
do a jury
recklessly
watch
endangering
or a
safety
verdict
while
watch.
using a dangerous weapon?
Yeah, I guess I got to stay on
Count 50. One reading.
until the
We,
verdict.
jury,
I don't
find
know
the
when it's going
defendant,
to
Darrell E.
drop.
Brooks, not
I don't
guilty
know
of
what the
first degree
plan is.
recklessly endangering safety
We'll have to
as
see if
charged in count
if
50
she's
of the
going to
information.
adjourn the jury and
Another
send them
reading. We, the
home
jury,
tonight
find the
and bring them
defendant,
back in
Darrell
for a
E.
verdict
Brooks,
tomorrow,
guilty of first
or if she's
degree
going to make them
recklessly
stay. I don't
endangering
think it's
safety
going to
as
be that
charged in
long.
count
I
50 of
really
the
don't think it'll be
information.
long of a
If you
deliberation.
find the defendant guilty of first degree
Well, and I think that what's going to happen is they're going to go back and they're going to say, "Do we all agree he's guilty?" And they're all going to say yes. And then the time is going to be spent filling out the damn forms.
51.
So how long is it going to take them to fill out the forms?
Darrell E. Brooks.
I think they might get it done tonight. I mean, I really do.
Yeah,
Safety
it depends on if
as
she's
charged
going to
in
have
count
them
1
stay
of
or
the
not,
information.
right?
Well, I think they said that they're going to sequester them.
Find the
So that
defendant
means
Oh,
they'll be
yeah.
they'll be. But I don't know if they're going to.
recklessly endangering
I don't know. I don't. This is an
They may
interesting
sequester
question.
him, but they may still send him to the hotel for the night. Like you've been
Yeah,
sitting
but they
through all
might.
this all day.
They might get it done tonight. I'm
Yeah.
saying it depends how quick they can get through those forms.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 52. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 52 of the information.
And what time is it there? Are you in their time zone? Nick?
Yeah, 6 o'clock.
Darrell E. Brooks,
6 o'clock. See,
first degree recklessly
I
endangering
think that it's going to be tomorrow. I hate to say it, but I mean, I don't see them coming back with a verdict tonight.
guilty of first
What do you
degree
think?
recklessly endangering
I mean, if she has them actually deliberate, I think they'll have a verdict within 2 hours. And it's really just filling out the forms that's going to take the time.
count 50.
Someone put up a calculation. They're like 76 minutes to read the pages, 16 minutes to elect the foreman, one minute to convict.
Another reading.
It's the filling out the forms properly that's going to be the thing. I don't know. I mean, they might come back tonight.
Safety as charged in count 50.
It's possible.
If you find the defendant guilty of first
My wife's cooking. Oh, I can smell it. It's wonderful.
following question, yes
Oh,
or no.
that's
Did the defendant commit first
I
degree
can't smell anything from down here except sadness. Sadness in my office
Sadness.
of not having food. I'm so hungry.
Find the defendant
See, I didn't eat. This is the problem. These drinks are impacting me extra strong because I haven't eaten all day.
for the
Yeah.
I had a little egg,
reading.
3 eggs scrambled for breakfast, and that's it.
Guilty of first degree recklessly endangering safety as charged in count 50.
So, what number are we on?
54.
The defendant guilty of first degree recklessly endangering
So,
safety.
22 to go.
Following question, yes or no. Did the defendant commit first
Rackets is getting Jimmy John's. Dude, I would take a Jimmy John's right now. The one that's ham and bacon. Oh man, that's a good sandwich. That's what I've been eating lately.
Ham and bacon, huh?
Yeah. Sliced ham and then bacon and it's Jimmy John's. The bacon's cold, but it doesn't matter. It just adds that bacony flavor to it.
Of first degree recklessly endangering safety is charged in count 55 of the information.
Oh, by the way, I wanted to tell her, but I asked her about my mom. My mom is so wonderful. I've got a great mom. She came on sort of, she's so cute, but she's fighting breast cancer and she's doing great. She went through the surgery. She's handling the chemo great. Everything's wonderful, but she doesn't really want to come onto this law stream. I kind of roped her in for that last time, but anyway, thank you all for the nice thoughts about my mom. She's a wonderful woman. So just to let you know, she's doing great.
you want these. You know. It's more. Oh, yeah, I said printed out.
Yes, I would ask for my mom. If you pray for my mom, I'd love it. Thank you very much for the prayers. My mom needs the prayers. She's a strong woman. She's the strongest woman I know. But pray for my mom, please. Thank you.
All right, thank you. Have a seat.
Oh, wait.
Count 56.
Okay.
One reading.
56 are on.
I don't know what just happened there. I'm having a lot of time caring about the fucking trial because we're just in this.
We, the jury, find the defendant, Darrell E. Brooks,
We're just
guilty
in this
of first
holding
degree
phase.
recklessly endangering safety as charged in count 56 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question.
Stop wearing the baldo on stream. Can't
What?
stop, won't stop. No.
What? What was that one? I missed that one. Say it again.
One reading.
They said stop wearing the baldo on stream.
What's Baldo?
Not guilty of first degree
Still need to know.
count 57 of the information.
Oh my
Another
God.
reading. We, the jury, find the
How much do you
defendant
really
guilty
want to know, Steve?
I don't know if
much-
it's. I
How
don't
much
need
do
to
you
know.
want to
I
know
don't-
about this
I don't
world?
want to know. I don't want to know.
It's sitting next to me, staring at me.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Oh my gosh.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 58. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty.
Let's see.
First degree recklessly
We've got more
endangering
chance to
safety
read. I gotta
as charged in
get through
count
the
56
drunken.
of the information. Another
The
reading.
drunken
We, the
Rocky
jury,
says,
find the
for
defendant,
one night
Darrell
only,
E.
the
Brooks,
drunken Rocky becomes the
guilty of
token
first-degree
Rocky.
recklessly
No drinks,
endangering
just
safety as
joints.
charged in count
Stone
58.
News tonight at 9 p.m. Central. That's on
If you find the
Odyssey, guys.
defendant
The
guilty
drunken
of
Rocky, all one
first-degree
word.
recklessly endangering safety,
Drunken
answer the following
Rocky.
question, yes or no.
Everything's funny when you're drunk.
I know. Gets me in trouble a lot, actually. The drunken Rocky says, legal bite stream is so much better. Said nobody ever. Damn. Meth Bear says, Rekieta Law, this prosecutor dead ass reminds me of Mark Richards with long hair. It does.
Darrell E. Brooks guilty of first-degree recklessly endangering safety as charged in count 59 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following
Oh,
question,
God.
yes or no. Did the defendant commit
Oh, my
first-degree
goodness.
recklessly endangering safety while using a dangerous weapon? Count 60. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly
Amazing.
endangering safety as charged in count 60.
I've never seen a 77 count indictment,
We, the
by the
jury,
way.
find the defendant, Darrell
This is so extraordinary.
first degree recklessly endangering safety as charged in count 60 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using
See,
count 61?
all these charges on all these counts are just bouncing off his head because the
Yeah.
only thing that matters is him.
As charged in count 61.
All those people that he injured
Another reading.
mean nothing to him.
Find the defendant
It's all about him.
guilty of first degree recklessly endangering safety.
It's really hard to, it's very hard to deal with this kind of person.
Safety. Answer the following.
And I pray that the families that he injured find in their hearts to forgive and to move forward.
I don't know how funny Darrell Brooks is, but I think he might be a little funny because I'm pretty sure he's reading from Revelation.
I
Based
don't
on
know
the-
that you think that's late in the book. You think he's looking at Revelation?
It looks pretty deep into that Bible.
Darrell E. Brooks guilty of first degree
I'm
recklessly
saying.
endangering safety as charged in count 60.
I'm
You should
saying.
go back to old Moses and the Ten Commandments. Maybe that's where he needs to start. Thou shalt not murder.
Question, yes or no. Did the defendant commit first degree recklessly endangering
First degree murder. Holy cow.
Count 63. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly
No honor,
safety.
no dignity, no self.
have enough
See, this
honor.
is the thing. If he had any amount of forgiveness or any kind of dignity or humility,
Of first degree
he would have pled guilty.
safety.
And then people get on the public defender's office and the defense attorneys for saying, you need to plea. We're bad guys for telling you you need to plea. But here's
Yeah.
why you need to plea. Why are you doing this? Why are you subjecting to the community to this evil?
One reading, we the jury.
Right? I mean, there is no defense. You are guilty. My advice to you is to plead guilty. Now, we can argue mitigation at sentencing. Okay, fine.
The jury find the defendant, Darrell.
But it's not a betrayal of our client to advise them that they need to plead guilty to save the families and the humanity. But see, he's such a narcissist that he's not willing to do that.
In a weird, it's like a weird, I don't know if I even want to say it because it's so like confusing and conflicting, but there's like a weird ethical obligation where if you are aware of the guilt of the client, it's your duty to inform them that they should plead, like to advise them in that way.
Well, and that's all confidential. It's not being disclosed. You're telling them what the right thing to do is. You're a counselor. You're a counselor. You're counseling them to do the right thing. And the right thing in this case is to plead and to save the families the trauma of this trial.
Yeah. And okay, Penny Whitbrot says, Steve, I will add your mom to my prayers. Please share my story of healing with her. I hope it blesses her. And they sent a video link, so I'll send that to you.
Bless you. God bless you.
Thank
Thank you.
60.
So I just put it in our private chat, so you can save that for later.
All right, thank
if you
you.
want.
I'm gonna save it, okay, and I will watch that.
Tiff, what do you want me to tell him?
I'll just repeat counsel.
Well, you don't make me do this. Don't make me do this, chat.
Guilty of first degree recklessly endangering safety as charged in count.
They really want me to
66 of the
inform you about
information.
what a baldo is.
Another reading.
I don't need to know. I don't need to know that.
Darrell E. Brooks guilty of first.
And the thing is that,
endangering
see,
safety.
people say I'm so innocent and all. I was in a fraternity. I see evil
If you find
in my job every day, but I don't choose to encounter evil as a day. It's a choice. And I understand it. And I'm not Mr. Innocent. I'm not Mr. Holier than thou. I am a humble servant of God, and I try to do my best. And I recognize evil. I don't know. I'm sort of not in my best right now.
No, it's fine. It's fine. And guys, yes, I will talk about Birch Gold, but waiting for the court to get done with this part and have a pause while the jury's out. And then I'll do the, we'll do Birch Gold and we'll have some discussion and hit all the chats and all that stuff's going to happen. But
after this gets submitted, once he gets through we probably need to listen to once she gets through the charges, we'll get through when she submits it to the jury. Then we'll take a break and we'll listen in the court, because right now this is just a listing, a recitation of all the 76 counts. And she's reading through the verdict forms. So she's on 68. We'll get to 76. That's when we need to go back to the court, I think.
If you find the defendant
yes, there is a good Rumble rant, Adam K. I'm going to read it in just a second. It's a good one. I'm going to read all of them, of course, but JM1030 says, hey, Nick, I graduated law school in June, and you wish me luck on the bar. Found out I passed last Thursday. Thanks for getting me through that tough time. Have a drink for me. It's a dangerous.
I'm out. If I go for number 3, I'm going to do it for number 3, but after this gets submitted, because
I thought that
3
was
is
your
my
third
limit.
one.
No, this is 2. 3 is my limit. I'll tell you, after 3, I am done. So I'm going to get 3, but it'll be at the end here on the exit ramp.
I don't know if you, I think chat, was that 2 or 3? That looked like 3 to me.
I don't know at this point, actually.
I think that was 3.
I don't know. I don't really know, but I will get one more, but on the exit ramp. When we know we're going out, I'll get 3. Okay. Just for you guys, just for the Pope.
Did the accident cause death to Tamara Durand? Count 71. One reading. We, the jury, find the
You know what? All it does is make me laugh and make everything is funny, and then I go to sleep. So that's my drunk reaction.
Some people are saying that's your first drink. Oh, okay. That's fair.
No, it's definitely not that.
71 of the information. If you find the defendant guilty of hit and run,
And I don't puke either. All I do is I laugh and then I go to sleep.
accident caused death.
And I'm at the laughing stage now.
72.
Even stupid stuff is making me laugh.
Defendant Darrell E. Brooks not guilty of hit and run as charged in count 72 of the information. Another
They say it's 3. I got to say, I'm going to defer to the chat. It may be 3. If it is, I'm
think
way
it
over
might
my
be.
limit. But I'll go for whatever the next one is. I'll do one more, but only for if the Pope blesses me.
Did the accident cause
Putting
death
your fate in
will
my
be
hand.
possible.
It's true.
Count 73.
They're at count 73.
One reading,
3 more after this one.
Nobody else has sold me books like
not guilty
Nick
of hit and
Rekieta.
run as charged in count
You know,
72
Wow.
of the
and
information.
seriously, it's
Another
true.
reading, we, the
It's
jury,
good
find the
info.
defendant, Darrell E.
And I
Brooks,
know
Did I
the
show you
source of
this?
it.
as charged
Look,
in count
did I show you this?
Oh, yeah. You got him in. Awesome.
Came in today, man, or yesterday, last night. It came in.
Yes.
See,
Very cool.
I've been signing them. I got half the order in, so I'm going to be mailing them out this week.
Count
This is
74.
to JM
One
1030,
reading,
by the way.
we, the jury, find the
cheers to you,
defendant,
buddy.
Darrell E. Brooks, not guilty of bail jumping as charged.
All right. I'm going to keep reading here. Vinny
74
D95.
of
So I
the
got signed
information.
up to my CNC classes. I start next month. Awesome.
Another
Very
reading,
cool.
we, the
I'm
jury,
Guardian
find the
says,
defendant, Darrell E. Brooks,
that does it.
guilty
I'm grabbing me
of bail
book,
jumping as
Project
charged in
Calm.
count
In a few
74
days,
of the
judge,
information.
and that concludes the trial.
75.
Brooks,
One reading,
bailiff,
we, the
full
jury,
press of the
find the
taser
defendant,
belt
Darrell
button
E.
until the
Brooks,
batteries run out.
guilty
Did he get tased once during this entire trial?
He might have been
75
tased
the
off
information.
of the
Another
cameras
reading, we, the jury, find the
at some
defendant,
point.
Darrell E. Brooks guilty of bail
Um,
jumping as charged. Excuse me.
let's
in
see.
Count 75 of the information.
Let's see. We got to. Why is.
One reading. We, the jury, find the
Why
defendant,
is
Darrell
this
E. Brooks,
picture
not
even
guilty of
real?
battery as
What
charged
is
in count
happening here?
76 Of the information. Another reading. we, the
What is
Hold
going on? I'm missing something.
Darrell
I
E.
know.
Brooks, guilty
Hold
of
on.
battery as
I
charged
just.
in count 76.
Why does they have a baby Lori Lightfoot? I'm so
For
confused
you
by
to
this.
determine whether the defendant is guilty or not guilty of the
I'll
information.
bring up the court audio
Make a
when we get to
finding
the
as
end
to
of these
each count
readings
of
and the
the
judge
information.
is there. We're really close.
Each count charges a separate.
I think
count.
she's. I
Oh,
think
here we
she's
go,
on
yeah.
it now.
Consider each one
Yeah.
separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case.
He's like,
Therefore, before the
"Oh."
jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror.
Oh, there's more to that
If
picture.
you need to communicate with the court
more to
while
me.
you are deliberating, send a note through the bailiff
Yeah, Ryan,
signed
I
by the
know.
presiding juror. To have a complete record of this
This
trial, it
man
is
that you use
important
says,
that you
shock this
communicate
MF
with
until
the
his
court
balls
only
start
by
boiling.
a
By the way, the
written
judge is
note.
complete bitch for tolerating this thug. 100%
If you
wouldn't
have
happen
any,
if he was
if
white.
you have questions, the court will talk with the parties before answering, so it may take some time.
T. Jones says, please preserve my rights at
You should
Rekieta Law.
continue
Thanks.
your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to.
Whoops.
After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to
You
the
could have read the
courtroom.
entire Bible
The
during the
verdicts
reading of
will
those
be read
verdict
into the
forms.
record in open court. The court
I think
may
you should have.
ask each of you if you
They
would-
might learn something.
Before
I don't think he's
swear,
read one page.
we will determine the alternates, and then I will have all of the
It's just a prop. The Bible's just a prop to serve the
civilian
will of
bailiffs
Brooks.
and deputy bailiffs that will be
DS
in
Ford
charge of
says,
the
Nick,
jury
where the fuck have you
during their
been?
deliberations
Here,
and
you're on
sequestration.
Rumble and Odyssey.
I know, but you dropped off because people thought that you got knocked yourself out in the last thing. You were disappeared for a while because of your karaoke performance.
Yeah. Yeah. I was supposed to be up this morning. Oh, it was
I have a lot of stuff up here.
it was a long night. Oh, here's the full image. Okay, this makes way more sense now. Now I get it. The image was cut off before. Oh, come on. No.
So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers.
Oh my god.
Those numbers will be the alternates.
Oh, they're using the tumbler method.
Yeah,
that
this
was
is
that was an
That
interesting thing in
we need to call upon one of you to
Rittenhouse.
replace another juror.
And we're like, why are they using a tumbler? And then we found out that's actually kind of a normal artifact of Wisconsin jury
First number
selection to
that
pick
I'm
the
pulling
alternates.
out is
Yeah, in Florida, the alternates are designated at the jury selection. So they pick the jury and then you pick the alternates. So you know who the alternates are from the beginning.
the
Right.
second
This is
number.
very unusual. I didn't know this was done, but it's actually kind of, I don't mind this. This is an interesting curveball.
And the third number I am pulling out is 1.
It's kind of like you want to win the lottery
wanna
or something. Like
confirm.
I'm like, bingo.
Well, I know Madam Clerk did it, but I will also do that to be sure.
The best thing about your chat, I gotta say, the Rumble chat is the mosh pit of the whole thing. They need to get that replay because the chatters are the half the fun of your stream. You know that?
Oh, I know. It
That's
weirds
gotta
me
be.
out.
That's number one.
There's so many shows out there that like don't care about chats at all. Like they don't care about the chat interaction. And I'm like,
But that's the joy of the internet. That's the
why
whole
you're
essence
live.
of why you're here. You know, you get to watch the freaking TV set and the cable TV. Who cares about them? The whole fun of it is you get the interaction between the chat and the people and the whole thing.
Dude, I love it.
Yeah.
I love it.
Make a record of that.
Mario Carter
Alright,
says
then-
Brooke Honda forever.
I will need all of the deputies and civilian bailiffs to come up and be sworn on the record.
By
For
the way, to the
sequestration
chat,
and-
we have hit over 5,000 supporters on locals. And that first, it was actually about 5,113 by the time I got to it. That first group of people, they all get an exclusive
Clerk report, Todd,
Rekieta
why don't you
Law
join them
gift.
just in
I'm
case
working
you're
on
needed?
getting it all finalized. I will keep people updated as the steps to it are done. This thing will never be offered again for sale or otherwise. It's just
All right,
for
would you
them.
all please raise
And we're
your
going to do it
right
again
hand.
at 10,000 with a new thing
Do you
too.
swear that you will keep
So,
all jurors
that's
on
the
this
next
trial
step.
together in some
The
private
locals,
and convenient place, and that you
locals
will not
chat
allow
is
any
best
person
chat,
to speak to
and
them
it's
or you
really a
speak to them
fantastic
yourself,
thing.
except to ask whether they have agreed on their verdict. and
You
that
know,
you will not
another master manipulator move.
person
Is what I
But-
just did.
their
No, by Brooks
verdict, they
is
have
that
to-
he is not showing his ass in front of the jury.
All right, and then
You know,
Madam
he
Clerk
is
will,
being the complete belligerent jerk that he is. And the jury comes in and he's all Mr. Like, I feel you. I feel you. You got to feel me.
paperwork.
What a master. This guy should, you know, he should open a law chat channel
all of them
and
are
a
informed.
online discussion on how to be a master abuser and manipulator. Because this guy has every freaking tool in the book.
And no, it's not an NFT chat. What is wrong with you? What kind of horrible person do you think I am? An NFT? No,
Here
no.
are
It
the jury
will be a
instructions.
physical thing.
Well,
I just have to get it organized.
For the record, 6:24.
I'm just waiting on responses right
All
now.
rise for the jury as they're excused to begin their deliberations.
Oh my God. Thank God. This case
Yes.
is going to the jury. Woohoo. I'm going to go get another refill, but I'm not going to finish it until you tell me we're on the exit path. All right.
Okay.
All right. Hold on
Okay.
a second.
And guys, I'm not 100% sure how I'm doing the jury watch or the verdict watch because I would like to spend a few minutes with my family today. So we'll see how that goes. Trying to figure out how I'll know when it's back.
Is that closed?
we would
All right. Thank you.
couple
You may be
options: leave the
seated.
stream running and
Just so
sit
the
here,
record
which
is clear, the alternates, of course, will not be participating in the
worry about.
deliberations. They will be in a separate jury deliberation
the other
room.
thing to do would be
Um,
to start
and
up a
will
new
only be
stream
called
when it
upon
happens.
if
Not
needed.
sure yet what I'm going to do.
After consultation with the parties. As far as how late, I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner.
So I'm working late tonight, all right?
Anything else the parties would want me to address at this moment from the state? Anything from you, sir?
Yep.
Telling your wife you're working late, huh?
Did you hear that?
Yeah.
Oh my God, this
I won't
microphone.
tell you. I won't
don't-
tell her your secret that you're
don't
actually
tell
just on a
anybody.
stream shit posting through the evening.
I'm sorry, I
Holiday.
should
I
shut the
don't-
mic off.
So here's what could happen though,
It's
sir.
shower day.
I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that
What did
they
he
have a
ask?
protocol in place. And
He wants to go
that's what
take
they
a shower. It's
like
shower
to do
day
as
for his
well, okay?
pod in prison.
And one more thing.
Go ahead.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How
You could have
essentially,
called
how
all
are
61 of them.
charges able
That
to
was
be
your right.
charged
You
if
didn't call any of
all
them.
the injured parties did not
It
testify?
does not have to be. They don't have to testify. It can be proven
my
by
perspective,
extrinsic
sir,
evidence.
The state
But he could have
presented
subpoenaed
their
every
theory
one
of
of
the
them.
case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law.
And he never asked for a
and-
judgment of acquittal motion, which would have tested that
Because that's
at
all
the
that
close
he
of the
would say
state's
about it
evidence.
at this
So
point.
he lost that
I have a
issue
point, though.
already.
I'm sorry.
I got a point though.
No, you don't.
No.
I'm not going to comment on that, sir.
Bring it up in
She
your
can't even take it
appeals.
Of
anymore.
course, the state.
Bring it up your appeal, buddy.
And they have to convince a jury beyond a reasonable doubt.
Game over, buddy.
Better for
Jury's
sir,
deliberating.
I was not
Suck it.
presented with any motions to dismiss, either at the end of the state's case or the close of the evidence.
She gave
regarding
you
any
every
legal arguments
opportunity.
you may have
She
had
begged you
regarding
to
those
file a motion to
issues.
dismiss at the end of the
Um,
state's case. You would have
And
lost it.
so at this point,
But she sat there. Do you have anything you want to ask
the
the
jury
court?
has the case.
Anything you want to
They
do?
will
Is there anything you want to
determine
do before
their
you start?
verdicts. If
What do you
there
mean?
are
What you
issues
Doesn't
mean? What
matter.
you mean?
that you want
Even if you'd filed that
after
motion,
the
it would have
verdicts
been
are
done. So
received.
No, I know, but she just gave
Um,
him the time to file, and he
then
he's
just
an
we'll
idiot.
have to
He's
make
just
that.
an idiot. He doesn't know
Yeah,
what he's doing.
that has to be raised because essentially you can't. If no injured party testifies, then there shouldn't be a charge.
I
Wrong.
disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact. So
Bye.
for you to comment any further would require me.
Why
to
is
give
she
an
engaging
advisory
him? Well,
opinion
she
on
loves this bickering.
what to do.
So you saying I need to make a motion?
So
No,
what I
no.
will
No, too
say
late,
at
buddy.
this point,
Why is she
I
engaging
do
him?
have one issue that I would like.
Okay,
to
court's
raise with
adjourned until the
parties.
jury comes back. Bye.
I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. and I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of
Okay,
that.
women of the world,
If you can
pay
hold tight
attention.
and stay with us for a little
Do
bit.
not, because somebody is
great,
an
and I'll
arrogant
confer,
SOB,
with the Sheriff's Department.
your job is not to mollify them.
Shortly, okay?
Ignore them,
Get my
move
files.
on, escape. Don't
You
engage.
want the
If you engage with these
Um,
jerkos,
you want
they
the
will monopolize your time and they will divert your attention from the good men of the world who are there to help you and to love you. Whereas this person is seeking to abuse you. Your job is not to make this person believe you. She's playing this guy like she's some kind of,
Also,
this is some sort of dysfunctional relationship.
sure, I scanned it.
Stop it.
It has a document.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you. See,
I'm sorry.
I said, see, I didn't interrupt you.
Thank you. I appreciate that. Unless I would like the parties back in about a half an hour. Thank you. Unless they have a question sooner.
Just take him outside with a water hose and hose
Your
him
Honor,
off.
do I have to go in that holding cell, or do I got to get to go?
What holding cell do I get?
Thank God. Well, the only 2 notes that I have are apprende findings of fact by the jury. That's actually, and the other one's disparaging defense, but that was a stupid objection. But they could have objected there, but who cares? But we do want to get into findings of fact by the jury. But as far as law goes, we can get into that. But your show, my buddy.
Hold on just a second. I actually just got an update from the person I'm reading right now. Let's see. Okay. All right. That's good. Things are moving along. Things are moving along on the 5,000 subscriber gift. Unfortunately, I do have to say that, sourcing and manufacturing will take a little bit of time, but I will keep people updated as we go, and that will be done in the open. But you guys know about it. I've posted about it on Locals. I have not posted what it is. Once we get things lined up, I'll decide whether I will leave it a surprise or if we'll talk about it more. But it is in the works. Not in the works like a lot of the stuff where I have an idea that I never ever do. In the works, like it's actually in the works. Okay.
Actually, in reality.
Yeah, actually really going to happen. Raceland 9000 says, how woke is this judge and how differently would she treat an Alex Jones? Impossible to say. Impossible to say how she would treat an Alex Jones. You'd hope with a sense of justice. And I know a lot of people don't like Alex Jones. I'm not fully convinced that Alex Jones received justice, which is unfortunate.
He's entertaining. He has a right to free speech. He's becoming the target because he speaks out. He becomes the target. He didn't shoot anybody in Sandy Hook.
Exactly.
And it's
exactly.
like, but people looking for a scapegoat. And it's like, he's just commenting. He's just talking, free speech is a thing. I'm just,
it really is.
I don't know. I mean, I don't agree with like half of what Alex Jones says. Sometimes he's great and coherent, and sometimes he's freaking insane. But the left picked on him intentionally, targeted him because he has got these crazy UFO Sasquatch theories, and therefore he becomes. It's like, well, if you as a conservative defend him, then you're a conspiracy crazy Sasquatch person. So they used him as a test target, and he went down because the conservatives didn't step up and defend him, and now we're all at risk. So I defend Alex Jones' free speech to be as crazy as he wants to be and to say whatever he wants, and because it protects us all from tyranny.
D. Hirsch says it better not be a fucking t-shirt. It's not a t-shirt. No, it's not a t-shirt.
What is it? What is
no,
it?
the 5,000 local supporters gift. is not a t-shirt. Don't worry. Oh, and just so everybody knows, I did get this question in the chat, and not going to talk about the locals thing too much more, but someone said, will the 10,000 at the 10,000, will the 5,000 people get it? Whoever is active at the time I hit the milestones, that's who gets the gift. That's what happens. So the people who are active at when it crossed that 5,000 number, they get this. If you're still active at 10,000, which I hope everybody will want to still be in the chat at 10,000, you will also receive the new 10,000 thing. And I'm going to make each milestone that we get to, and whatever I decide they are, those will all be unique things. So that will not be available ever for anyone else. Fair and Balanced says, you do karaoke, and Megan Fox and I do not get a call. What kind of friendship is this, you degenerate? Megan and I deserve better. I don't know if you really wanted me to call you at 4 a.m. while smashed out of my mind to say, by the way, I'm singing like 3 lines from every song I've ever heard from the 90s. Do you want to join me?
I'm 24 hours behind you, buddy.
Let's see. Ray Note says Fox 9 has a smaller bug. Okay. Disband the EU says no fats allowed. Blue Fire 3, what a bunch of cucks. They bottled their numbers after getting salty that you've been kicking their ass this whole trial in terms of views and quality. Well, look, they have a significant advantage over on YouTube in that they have the entire world's audience to choose from. Whereas Rumble, we're not there yet. We're going to get there.
May I suggest that once you get past the 90 days on all 3 of your strikes, that you could live stream and risk an extra strike. Not that I'm ever going to go on that other channel that's not Rumble, because as solidarity to Mr. Nick Rekieta, I am exclusively Rumble because I'm just a new content creator. But I would say that you could go back on there as a live stream when the 90 days is gone on all 3 strikes, wouldn't you say?
It's a possibility. I'm not into it right now, but things can change. For now, I'm still bitter.
I'm with you. I will, because in solidarity, because you have sold more books for me than you have made my books basically in the black, so that I don't have to spend money out of my pocket. Thank you, God. But because of that, I will say that I'm only going to be rumbling.
Let's see. Oh, here we go. And I do actually have a YouTube video that is going to get released in just a little bit. But I've told the full story of YouTube deleting my channel and how it comes back. And it's the full thing, and then kind of what the game plan is for now. So I am, like I said, still posting content to YouTube. It'll just be, for now, it's going to be the sanitized content that and not live at present. So you guys can check that out. It'll probably go live. I just have to make sure I have to change 1 or 2 things and make sure the tags are set and all that stuff. But it'll go live probably when we wrap up this stream.
See, and I gotta say, as a participant in your afternoon live streams or whatever this is called, I don't hear anything that you're saying that is out of line. Now, maybe I'm delusional, but I mean, I'm like listening to you. I'm like saying nothing that you're saying is subject to any kind of problems.
There we go. Not subject to terms of service. I'll agree. Just some of the things I say, are they out of line? Yes.
I mean, your night show is different, and I can't handle your night show because you killed me on that interview we did. Boy, I was out for like a week for that like 5.5 hour night show shit. But on this one, I would say, but this afternoon stuff, I don't see. Have you said anything that's out of line? I don't get it.
No, I haven't. And I could certainly have done this stream on YouTube. But my problem is, if I put it on YouTube, people will send me super chats through YouTube, and YouTube takes 30% of that. And I'm not really a big fan of giving YouTube any more money. Steve, I gave YouTube, through the super chats generated on my channel, their cut about $400 to $450,000
Mm.
that I made for YouTube. And it's different than advertising, because advertising dollars are guaranteed money from the advertiser. So the advertiser says, we want this many views on our ad. And then YouTube will make that happen. They'll distribute within their demographic guidelines and their geographic guidelines, and they will make that happen. And I even think that YouTube will recommend videos to get up to that view count. I saw that during the 2020 election stuff, when Republican content went through the roof, and that's because Trump and the RNC had massive YouTube ad buys. And so any of the content relating to that was pushed way up. And it continued through the election because of the controversy afterwards, where the Trump campaign was still spending money on advertising for the election fraud that they were alleging. And so that content it got, every video I put out was 100,000 views minimum at a time when it was really hard for my channel to get that many views. So they make their ad money in advance. And it doesn't matter what content is on the platform. They will deliver an ad through some content to make it happen, even if it's just cat videos. But super chats are different. Super chats depend entirely on the live streamer, the audience wanting to participate in the show that's there. So if I take my show away from YouTube, that is me taking away potentially millions of dollars over the course of the year.
Super chat things are, you get a better percentage than the YouTube super chats, right? Isn't that true?
Yep. On YouTube, I'd get 70%. On Rumble, I get 80.
Okay, so you much prefer.
And on locals, I get 90.
Hey.
But yeah, so but that's the thing. I mean,
but the thing is that it's completely dependent on your content provider. So when you provide the super chat, people are given to you. They're not given to Rumble or given to YouTube. Sorry, I said the word.
No, you can say YouTube. I don't care.
I know, I don't say those words. But the thing is that when you give to Rumble, I mean, you have the forum, but really the reason the people are given to you, they're not giving it to it because of the forum. That's my point.
No, and that's why that's my biggest hesitation with streaming on YouTube at all, is that I'm then giving them a cut that I don't believe they deserve. If they don't want to have my live content, which they've clearly expressed that they have a problem with how I do live content, and if they don't want to have that, then I don't want to provide it for them. I'm happy to let people not do business with me.
Well, like my book on Amazon, which people are saying, can I buy it on Amazon? First of all, my book is very, very specialized. It's focused only on law and people that are interested in law and people that want to support me. So the issue of people that want to buy my book, it's a very narrow segment of the world that wants to do that. Well, Amazon, they're saying, well, why don't you put it on Amazon? Because Amazon wants to take like 80% of the money. It's like I did the cover, I did the layout, I did all the writing, all the content. And YouTube and freaking Amazon wants to take everything and give me a pittance for all the efforts of my life that I've poured into my book. I'm like, why should I do that? It's insane. I'm not giving them my money. Now it's like, look, okay, I understand that I'm not going to have mass appeal, but there's only a limited number of people that are going to buy my book anyway, right? And those are the people I care about, the people that really care about what me and what I have to say and about the law. And that's a very narrow people, but I'm not going to give Amazon.
And we only like narrow people really around here.
No, that's
no fats allowed. Just kidding.
Okay. Back to you, my friend.
Speaking of back to me, look, guys, you know what time it is. It's time for you to reassess your IRA and 401k with help from the Birch Gold Group. That's right. birchgold.com/knows. It'll take you to this website. That's what this page is. This isn't a special page. This is the same page you see. And it has these two juicy buttons, green buttons. And you love pushing a juicy button, chat. I know you do, especially when I mention Peter Tragos. But you can go ahead and push this juicy button right here and get information from the Birch Gold Group on how gold and silver might help you protect and preserve your IRA or 401k. Those retirement assets are things you've worked your entire life for, and they are subject to the whimsy of a dementia-riddled president. They're subject to the whimsy of foreign oligarchs. They're subject to all sorts of volatility in the market, not to mention rampant inflation. And the only thing going up higher than inflation under Joe Biden is children's hair into his nostrils, which is disgusting. Gold and silver have acted historically as a hedge against things like inflation and a damper to market volatility. And they may be right for your retirement account, or Birch Gold Group also will just sell you some outside of a retirement account if you want. They'll ship it to you and everything. You can check it out, but don't listen to me about it. I'm just a humble ad merchant. They're the gold merchants, and you click on this button and it will take you to a page, and they'll get in contact with you very quickly to tell you about it. And if it's the right move, you can make that decision for you. Listen, they have never once, despite all of these ads that are just terrible and full of horrific jokes, sometimes they have never once emailed me and said, hey, can you not say like a Holocaust joke or whatever? They've never said anything like that ever. They fully seem to support free speech. When Montegraph even called them and was like, I want to complain to the manager, they're like, yeah, we don't care. Do you want to buy some gold? Because they're a business that does business, and I can jive with that. I can jive with that.
And your click through is information only, but
yes.
And I'll say that as a public servant and as a public employee, my IRA under Joe Biden has lost 25% of its value. Now, thankfully, I have 15 more years to go before I have to retire. But that there is an investment strategy that 10% of your IRA should be in something like gold or silver, because it's theoretical that you could lose everything, and there is some security in that. So I really should. My wife and I talked about a year ago when Biden took office that we should shift everything over to gold, because we're conservatives and we don't believe in brash decisions, and we let it ride, and we lost 25% of our money in the stinking market. So maybe we need to move over 10%, at least 10% over to something that at least has some residual value, because it could get zeroed out.
Yeah, absolutely. And I say I'm not a gold merchant. I'm not, but I've worked in the world of finance for a long time. Oh shit. Oh, they ended their live stream. Okay. Gotcha.
Who's they?
Long Crime ended their live stream.
I was on Legal Vices, for the morning.
Yeah.
Yeah, he's cool, man. I've never been on Legal Vices show, but can I have your blessing to go on Legal Vices?
Of course.
Okay.
Go on. You don't need my blessing for anything. Go on whatever show you want to go on.
No. I do because I owe you and Andrew a lot. So I am firmly committed. I don't believe in betraying the people that have blessed me with their, and I am definitely on Team Rekieta and Team Bronca.
Okay, so I was wrong. I didn't end the Law and Crime channel. The Law and Crime did not end their stream. The other TMJ4 did, the Milwaukee Journal. They ended their stream, and I got confused when I looked at my tabs. That was my bad.
I do like Legal Vices. He's funny.
Yeah, I like Jeff a lot. He's awesome. Space Allen says, here's some interaction, Nick. Oh, thank you. Thank you. Go for Big Guy 911 says, you got us Baldos, didn't you? You sick fuck. I'll take mine in black. Always wanted black. If we were doing Baldos, I would give they'd be custom green. They only come in black and pink, but they'd be custom green, and they would be engraved with a nice ridged Rekieta Law logo, just for your pleasure.
Yeah, Vices is off, by the way. He's done with his stream, because
that man needed to go to sleep.
He needs to go to sleep. So we are bringing in the people that used to be with Vices, but I respect Vices a lot. I like him a lot, but I still have my loyalty to Bronca and Rekieta. But just wanted to let you know that I was
You're
over
gonna
there.
you're gonna get me in trouble for having a loyalty test
Because-
that I don't have.
No, but there are some people that are broadcasting that are betraying you and going over to legal bites. I will just tell you.
Oh my goodness. No,
I'm
they're
just-
okay. And they can go on legal bites all day. It will
No,
never
no.
bother me. Will
It
never
bothers
bother
me as a loyal follower of the Pope.
It bother you all day. I am being very clear on the record on this. I do not care who anybody streams with.
But I'm a
They're welcome to
representative
do
of the
that.
chat, and I care. So there you go.
Okay. Highland Lass 24 says my fee for Darrell Brooks's masterclass in what not to do in court. Oh my goodness. By the way, guys, Ryan, the editor, has offered to say, has said he would keep the stream running, and we would wait for the jury verdict to just come back, and he would let me know if it came back, where that way I could step away, but the stream would stay running. We'll see. I've got a bunch of chats to read still before that happens, but that might be a possibility because we're on Rumble and I don't have to worry about an automatic copyright hit having blank footage playing, just sitting there waiting for the jury to come back. So we might do that. Not sure what the answer is, but we'll see. Got to get through the chats first. D Hirsch says enough pontification. In other words, shut the fuck up. Red 1777. This bitch of a judge is the best defense Brooks has had in this trial. I bet she takes it up the ass. Whoa, my goodness.
That's good. That's a positive, though, isn't it?
Yep.
I'm just saying.
Oh man. Steve, why are you even a real person? Darby 424 says she is more responsible for delaying the trial than Darrell Brooks. That is true. I hurt so much.
I got you on that one there. I tell you.
I'm dying. Like I need to have you ever seen when like a group of black people watch David Blaine do a magic trick or Chris Angel?
No.
Okay, there's this phenomenon of, and look, I'm not a racist. I'm just a casual observer. There's a phenomenon amongst groups of black people where when something blows their mind, either a great joke or an amazing magic trick, they all like cover their mouths, go, oh, and run away. Like they scatter to the winds and then recongregate back where they started like a yo-yo. And it's amazing. That's what it took as a black man myself. It took everything in my being to not flee my desk when you said that. I'm like, oh.
Well, I love what's the guy that's the street magician.
Yeah, well, Chris Angel and David Blaine, both of them.
Well, Blaine is great. Angel's kind of ridiculous, but David Blaine is amazing.
Yeah, they're both. He's really cool. Well, I mean, cool. Like I do magic, so I'm cool and everything. Look, I'm just gonna casually shove this motorcycle spoke through my hand. Don't worry about it.
Right?
I'm
Yeah,
David
he's
Blaine.
crazy.
Oh, it's no big deal.
Yes.
Well, here's my eyeball. Here you go. I don't like his demeanor so much, but yeah, he's nailed his presentation.
Yeah.
Second Amendment or Die says this judge writes book about a trip to Walmart. The book longer than the Silmarillion.
Oh, great.
Let's see. Oh shit. Okay. Here you go.
See, occasionally people get my sense of humor. See, the thing is my sense of humor, it's so dark and evil that most people take it wrong. So they're like, I can't believe he said that. But it comes from the darkest depths of Mordor.
The liquor is like a fishing line reeling it out of you. Oh my God. Second Amendment or Die. Wait, I read that one. Hans Gruber says, will he spin that objection sign? That'd be good. Horror Amarada. The exchanges between Darrell and the judge seriously give me anxiety. I just want her to make him shut up. She doesn't like on one hand, she doesn't have the tools to force him to shut up, but she could use the tools of just power.
Well, and women of the world need to pay attention to this, because this is exactly the kind of poisonous dynamic that goes on in relationships, because women get enthralled and entrapped by this kind of narcissistic personality. And this kind of person is evil and wrong. And this kind of but they dominate, because it's like, they get enraptured by it. It really is a male female dynamic, and she's like engaged in him, and now he's dominating her, and she's fully, and like all her attention is focused on this jerko, and he doesn't deserve it. There's good men out there who will give you respect, who will love you, but that don't demand this kind of domineering. But because you're all focused on this guy, you're missing the good man that's out there who's not doing this kind of game. I mean, as a single woman out there, if anybody's watching, this is a lesson in how you need to avoid this kind of domineering man. Right? I mean, I don't know if it's kind of a strange point.
No,
but
it's true though, because you find over and over that abusers end up in a shocking amount of relationships.
Right.
And you always wonder why, like how, and I don't know what the reason how is, but
then his closing argument, he's abusing, and she's engaging with him, and he's been abused by him. And then at the end, he comes across and he's like, oh, and he cries, and he's so sympathetic, and it's like, oh my God, oh, let's just make up. And then she makes love to him, and then they have a baby, and now you're connected to this jerko. And a mature woman will see this guy for what he is. But younger women see this as some kind of dominant male. This is not a dominant male. This is a pathological male. So there's a lesson here for women, for good women, to avoid this kind of man. This is not a dominant man. This is an evil man. They need to pay attention to the man that's going to treat him with respect. I don't know. It's a strange lesson to come out of this trial, but it's very true and pathological in our society. I mean, what do you think, Nick?
No, it's I think you're 100% right. And that I think is what so a lot of the comments in the chat, some people might say are misogynistic or whatever. I mean, I know the internet, so of course people say that, but it was a demonstration in real time of this thing where this judge has all of the power in this dynamic, and yet refused consistently to exercise it, and allowed him to use his abusive personality to control all of the engagement. And it was really, really strange to see.
It was
to the point where
really strange going on here. I mean, it was and you see even the prosecutor there stepped in at the end of the closing argument and said, let me interrupt this pathological feedback loop and try to short circuit it, because she saw it, that it's like, and that's what happens. A lot of male female relationships, you get this pathological male, and this woman is pathological because she's enabling it and engaging in it, and she's enthralled by it and trying to, like, if I can just explain to him, all her attention is focused on this pathological male. Her attention is valuable. Her attention is what men seek. And she needs to focus that attention on a good man, not on an evil, pathological, manipulative man like this guy. But yet her whole life is focused on this guy. Tell him to go to hell and focus on the guy that's going to treat you right and going to be a good man and a good father to your children. I mean, it's a weird point to be making in a jury trial on murder, but it's damn well applicable and if there's any young woman that's watching this, they need to be aware of this danger.
Yep, absolutely. Absolutely. And yes, Amber Heard had similar behavior. That's true. Of course, there are plenty of women out there who exhibit the same sort of manipulation. And that was probably part of Johnny Depp's problem, is that for whatever reason, he would give in to that abusive behavior.
Well, and that's the reverse. I mean, there's the male. I'm looking at the evil pathological man, and then the women who see that as strength because they're looking for the alpha male. And they're seeing this guy as being dominant and being aggressive and being the alpha male. He is not an alpha male. He is a pathological, psychological psychopath. the strong man, like I am dangerous. I am dangerous. If I'm in a courtroom and you're on the other side, I am the most dangerous man you will ever know because I know what I'm doing and I am indisciplined, right? I'm a dangerous man, but I have control of my focus. I have control of my intellect. I have control of what I'm doing. And that's the man that you want, somebody who uses their discipline and their knowledge and everything that they have for good, not for evil, not for self-centered reasons, for something greater. That's the point. I don't know. I don't know if I'm 2 or 3 in, and I'm on number 4 or 3 or whatever the hell
You're
it
on
is,
4.
Okay,
I guarantee you're on 4.
But I will just say that there's a lesson. There's a greater lesson here for women and men.
Absolutely. Hans Gruber says, objection, Your Honor. The prosecution is ugly. Workshop Express. Check out my new YouTube and Rumble channel, The Dashboard, for high quality dash cam and other automotive content. That sounds cool. Depends on where you drive, I guess. If you drive through a gay pride parade, that would not be a good content at all. That'd be very horrifying and you'll get banned. Outcast77 says, God bless you. Blue Varo says, how is the hangover, Nick? I was fine because I slept until 1:30.
Everybody was saying over on Legal Vices, we were talking, and everybody's like, where's Nick? And they said he's been knocked out by his ridiculous stream that he did the night before. And I'm like this thing, and thank God that Nick is getting some sleep. I always think about you. I'm like, I pray for you to get sleep, man. I mean, you work more than you're the hardest working man on LawTube, aren't you? Or I'm sorry, I said the word.
I don't know. I know that I set a goal a long time ago, and it's probably a bad goal, but I said I will make more content than anyone can reasonably watch. So I had to put the reasonably in there because someone always will.
Right.
But
that's a lawyer word.
Yeah. But no, it's I don't know. I've found a way to marry my pleasure with my employment. And so I don't know why I wouldn't do it as much as possible. But last night got a little.
I gotta go. I'm going to go back and watch this because I'm going to go back and watch it.
It wasn't here on Rumble. It was on Twitch, but I'll send you a link if you want.
I would love to watch this because I've heard it's like the epic of the most Nick Rekieta epic zone of ever. The last half hour.
You're talking about a completely different stream.
Okay, well, explain this to me. Explain to me what I'm missing.
So that was the other night where I went. That was with Andrew. Bronca was on, and I saw
a lot of that. I watched a lot of that actually.
After he left, things got interesting because I got. Well, I can't tell you the full details, Steve. I can just tell you that I was in a mood that night. We'll say I'd had a mood to deal with. And then I had a couple drinks and I said to ask me anything to the chat. And they asked some questions that led to me expressing some things that I might not have otherwise said if it wasn't the magical combination of a mood, of liquor, and of a mood and liquor. That's it.
I'm going to watch that. I'm going to watch that back. So it's the last half hour of the Bronca.
Watch it with headphones and not in public.
I will,
because
I will do so.
The language got elevated and not in the academic way.
Okay. So
but
that's my homework for tonight. Because after tonight, this jury comes back. I may be off for quite a while. I mean, I have my Rumble channel, but this is
I may have said the words, I will shove the cock of freedom so far down your throat that you'll have to vomit to taste my semen. That might have come out. And that might have been one of the more tame things I said. But speaking of untamed things, welcome to the stream, Uncivil Law. How you doing, buddy?
How's it going?
Pretty good, man. Pretty good.
How many drinks have you had?
Some number of drinks.
I heard you were 13 deep earlier.
Yeah. I think we're at like 17 or 18 now.
How are you alive?
Yeah, it's a coffee liqueur, so it's not super
okay,
heavy,
so it's not as bad.
What is it you're drinking?
I'm drinking a coffee liqueur. In this case, it's Kova coffee liqueur.
That's what like 33%, 66 proof?
Something like that, yeah.
Every time Uncivil
tend to
Law
hover
comes on,
around
I
there.
feel like all of a sudden I gotta get my act together because he's like he's that intimidating lawyer that knows all of what he's doing.
Ooh, I like it. I like it.
Yeah.
Okay, what I'm doing, so I'm reading chats, and then I think I might step away. Oh, wait, what?
Oh, I need my court reporter. I'll wait for her.
Uh-oh.
Oh, she's all smiley. Look at her.
Oh, jury has
She's
a
gonna-
verdict, baby.
I don't
Thank you. All right,
I
at
don't
7:05,
think so.
we're back on the
No
record.
way.
I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email.
You're gonna address that Reddit post. If you even address that Reddit post, I'm gonna punch you in the neck.
The person sending the email had found a post on Justice for Darrell on Reddit. So
Yeah.
it's
Oh,
Reddit.
she's
I'm not
doing
sure
it.
how Reddit works, but and that the thread on the Justice for Darrell Reddit site was claiming to be a member
Let me kick you guys out.
of the jury pool. And I am going to provide the parties with the information that I was
I'll try the
given
other fix too.
this morning. It's a color copy of the attachment and the email.
StreamYard
was
is being
sent.
ridiculous lately with the echoes.
The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification
that should-
at
hopefully
9:30
that'll fix the
a.m.
echo.
That the clerk of court wanted to
Can
speak.
you hear me?
with
Check.
me. You may recall this morning I stepped off
This
the
is
bench.
stupid. She's
little
letting the world internet troll people.
Information that was
infect her
provided to me,
trial.
which was
This is
an
ridiculous.
email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case. And here are my thoughts on the trial.
Unbelievable.
On this subreddit.
This is terrible. This judge
Apparently,
is just
again,
out of
it's a
control.
subreddit.
Bad.
Called Justice for Darrell. All those Justice, the number 4, and Darrell, all no spaces. I then
Jack Flack
had
says,
contact
"Where are
with,
you hiding legal
Captain
mindset?"
Dussault,
He's on his channel. Or
advised
he
him
was
that
on his
it
channel
should be
earlier.
investigated, and basically turned over
his
the
Rumble
matter
channel.
to law enforcement for a full investigation.
I gave him a big super chat.
At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions.
This
to
is the
jury
dumbest thing I've ever seen in my
arguments,
life.
and then turning the case.
She is
over
responding to some stupid internet
court
channel
deliberations.
in this case.
And
Why is she doing this?
of
This
course,
is
I
insane.
am
Why is
concerned
she
about
putting this in the
integrity of
record?
these proceedings, and
I mean, there's
will
some chance, right? I mean,
an
I think she kind of
appropriate
has to some degree.
No, she does not. Stay away from it.
is done.
If it exists, it
But at this
exists.
point, there
She's
is
now putting it in the
no-
appellate record that there's
I would
some
say
kind of
credible information that this is in fact a
This is
member of
crazy.
the jury.
There's no
But
credible
I will leave that
information.
for law enforcement to determine, and of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted.
There's no warranted
So
questioning.
that's the information I
look at
wanted to
him.
provide. Again, copies of this information will be provided to the parties. And
This winds up in some sort of mistrial. I'm going to be a very unhappy camper.
I have no
They-
further
it
information
can't
about
because
it at this
it would
time.
be
I will
every
not be
trial. Every
the judge
trial
that
there'd be a
will
Reddit
further be
post.
reviewing it
forever.
in terms of any requests
Oh, we
related
gotta
to that
investigate every
investigation.
Reddit post. No,
I
you
will
don't.
simply be
It's
handling whether
nonsense.
any
One
request as
read
relates
of that
to
Reddit
this
post
case
tells you
in
that this is
particular.
bullshit.
we went through
I
this,
hope
Kurt.
we have the copies.
Nick and I went through this like about an hour or two
Provide
ago.
those. Go ahead.
And it's just trolling by some random person. It's garbage. And now she's putting this into this trial record. Why is she
All I
doing
can
this?
tell you, sir,
Week.
is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a
Oh,
subreddit
at least the judge doesn't know what Reddit is.
that is entitled Justice for Darrell. And
Oh.
it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors.
On the
which is
post,
why I
they claim
turned
their man
over
inside
the
got booted to
information
alt.
to law enforcement
Yeah,
so they
it's
could
all
make
fake,
a full
though.
and
It's
complete
all
investigation.
fake.
For the record, I accept for value and return for value these documents.
Oh Lord, have mercy in
I'm
heaven.
confused.
We know you're confused. It
At
seems
this point,
unfair,
sir, I'm
Your Honor.
providing the information. I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this, I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Let me go dig up this thing.
It's so stupid.
Was
We
this
covered it
just
earlier.
found out
but it's-
about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second, I will say I'm aware of a second email.
Why
that
is she doing
to
this?
our clerk of court at
Oh,
10.
look, Mr. Brooks,
I mean,
here's some
I guess she
information
has
that
to put it up on the record.
no,
but
she does not. This is absurd.
And
She is
any-
insane.
I think they're.
I'm losing
stepped
respect.
off
I was
and,
at low
following
at the
the
beginning. I
case
went
being
up,
given
and
to
now
the
I'm
jury.
just
I was advised
ugh.
that other emails had been received
Terrible.
throughout the court system. And I simply said, obviously, that information needs to go to law enforcement.
She thinks that he's a good actor, that he's
But
actually
any
listening to what she's saying. She's
Person who works in
delusional.
the clerk of court's office who has received an email will be.
He's as
that email
pathological as he is.
topic will be forwarded to the sheriff's department. Their forensic unit is handling the investigation, to my understanding.
Okay, Danconia Copper in Wisconsin accent.
Yes, Your Honor, I
Don't-
just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against.
These people don't know how to internet. I could smell this troll
Thank
from
you. I
a
appreciate
bridge
the
away.
additional record.
Can I say something, Your Honor?
Go ahead.
No.
Oh, ugh.
I think this means
Just
I'm free.
briefly skimming through it.
I think it's true.
I do want to state for the record that I have no involvement with this.
We
Good.
believe that.
Really like shocked like this even came to light.
Came to light. Okay, you're losing me now.
I will say
Yeah, it was written
Just
better
by
than
skimming
we would
through
think
it.
you would do it, frankly.
I suppose if there's a mistrial, it means I get to grift off the whole thing again.
Talked about in the court, so we'll have to. I mean, common sense would say that this came from someone that has either been in the court to hear what goes on in the court, or a jury member. There's no other way.
Why? The entire trial's been broadcast. What could a juror possibly say that I couldn't say?
You'd say it.
right?
Kurt, go.
Well,
How would you authenticate
Well-
yourself?
it's pretty obvious that this would come from somebody who's actually
No, not at all, buddy. Literally anybody
Seems
could
pretty
write
clear.
that.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there
This is so
It
stupid.
should
Were
have
to
never
be
come into the
procedure
record.
This is so
I mean,
violated the rules,
silly.
I would take that very
What a waste of
seriously,
time.
and I will not hesitate to take
See,
any
'cause
action that
she
I deem
took the bait.
appropriate. At this time,
If they had never
Exactly.
read this
simply
into
being
the record,
investigated. This
he
was
would
an
have brought it
anonymous
up.
post,
That's what would have happened.
and
Well, what
if
about
either
this
party believes
post? What
She's
what about-
feeding him.
action
She's feeding him
to
stuff.
take place as it relates
Oh,
to this particular
this is
jury,
just so
then I will
terrible.
file the appropriate request with the court.
I'm not sure I agree with your reasoning, but maybe you could explain it in more detail.
Something else?
No,
Kurt?
I
I'm
tend to
like-
think the judge is pretty right here.
While we're
I'm
on
3
the
drinks
record,
in, so you're just gonna have to roll with it.
court's procedure,
I'm
but
18 drinks in.
We have no objection to any exhibits going back to the jury room if
Yeah, but
they
you're
are
not
asked
Steve.
for. And
I'm a lightweight.
the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
Well, I'm willing
Oh
to
my God.
discuss that. Do
Ugh,
you have any position on that, sir?
Yeah,
I object. I don't understand.
I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked.
Every exhibit in the record is
That's
relevant.
fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the
Stupid.
relevance
This
and
is
the
so
admission of the
stupid.
exhibits. The issue is whether
Holy
it's
cow.
to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in.
So in
the
Wisconsin,
complete
action says,
form.
don't you know
under
if you
the
drive your
statute,
car from the
really
bar,
maybe
you're going to
only a
end up
portion of
riding
it
far
would
with
go back
Officer
to the
Lars?
jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received.
Mario
And
Carter 13. I ran over dozens of people, but
jurors
they
can
dehumanized
ask
me
to
by calling me
view
a monster.
photographs,
We're not so different.
written
You and I.
documents, they can even ask to view the videos. The videos would need to be done one
Carts
of two
312
ways.
says she who must not be
Either
named
which
only has
requires
900 people
everyone to
watching their
assemble
stream. Lol.
because
And I
We
hope
do have the
that grows. I hope
technology
she has all
to
the
play them
success in the
directly
world.
to the jury room.
Thorium, Nick, you should look at what
But
happened to
that
Ureni Rios
Simultaneous
Gonzalez.
with that is it
Insanity.
would be played in here. So everyone would be seeing what's being played in the jury room at the same time. So that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No.
No.
Talking about a video, we have the ability to play it directly. There's a TV. I should have said that. Probably not to you. Why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury
Probably
room
from all of his other
that is
trials that he's had to
connected
go through.
to the technology in the courtroom. So whatever
Wayfaring
is
Broad
playing
says, didn't know it was a
here could be a
90-10
still
split here.
photograph,
Good
could
to
be a
know.
document,
This goes
could be
towards
a
my
video.
indulgences.
We
Pope.
can
Oh, indulge
play
away.
in the jury room
Indulge
at the
away.
same time.
Fought
But as far
and
as
was-
other
God,
exhibits,
And I read my Bible all the time. It saved my
So it
life
would
while
be only
reading
the
it when I was
exhibits that's
driving
been
in a parade.
received.
Darrell Brooks,
Received.
probably.
So nothing new, nothing's gonna come out of the blue and be like, yo, yeah, we're gonna.
only what's
No.
been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
I want an original
About like
copy of every exhibit.
7,500.
There's a lot of exhibits,
It's a
but
lot of exhibits.
but I'm willing to have her print it off. If
Is
you
it
would.
verified?
I think it'd be helpful just in case. I'm guessing
We know you're guessing.
at some point that will come into play.
Right. For example, they may come back and say, we'd like to see exhibit 15.
It's a sidecar,
which is the
either
map,
3 or 4. I'm not
a
sure.
large map of the parade route. Okay. They might want to see the other map.
Dark
Maybe
Fox
they wanna
11
look at a
says,
video.
close on my house on the 9th and we'll be closer to your
There's
place.
a lot of
just
exhibits,
north
so
of
I'm
you.
not going
No
to
more
guess
being a
speculate what they
renter.
want.
Cheers. Awesome. Congrats,
Sometimes
buddy.
they write notes to us and say they literally list out all the exhibits that they want. Other
Matt
times they'll
himself
say, we have all the
sent a
exhibits.
Facebook video.
So,
I think that's probably one of
Sometimes
Darrell's
parties
videos.
do stipulate. That's what the
Shocky
state,
Adam.
I think, was trying to
The
get
play
at.
of sympathy towards him, his family, is worse than irrelevant. He's
So,
trying to
do you
manipulate
have
the
a
jury into
position on
feeling
that?
guilt over imposing maximum penalties
if the
because of how the
jury
consequences might fall
requests
back
an
on the
exhibit,
family.
No, that's
You want the
100%
court to
true.
rule on it
The
individually,
manipulation here,
or
he's using everybody,
agree
his children,
that if they
his
request an exhibit,
family,
it can be
the
released.
Christianity, the Bible, everything is
Right, fair enough.
subservient to his ego. That's exactly what's going
Anything
on.
else, Attorney Opper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay. Thank you.
Some of that will depend on when it is, if it's late in the evening versus during the day. And you might be wondering, how late will I let
Okay.
that? We're done for
Okay.
the evening. They'll come
That was
back
weird.
in.
It wasn't a
read
loading
them
message pause.
the
That must have been
instruction about,
completely on their side.
They obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate.
She just is a talker, isn't she? She talks and
It would
talks and
go
talks.
Again, where they are being
Ugh.
sequestered, and then we would reassemble tomorrow.
Have on the
morning.
record here, Steve Gosney
That's
hates
what
when
it's-
women talk.
Okay.
Perfect.
Thank you.
You're welcome.
Well, I mean, there's a point at which
Yeah,
you got to shut the frick up.
talk to the judge, the deputies. Or
I did. Thank you for that reminder.
Oh,
the jail
Josh
Thank you.
said
316
I
says
follow
Steven
the
is
standard
based. Hope to see him
operating
more often in streams.
procedure, which is to
When he
have
has
you
time and
in
inclination,
central
he's
holding
welcome.
and not up at your cell. But if need be,
Retire
I'm
USA.
willing to.
U.S. Air Force
order that
Lieutenant
we
Colonel
do a
says,
shower
Nick, I
later.
really appreciate your sycophant Steve's analysis and commentary. Great stuff.
If
Have
that's
some more
helpful,
grift.
whether it be tonight or tomorrow morning. Okay. So even though you're
People
going to
say I talk too much. Do I talk too much, Nick?
make
You're
sure I'll
fine.
work with the jail.
Okay.
to make
You don't
sure
talk
that
too
you're
much.
given that
The judge
opportunity,
does.
after we're done for the night.
Yeah, I mean, compared to this woman, come on.
So I've been
And I will
told
have
there is
to-
a question that will be coming out shortly, so don't go anywhere.
It's a
Mars
question.
Lance
Don't choke me, Judge.
says, drunk Steve
What?
is hilarious.
Choke me.
Don't choke
Thank
me.
you.
Yeah, because you know what I'm about to say.
What?
What are you about to say?
Subject matter
Jurisdiction?
jurisdiction.
Subject matter jurisdiction.
Oh, yeah, I tailed it.
You knew I was about to say that.
You
Sir,
know it's
I'm not
hilarious.
interested, I already have. All right. There are requests for free exhibit.
What? Dude,
My
she
wife
filed
is
a
gonna-
written order on it and gave it
Yeah,
to you,
he's
and
not
you
bad.
tore it up.
Cold.
JPat1218 says, we need a 3-drink
Signature.
Gosney and no tie Bronca stream.
I'm down.
I need to know the
Left-handed
number
luck.
to tell.
The super chats
The
are like
parties to the
stripper dollars for
foreperson,
live
I'm not gonna
streams.
say the
Here's
name
some
of the
hoe
record.
bucks for your
They
rumble
have
pong,
a
Nick.
request for 3
Oh.
exhibits, 15,
Wiggle, wiggle.
5, and 55.
I still
only I
say
had a
I'm the
poll.
mosh pit. The
And
chat
number
is the
11 is
mosh pit of
forward.
Rekieta Law, and I'm in the mosh
Said
pit, man. I love the
15,
chatters, man.
55.
Alto Patones, tell Steve I just got his book.
So,
I want his
I can
signature.
pull-
I was gonna say I don't know. I know 15.
Maybe.
15 is the map.
15 is the map. Yeah.
Any
Jack
objections to the
Frost
map,
EC
sir?
says, thanks for making this nightmare watchable.
Yeah. I want you to rule on everything.
I mean, that is true. The fact
Oh,
is,
do I go
want
one
you
by one?
the
on
commentary in this
everything.
in this group
So I'll start with
makes
exhibit
this stuff watchable because this guy is
15, which the
intolerable.
map. What's your position on that, sir?
my position is
I don't understand.
at this point, what is the relevancy of the map? I think it's been seen a million times.
I
know
think it's
about
review
heart
evidence
now.
in the jury
That's
room.
probably the only one I know by heart.
Well, what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to
Dino
work through.
Klein says, Rekieta Law and
to
Steve,
assist
perhaps
them
the
in
judge is just going
identifying
above and
which
beyond to
victim
make
is
the
which
process
and which
appear
group they were
fair.
with
Oh,
and
yeah,
where
she's
they
been
were on
doing
the
that the
road.
whole trial.
Absolutely.
Above and beyond and beyond.
It's helpful to them in their deliberation.
I don't know if you've seen recent news headlines about his opening statement. His crying
Right, I
is supposed to
will,
when compared to
send
Rittenhouse,
Exhibit
crying when
15
testifying.
back.
Perhaps that's playing a factor.
To the jury
Um,
room. It is an exhibit.
Yeah, I mean,
And there really is
I don't know
no
if the headline
reason
is playing
not
anything,
to
or she's
send it
doing a
back
full
that has
trial.
been identified by the parties. All right,
Well,
the
and the
next
issue on the
exhibit
exhibit
5,
here,
that is the
I'm
photograph.
not sure if I'm completely coherent, but the exhibit issue
I
is that if it's in evidence, it goes back to the jury room.
It was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So I don't even it's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one.
Marsland says this is like the legal version of Mystery Science Theater
I don't even
3000.
know
It's
what
only
I'm looking
bearable
at.
with the commentary. Stardust Crusader
This is
says,
safe
from
position
Florida here, I
on-
got a jury summons for election day. Hope I don't get put on a
Okay,
panel.
Judge, there's
I've done it
no
once
legal
and never
basis
want to do it again.
Exclude that from the jury. There's nothing prejudicial. It's a
Go in and tell
single
them you can't be
photograph. I should
impartial.
say overly
It's not that
prejudicial.
hard.
It's a single photograph of a
Mars
single
Lance, did you get us all
person
baldos?
showing
I addressed that
the
earlier.
injuries
Degenerate.
that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well,
The playbook
there
is
is an amended
the
information.
sovereign citizen
and I
playbook is to be
instruct the jury
confused.
except 6 counts. Be that as it may, I'll find that it is probably exhibit 5 to go back to the jury, and that will be sent to them. Now, exhibit 55 is a video. How long is that video?
Canuck 33, what happens if the jury asks a question for an explanation about jury nullification? Is that problematic at all? They would just be informed by the judge that
So
they
they
are to follow the law.
And I'll
It'd
hear
be the
from
corrective
parties
instruction.
First, but
they're
Right.
charged
my
with following the
inclination.
law and making their
Any
decisions based on the law.
Objection to
Exactly.
claim for the jury,
it.
exhibit 55.
What exactly is in the exhibit 55? I don't.
Dragon Fighter says legal vices
It's a
abandon me.
video
Will
from
you take me
Purdy
back, Rekieta Law?
Insurance facing
Always.
eastbound showing.
I love
Always.
legal vices. I think legal vices is cool.
We could put it up if you want to preview it, Your Honor.
Trying to get through
Go ahead.
these as we wait.
And we are
J
requesting that
Pat
it be
1218, will he ask
viewed by
God
the
for his
jury
oath
in
of
their
office? Yes.
deliberation room.
What I can tell you, if I do allow it, since I would have to, we'll verify that the technology is working, and then I would play it for them twice through.
Oh, I hope they
We would
come
watch
back
it
tonight.
at the same time as they're viewing
You
it.
know, it will make me so happy if the jury comes back.
And I'll preview it for Mr.
Right
Rich.
now.
You can see it
Just
first.
be done anyways.
Well, the state-
Wouldn't that be great? I've committed to this trial with you, Nick,
I know.
but I may not ever be back.
FSPU 19 says, drink more, Steve. Don't be an LB. No, you're fine. Don't drink anymore. Her skeletal says, well done.
Your
Well done.
response, sir?
Stuck with the bit.
If I do any more, it will be beyond the ever I've ever gone. We'll be entering the zone that I've ever encountered. You know what I'm saying? The territory of drunkenness that has never been plowed before. One more. Oh shit! You're gonna have to cut me off.
Boomstick dude says, too bad the battery charges are not first, so jury could find him not guilty on those just to get him smiling like he was
objection would be
getting off, and then hit him with the litany of guilty charges just to fuck with him.
Will be hard. It would be hard to say why the jury would request it.
Left-handed luck. I was really expecting him to end with jury nullification. No,
I'll just let
start
you
with it.
rule on it. I don't.
Left-handed luck. Over under this guy
Really?
going, offing himself before sentencing just so he gets to say in his own destiny. It's a possibility. Narcissists, though, tend to not be interested
So
in killing
many
themselves.
videos that's kind of like the same.
Matt from
video
Tennessee,
anyway.
I've read the Bible all my life. Objection,
Well, Exhibit
facts,
55
not
was
evidence.
received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write
Josh
on the note
3:16,
back
if he
to the
made
jury.
peace with God, he
This
would
relates
admit to
all
the act
three.
and bow out and accept
Exhibits
the punishment.
15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds.
Left-handed
And then I
luck,
will
this judge
initial
would
that
drop
and date
a
it.
gay black man off at Jeffrey Dahmer's apartment
The
on a
reason
promise
why
he
we
wouldn't kill and eat him,
play twice.
and then be surprised when he
And
does.
I just would note that the jury 4-person wrote yesterday's date. It is the 25th. My date will be
Hilarious.
obviously they didn't get the case until
You got your chats are hilarious.
here on their part, putting the 24th versus the 25th.
Or maybe I'm just
Technology
in the
with them, so-
state to think that everything's funny, but that was pretty funny.
Any
No,
reason
perfect.
why
You
it
could-
needs to be played twice?
That's my practice, at least on short video clips.
Left-handed luck,
what
whoever
about if
runs
they
against
request
this
for a
lady in
long
her next
video?
election is going to
Then I'll
destroy her
make a
with clips from this
determination then.
trial. She's made herself look too weak to be on the bench. Well, judges don't really have those types of
I
elections.
find that since we have the
Well,
new.
no, actually, I don't know if there's elections here, but this,
Play it twice, then,
I'll tell you, there might, if I was
them
in
to say stop.
Wisconsin,
then can you go back?
there might be an argument to run against her. I mean, she might lose. I mean, this is,
There are elections. I mean, she is elected.
Yeah.
She was appointed by Scott Walker
So
and
we'll
then
stay out
reelected.
here.
I love Scott Walker, by the way. He's cool, man. But
We'll
but
work to, they'll
boy,
have to
she's-
sponsor,
she may be a great judge in regular cases, but this case, she has not done her best.
make sure the technology is working. So if the state wants to. have
Solomon
that ready to go,
7589, just shut him down. You'll never convince him or win
I'll
the
set the
argument. He
bag
doesn't
in
care.
return
All you're doing is
for
giving him
Exactly.
time and power.
Exactly. Yep.
Spatula guy, not guilty verdict because of the incompetence of the judge and DA.
No, I don't think so. The DA has been great. The DA has been. I give A+ to the DA.
okay.
I pray that they're doing the same thing on their little minor misdemeanors and regular felonies that aren't in the public spotlight. If they are, salute to this DA because they're doing it right.
Spatula guy says this woman would be fucking prisoners if she was a guard and not a judge. Well, it's a bit forward. Ajo Nuzzo says, I'm quite sure that the man behind Brooks is T.C. Willis. He was a private security guard for Kyle Rittenhouse's family during that trial. Very cool guy. Saw him on the Higher Line podcast
Is
with
there,
Mickey. Somebody.
Audio with this, or is it just video?
Mickey Shook.
Just video.
Left-handed Lux.
Thank you.
Damn it. I just lost that one. Where'd it go? No, Steve, you're not that drunk. I'm just fucking hilarious, he says.
That could be. You are funny. I'm not funny. Or at least I think I'm really funny. This is the thing, is that I think I'm funny, but I know that people think that, like, whenever I tell a joke, they get offended and they think, oh my God, I can't believe Gosney said that. So
To me,
My-
that's hilarious. That's the
I know, but-
qualification for funny.
So I try not to be funny because I know that my humor does not go over well. But you're one of those guys that can say stuff that's just hilarious and it goes over. So I'm with you. Hey, Kurt, welcome back.
Thank you. I was just having some chicken.
Lucky.
I
Kurt
haven't
can
had-
say
I haven't
funny
dinner
stuff.
yet.
Kurt can say
Yeah,
funny
sometimes.
stuff, but people don't always let him say it.
Yeah, no. Sometimes people get really, really salty when I say
Stop.
funny
My
things.
humor can only get so large.
Yeah, right. Exactly so.
JPat1218 says, I grew up in Muskego where he was held and went to church in Waukesha. My sister's friend's daughter was injured in the panic from the incident. Weird to think life decisions could have led to me being at that parade. Damn.
I know it's sad. I mean, this whole trial, let's face it, there's some sadness. There's a whole lot of sadness here. The good people of Wisconsin have been subjected to this jerk's actions. And we are doing that. We are doing the public service by portraying it. We're creating some humor around it, but the evil that's been perpetrated on this good town is unforgivable. And thank you for doing, because the media has not been covering this trial. I don't care. The media has not been covering this trial because this guy does not fit the narrative. Screw them. you're doing the right thing by covering it. So thank you, Nick.
Oh, you're welcome. It's my job and obligation to make me as much money as possible. The alleged juror, by the way,
Trying
was
to make as much
apparently
money off you as possible right now.
yes. Wait,
Yeah.
are you on your stream watching this stream?
Yeah.
Yes, that's great. I love it. The A Train 007. Ghazni looks up to you for some reason, you filthy shyster, but his takes are solid too. 80s heart is definitely the worst heart.
No,
Damn.
and I'll tell you, and to apologize for whatever butt kissing I'm doing,
Turn it off.
let me tell you, Nick Rekieta has sold more books for me. Screw everybody else. Nobody else has sold one book for me. Nick Rekieta has sold a bunch of books for me. So I am loyal and I praise the Pope and screw everybody else.
That's my understanding.
Nick is responsible for everything good that's ever happened in my channel, and I pledge undying fealty to him and his reign. I owe him everything forever.
I hate
The email that has the
you
9
guys so much.
and that's my understanding. Yes.
Whatever he needs, whatever, in any way.
Were they identified to have any
Whenever,
connection with the
wherever,
trial in
like
any way?
like a Shakira song.
I'm leaving the entire investigation in the hands of the sheriff's department. I can't answer that.
Guys, again, I'm gonna do one more plea to check out my locals post and my YouTube community post about Chrissy Mayer's channel. Her appeal just got rejected and it's absolute garbage. There's no gore or graphic violence in the video that she showed. Everybody showed that video. I showed that video. Everybody did. And the fact that they're doing this leading up to her big live stream is like, I don't know what she has spent preparing for this live stream, but imagine investing thousands of dollars into preparing a huge live stream, 48 hours long, all sorts of guests, and YouTube just saying, nope, you don't get to do it. Oh, by the way, I know all your deposits are paid. Now you don't get to reap any benefit from what you've done. So if anybody out there is on Twitter, please consider tagging Team YouTube and just hammering home on how much bullshit that is. She played the clip of that the incident at that fast food restaurant where the woman was charged like 50 cents for extra sauce.
All right.
And she and her friends just proceed to bust like the plexiglass and go crazy.
And we'll let you
She was
know if
struck
there are
for
any
graphic
additional
violence,
questions.
of which there's none in that video.
Subject
It's
matter
property
jurisdiction,
destruction.
Your Honor.
I decline.
Subject matter jurisdiction.
She has a ruling on the record, you dummy. Okay. Oh shit! I didn't mean to stop the screen entirely.
No, that's cool. That was the
No,
end
I
of
meant
it.
to just remove it. Sorry, the back end
cool.
stuff.
That's
Back end
where
stuff.
we are. That's where we are. Sure, we're waiting for a jury verdict. So, do you think the jury's going to come back tonight? That's the question.
I hope so.
I
Surveyor
hope so.
8.
I hope they're just splitting up the forms and seeing how fast they can sign.
Yeah,
I
let's
agree.
speed run the guilty verdict
Hey,
here.
Kurt,
And
I
then-
heard something cool about you, and that is that you get your hats from the same person that Stevie Ray Vaughan got their hats. Is that true?
This is true.
Wow, that's cool.
Surveyor 8587. Difference between Kyle and Darrell Brooks is that Kyle broke down from trauma and the fact that he had to take a life. Darrell Brooks cried because he knows he's effed. It's all about Darrell. Ejod STL says, Law Pope, a toast to my saint of a wife who puts up with trial live streams playing in the background. Okay, yeah. I'm not going to drink any more liquor, though. So to Ejod STL.
I might do
cheers.
number 4, man. I'll tell you, I've got a little bit left
That
here.
is number 4.
Is it? I don't know. I've lost track.
I'm keeping track of you, good sir. Cheers to you and your wife who puts up with little old me yakking in the background. I appreciate you, you nice lady. Cheers. All right. Snub Birth 13. I'm all but convinced this judge has some bias in his favor or her self-interest. There's no way that she lets this stupidity go this long for a sovereign citizen. She wants to declare a mistrial. If she wants to declare a mistrial, she could have at any
No, she
point.
absolutely does not want to declare. That's her whole point.
Yeah. Okay. I'm going to read through these. Guys, when I get through the chats, I'm probably going to step away from Ryan, the editor, has offered to monitor the stream. I'll leave it running and we'll Well, I'll just pull the court up, and if the court comes back for something, he can let me know, and I'll come back and pop in right away if something's happening. But we've still got a bunch of chats to go, so that'll be a bit. Maybe we'll get a jury decision before then. CJS 51177 says no. That man. Oh my God.
Just the significance of seeing it as different speeds. Was that in the question?
They just said, can we see exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed.
He's going to challenge
So I'll
every
grant the
question.
What
request.
would be the significance?
We don't know. They don't
The
say.
significance is the jury's requesting it, sir.
I'm saying at that speed.
Oh, so
Oh,
there's
they
a
want
jury
the-
question.
Tell you the significance.
So they want to see back the video.
Speculate. But I think it's proper, given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask me if I have a position?
Because
You-
she's required to
That's
ask.
required to do, sir.
You're not
Exactly.
required to address subject matter jurisdiction, which has
Oh God, this guy.
allowed to ask.
I'm definitely going to at some point have to make a soundboard out of him so I can have subject matter jurisdiction on a button press and
Case right
Right.
now.
I mean,
And I
grounds
think
on a button press.
jurisdiction.
You could have like a keyboard. I heard you doing the vocoder the other night. It was cool.
Of course it's denied. Of course. Because
I really do like the
It's denied because
The,
you haven't ever
vote
levied
order
a
thing.
valid
Yes, you
objection
do.
ever. Even the ones you won, you
Has to
didn't
be
levy
proven
them
at
as a
some
valid
point.
objection. You just happened to get lucky.
do I gotta go through the song and dance to get it proved?
What approved? Ben 5375.
Jury's
Nick, can
ready.
we do Joe Biden clip for breaded? I have the clip from back in his Senate days. Let me know where to send it. If you want to use it, email me.
Just once.
Sammy Zan says, I honestly think she is concerned about the public outrage and has been branded as something she is not, so she's extra careful, but this just makes her look weak and gives him power. Space Allen, the record will be very clear to the appeals court that he was given every consideration. She's good. It's frustrating to listen to, but this trial is just not
That's
is not just for our
40%
entertainment.
That's true. That's a good point.
Wrong. All trials are only for our
Yay,
entertainment.
nay?
This is not a television show. It's not a reality show. This is reality.
Wrong.
wrong.
Wrong, Stephen. Wrong.
What? Oh, yeah. Well, maybe this show is, but I'm saying the trial isn't.
Galactic Dude says, is the death penalty on the table? No. Lynn's 1968. It's
Yes,
sad that we
40%
all know
better.
Darrell Brooks' name, but most can't recall the names of the victims. My brother was murdered. Homicide laws are far more complex than what most people think. Statutes vary by state.
True.
Yeah, homicide usually comes in multiple different flavors.
Right.
You know, murder 1, 2, 3, manslaughter, sometimes involuntary in different grades, sometimes involuntary different grades, vehicular manslaughter, sometimes reckless, sometimes it comes in like 10 different varieties, basically.
Right. In fact, my homicide module that I'm doing this tomorrow night with my criminal law class with Andrew Branca is covering this exact issue. Is that it's very complex, and the homicide statutes to vary by jurisdiction, and there's a lot of crazy questions. And Uncivil Law brought it up, and he's right on the money that this is not a simple question. These homicide laws are not clear, and it varies by every jurisdiction.
Mm-hmm. And it is possible for something to be murder one jurisdiction or not murder in a different jurisdiction, or versus the one that always I have to remind myself of is some states differentiate like top count murder for death penalty reasons. So, for example, you can't charge top count murder in New York unless you like killed a police officer or witness to a crime, or so forth and so on, right? But other states, their top count murders just like what other states would call second degree murder. So
Well, the
Yeah.
issue we were talking about earlier was that Wisconsin evidently has this thing about premeditation, and that it
Mhm.
only takes a split second. That the requirement for premeditation is just enough to form the intent, can be just enough to pull the trigger, but that erases the line between passion, heat of passion killing, and first degree murder, so that every heat of passion killing qualifies for first degree murder, because just the second it takes to pull the trigger is enough to qualify for first degree murder, and that erases the line in heat of
Yeah.
passion killing. So that's a problem, and I saw that in this instruction in Wisconsin, and it conflicts with the modern view. But uncivil law, what do you think about that?
Well, I guess you could technically split the difference between the two. Like I could form an intent to kill you instantly without being provoked in some way, just because I'm there might be some situation where the desire to kill somebody would come instantly without heat of passion. So I guess there is a difference somewhere.
Nick C, 1987. My first rumble to Pope Rekieta, the cartographer, first of his name, patriarch of Griffmark and vanquisher of Troons. Long may he reign. Thank you.
I feel like I understand the desire to kill arising in a split second on a personal level.
Wait, just now?
No,
Seeing Brooks trial
not necessarily just now, but there's definitely been times in my life where, like, yes, I would like to kill this person.
But there
never
is
felt
something.
that way in
reasonable
my
person.
If we're
entire
going to
life.
have a heat of passion killing, and that is a mitigator, then it needs to be given some kind of
the moment.
Yeah.
the point is that if you're actually acting in the heat of passion, the fact that it takes a second to pull the trigger, that should be out as first degree murder. This is
I'm not necessarily opposed to what you're saying.
Yeah.
In principle. Yeah, I understand.
That's the modern
think-
view. The traditional view is what the other view is. It just takes a second, but the modern view, I think, is more correct, because otherwise everything's first degree murder. There is no heat of passion murder, and the
Sure.
fact is that there is a heat of passion murder. If you find the wife in bed with another, and you kill in relation to that, it's not like some formulated plan to pull the trigger. I mean, there is a mitigation there. It is a lesser crime than actually planning and deducing of like how you're going to kill somebody. So I think it is a lesser degree of culpability. So the modern view is the correct view, but there is this lingering thing, and obviously Wisconsin has that.
Yeah, fair
Let's
enough.
see. Mop Soup, have you ever been a misdemeanor? Oh, okay. K Steiny says, no victim, no crime. Sin Digital Art 9. Hey, Nick, came here to shamelessly shill my Instagram account at sin_digital art 9, where I post fan art, except for this month because of Hwayan Hantober promptly list. So come follow me and like my posts. I don't know what
What
those
is
words
that
were.
exactly?
I don't know. Let's see. Next, we've got Thorium says, I think the judge is really nice in bed. No, I don't want it in the ass. No, I don't. This is the third time you try and put it in. Okay, geez. Chat, keep them going. Judy Brady says they are going to find him guilty for just having to leave so many times. That actually might be true. True.
Well, I mean, how many ways can this guy be guilty?
All of them.
76.
Yeah, well, boom, shot.
Let's see. K Steiny, he thinks any jury is going to nullify the law against murder. I'm consistently astounded at human idiocy, but I shouldn't be.
Hey, uncivil law too. I know you do these great breakdowns, and I
Yes.
fully respect them. I'm going to give you 163 Wisconsin second 949 state of Wisconsin versus Barchikas, and that has to do with jury nullification. So
Fun.
I'd love to see your take on that, because if anybody knows, uncivil law does these long, very long, in-depth, to the bottom of the barrel in analyses of these cases, and it's really very thoughtful, and I'd highly recommend uncivil law's take on these cases. And this is one that was just cited having to do with jury nullification. I'd love to hear your video on that. So if you would, please, if you'd consider doing that case.
Okay, cool. Super chat me.
I just sent it in the private chat there for you.
No, I mean pay me.
Oh, I'm a poor public defender, man. You're asking
Oh,
too much.
okay.
Yeah.
Use your client's drug money to give me some revenue. I don't know.
Drug money. I don't get their drug money. I get appointed because they're indigent. But anyway, salute to you.
Kay Steiny says he thinks any jury is going to nullify the law against murder. I'm consistently astounded at human idiocy, but I shouldn't be. Gnome John, he's fighting to repeal Marbury versus Madison. Get this man. Get this man. He has my sword and my axe. I am with him. Marbury versus Madison is the most egregious overstep of constitutional authority ever created. Kurt agrees. Oh, but he has to go. It's weird. He won't.
Where'd he go?
He had to go, right? He agrees with me though on this, Steve. Trust me. He fully agrees.
You're doing that thing. Okay, I get it. See, I'm not quick enough. I'm like 3 seconds behind all these jokes.
Horror Amarada says, this hurts so much I'm giving you more money. I can leave whenever I want. You're stuck here in the grift. You can't leave, Horror Amarada. You can't leave at all. You're all stuck here. You're stuck here with me.
No, yeah, we can talk about Chevron versus NRDC or Wickard v. Filburn or the Slaughterhouse cases, though. If you want to find something we want to overturn, that'd be fine. Just saying.
Okay.
Available. Was that
I
too much?
I just wanted to glare at you. Wickard needs to be overturned dramatically.
Uncomfortable silence.
Absolutely.
I don't know what's going on here.
See, Steve, I actually vehemently disagree with Marbury versus Madison.
Okay.
Yeah.
And Kurt doesn't.
Yeah.
He pledged his loyalty, and yet here we are.
This is very academic disagreement, by the way. This is not something that's emotionally driven.
The John Beck says, she said it during nullification. She summoned the boogeyman. Someone is going to Jack Ruby, this guy. Orenthal G. Mudbone. And I'm going to have to step away a little early in just a minute because I have to order some food for my family.
I haven't had dinner. I only had.
Well, you can step away and Steve can step away, and then you can just leave me in charge of the Rumble chat, and I'm sure that'll go over great.
Kurt, it can't go bad. That's the thing. You're limited by where you are, not where I am.
Yeah.
I accidentally showed a vagina on stream the other day.
Excellent.
That video is still up and unstruck. Rumble's the greatest place on earth. That was Anna's fault.
I'll hold the fort for a while and respond to your locals chat. Should go over great.
Hey, Nick, once you're out, I'm out, and I'm out for the count. I don't know when I'm coming back because I've got a real job. I am not a law tuber. How did I ever get sucked into this den of sin? I have a real job and I'm here for this trial. But once you're out, I'm out. So if you want to buy my book or watch my Rumble channel, do it now because I'm gone after this.
Here we go. I'll pull this up. Here we go. Let's present it. There it is. This was all a prank. I didn't think this would blow up like this. We are sorry. Love our drama. It was all a prank.
Stupid judge.
Of course it was obviously a prank. It was written as if a troll wrote it. Like there was no question to me. All right, Orenthal G. Mudbone. These two are perfect for each other. I don't understand why she can't just end it. Under what lawful law can this keep going? Ganek, are they legitimately worried an appeals court will believe any of his horse shit? I don't.
The thing is, see, I'm an appellate criminal lawyer. That's what I do.
I'll be right back.
This crap will never go anywhere in appellate court land. I mean, the fact that like as biased or as pro-state as this judge is, the appellate courts are 10 times as pro-state as this is. Do you think that he's going to get any kind of audience or any kind of in the appellate courts? I mean, Kurt, what are we talking here? I mean, the people think this is the thing. When I wrote an article,
the only thing I would do as the appellate court would just be to expand the court, to expand the judge's authority.
Exactly.
Because like the only thing I would be doing is being like, because the judge is to some degree creating case law before our eyes.
Exactly.
Right? Because there's no case that's exactly on point. not a problem. This is what we do in common law. We take what's there, we interpret it, and we take the principles that are there and then extend them or not, depending on the competing factors. So the
Right.
judge says, okay, here's a whole bunch of cases that I have that speak to particular situations. Right? I've got this case that deals with you being present in the courtroom or not. I've got this case that deals with your right to forfeit, your right to call witnesses. I got this case that talks about waiver versus this thing. I got this case, this case, this case, this case, right? And no case maybe is specifically on point. And so, for example, for the waiving of the closing argument. And so, like, no case dealt with that exact scenario. The judge, very reasonably and very correctly, in my view, says, well, okay, here's all the judicial decisions that are on this point. Basically, the overall theme is, the judge gets the right to control their courtroom and you don't. And there will come a time and a place where your antics, whatever they are going to forfeit your rights in basically every possible respect. Like, you can basically forfeit yourself out of everything at some point, is basically the bottom line.
Exactly. What's going to happen is either he's going to lose, he's going to go to prison, he's going to file the public defender is going to file an Anders brief. He's going to file a pro se brief.
Right, yeah. I want to cover that case. That's a good one too.
Yeah, he's going to file a pro se brief or a pro per brief. And the court is either going to PCA it, meaning affirmed without opinion, or they're going to give expanded powers to the state and the judge by saying that in these type of cases that the judge has the power to remove from the courtroom, and they're going to give her expanded options for dealing with idiot client or idiot defendants like this. So I don't see any appellate court in the world saying, oh, gee, Mr. Brooks is right. That's just not what's going to happen. This is why the arc of appellate law tends towards the state, because these idiots push the issue. The state, when the state picks their cases, they pick the cases that they want to go that are favorable to them. When they see a case or a fact pattern that's favorable to the defense, they don't appeal it.
Right.
So only the idiots are appealing it. And so that's why our appellate law gets driven pro-state and against individual rights, which is a problem. But this is the reason is because of these kind of idiots.
Well, maybe, but I don't necessarily have a problem with this going in this direction, because like the idea of the judge in control of their courtroom, on some levels, as old as you want to go. So the idea of the judge, whether that's the king or whatever form the judge is, that the judge has like a lot of control, can exercise a lot of control is not a novel concept. So
well, and see, that's the thing. We all agree that the judge should have this discretion, and that the fact is that she's relying on the Supreme Court case that doesn't quite say that she can do what she's doing, right? It implies it, but doesn't quite say it. So they're going to explicitly say it. But the problem is that propagates down into the case that's maybe the more marginal case, the person that's actually innocent. And then all of a sudden that you and I, the reasonable citizen, are dealing with this overwhelming state power. And it's a problem, because the arc of law tends towards expanding state power. And that's a problem over time of common law. And because these idiots like this guy push the issue, and the state doesn't push the issue. So I don't know. I'm not
sure I necessarily agree with that proposition, because there's lots of cases from the Supreme Court which have expanded and granted rights to defendants. Miranda perhaps being most notable. The Supreme Court themselves described it as a prophylactic rule.
Except that Miranda is basically useless. I did a whole seminar module on this, that Miranda is basically been completely eviscerated over time by so many exceptions that it's basically a meaningless right. And over time, our rights have been eroded. And just full disclosure, because we haven't had a real heart-to-heart discussion, but I'm basically a classical liberal, and I believe in individual rights and expanded individual liberty against corporate power, against government power. And what you find is expansion of these government and corporate powers to the point that the individual rights get minimized to a small portion. And I think that arc of, we need to fight for individual liberty as lawyers and as citizens of the United States. And I don't know where I'm going. I'm so
Well, that's
far.
fine.
I don't know where I am on my
I
drunk
certainly
level,
understand.
but
I certainly understand and respect classical liberalism, but I think on balance, I consider myself more conservative than a classically liberal.
you're
And
what now? Say again.
I consider myself more conservative than a classic liberal.
How would you define that?
I think for myself, the distinction is the conservative, the classic liberal, as you say, and I think correctly, promotes individual rights and individual liberty and individual autonomy and stuff like that. I think the difference for my mind for the conservative is the conservative sees value that's balancing and potentially at times overcoming for institutional power.
Why
The
are we?
conservative, I mean, the hardcore conservatives originally were just like those were the people that supported the monarchy. Like they speak
Well,
to the
but
power of
you know,
institutions.
when
and
I
stuff
look
like
at
that.
conservative, I say, what are you conserving? Well, to me, I am conserving the radical, revolutionary, liberal idea of the founding
Right,
fathers
they are
and
ready.
the Constitution.
Okay, hold on.
Okay, I'm sorry. I love talking with on
Get rid of
civil
that.
law because
You're
I love this.
Yeah.
So anyway, go back to.
I see value in the institution and I see value in
clarity.
the
Okay,
government.
so they're replaying this exhibit for the jury that they requested. So that's what's going on right now.
And just so any question by the jury where they want to review evidence has to be an open court in front of the defendant and in front of it has to be replayed. They can't just send it back and have them review. They have to do it in open court. So that's what they're doing right here. I'm surprised. I'm a little surprised that they're asking these questions. That doesn't make me happy as a rooting against defendant Brooks.
Yeah, I think we all agree on that much. Defendant Brooks should suffer in.
They're asking it to be
Yeah, but it
stopped.
looks-
Any objection from the state,
No,
from the defense?
Looks to me like they had a question maybe related to the domestic violence.
Oh, okay. I see.
I want to give it him.
You want to give it to him? Give him some
No, I
domestic
wouldn't-
violence?
No, sorry.
Well,
I definitely want to punch him across the face.
Uncivil Law and I had that big death penalty discussion, and I'll tell you, nothing argues for the death penalty more than Derek Brooks or Darrell
Yeah.
Brooks.
Yeah.
Poor Derek Brooks. That poor guy.
Darrell
What did he
Brooks.
do?
Derek Brooks is my friend. Darrell Brooks.
Not anymore. He's not.
Derek Brooks is my best friend, but Darrell Brooks is this idiot right here. Not to be confused.
You support the death penalty for your best friend, man. What kind of friend are you?
Rude. Rude.
You
I do, though.
Stab me in the heart.
I just want to say, guys, we are currently at 9,500 rumbles. Let's see if we can bust 10K. Hit that plus button. Hit the thumbs up on your mobile app if you're on there. We're almost to 10,000 likes on Rumble on this video. It's massive. It's gonna
Also,
be one
while
of the
you're at it,
biggest
come over to
videos.
Uncivil Law and like my video, you assholes.
Wow,
That's great.
man.
That was awesome.
Okay.
Most
TMF
disagreeable people on earth are in this channel.
TMF Squid says, I still don't know what the monster is trying to accomplish with this stupid I accept for value in return for value, Your Honor statements. He's just reading off of a script. Why is this? Sorry, my headphone cable got stuck under the wheel of my chair. And it was like lined up between the two wheels, so it's just rolling along. Anyway. No, he's just reading off a script. There's no meaning to it. He doesn't know what he's saying either. He doesn't have anything. He's reading some sovereign citizen script about probably related to contract law.
Any
And
objection?
he's
to
asked
stopping that video?
if this is civil or criminal.
no.
Like he has actually asked if this case is civil or criminal. It's
For the
criminal,
record, this
homie.
one was stopped
That
at
whole
March
sovereign citizen
What
shit
time
should
was
come
that?
through an advisor, like saying, this stuff has not worked for the last 20 years. Disclosure. They should sue the sovereign citizens for being such idiots.
All right, I would think you might want to stay close by.
And usually the close questions like these,
Yeah.
the jury comes back real quick after they ask the question. There's somebody that says, well, what about this? And that's the last issue that they have to resolve. And they go back and they fill out the form and they come back. So I'll bet you this jury's going to come back tonight.
Oh, I would think so. I think Like I said, I thought the jury might be out 2 hours tops, and mainly just because of all the paperwork that they have to fill out, going through each of those counts and just writing down the names and signing, and it just takes time. But yeah.
Yeah.
Let's see.
I've been streaming for 11 and a half hours now.
Wow.
I'm only at 6.
I'm sorry.
Yeah.
I said a bad word. I'll put money in the tip jar.
Yes, you should. Something Awesome says, I was trying to run errands this weekend and there was some children's Halloween costume parade and some BS. And I'm just saying, Darrell Brooks had a point. Oh, no.
What?
Nothing.
I missed that. What did you say? What was the issue
No,
there?
The chat, so the super chat basically just said that they had to run some errands and they came across a parade and they're saying Darrell Brooks had a point because they probably had to wait.
He is not, and this to make clear, this guy is not dumb and he's not insane. We're not dealing with insanity or stupidity. We are dealing with pathological narcissism and attitude. That's what we're dealing with, and that's the thing, because it's easy to say he's insane or he's dumb. He's not either of those things. He is pathologically narcissistic.
Pathologically jerkwad.
Yeah, that's the summary, right?
Pathologically going to have a sovereign citizen of 6x9, all for his very own. He can have all the sovereign citizens stuff he wants in his 72 square feet.
And he will.
Vibe AI. Hey, Nick, thanks for the epic rants and streams. Grift me some subs, you slackers, so I can go get started. And click the plussy already, you freaks. 9,000 out of 19,000 watching. Come on. Later. We are over 10,000, so thank you for that. I think we know what video will be on top of Rumble all day tomorrow. And this video loves being on top. Wamba Tommy, can I have a toast for my dad who passed away? A 4-tour Vietnam vet. He left behind 7 kids, 22 grandkids, and 12 great grandchildren. Jury wants to be done for the evening and come back tomorrow.
Should assemble. We'll get the alternates because they're sequestered.
Wow.
What is this? Is that real or is that just?
Yes, that's real. That's what the judge just said.
What'd she say?
The jury wants to go for the night and come back tomorrow.
Mm. Well, that's the end of our chat.
Wow.
Same.
That is insane. What?
Well, it's a lot of forms to fill out. Let's face it.
To basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room. So I'll read a modified kind of version of instruction 50.
Implement order 66.
Sorry.
We are in the record.
So there's matter of jurisdiction.
I decline to address that further, sir.
Will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based in any law or fact?
Hold on.
There's one other thing besides capital punishment, and that's called corporal punishment. Corporal punishment is also a thing. And the ACLU.
You want to spank his ass?
Yes, exactly. Just a little like immediate corporal punishment to this idiocy. We've eliminated that from our subject of penalties because the lefties have said no, nothing except incarceration. But corporal punishment may be effective. I don't know. We need to think about this seriously. Forget capital punishment. I'm talking corporal punishment. What do you think?
Yeah.
I wouldn't object to him being put in the stocks for the remainder of his life. That'd be fun. I could throw tomatoes at him.
Look, some corporal punishment's a little bit fun.
Well, that's a different context.
It's the only context that matters. To the grandfather, to the dad of Wamba Tommy, a 4-tour Vietnam veteran, a man who saw probably some of the most horrific trauma one can imagine experiencing. diligently returned and then came home to create a family, to pass on not trauma, but value and appreciation to 7 children who have then to their children and their children passed on those same values. Truly someone to be admired and who will definitely be
I
missed.
thought it was
Cheers.
2 people that got excused from the jury.
3. There were 15.
No, I'm saying I thought it was 2.
It was
from the
3.
16.
No, only 1.
Well, you did say 2.
No,
Ugh.
she
One
said 3
had got
names.
excused before, and then another one was getting excused.
No, I only excused 1.
I really want to strangle this guy. He is he is such a horrific human being. Oh my goodness.
Short drop, quick stop, baby.
Second, he's like a 2-year-old.
I don't know what that.
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
This is a child.
Not on the record, Your Honor. Verified proof, lawful law.
No need to get in your feelings. It's
Lawful
been a
law.
long day. I'm tired.
No
too.
need to get in your feelings.
I agree.
Make sure he gets his shower.
I just
Make sure the other inmates are there.
He was trying to get to his shower today.
You said 2 on the record.
See, when you drink, you lose your inhibitions and you get weak. And this is the problem. This guy, it's hard. He is a test of everything that we are. He is testing us.
I'm failing.
It's hard because this guy is everything that's good society and good people have to fear and to loathe. And here he is.
Jadine says, take my money, you Shasta lawyer, disloyal whore. I cannot believe the jury's not just wrapping this up personally, but okay.
Well, it's a lot of forms. I mean, this is like 76 counts. Jeez, they're looking at this pile of paper and they're thinking, let's just come back, do it tomorrow. No hurry, no problem, right? I mean, come on, they've been 3 weeks. So this is not out of line.
Let's see.
Thank
There's
you,
also
everyone. Please be seated.
corporeal punishment.
The record to reflect, I have
Very
12
dangerous.
jurors who have been deliberating, plus the 3 alternates who were sequestered in a different jury room. I want to give you kind of a modified instruction from the one that you've heard many, many times throughout this trial. Of course, for the 12 who have already started to deliberate, do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow in the jury deliberation room. Do not discuss this case among yourselves or with anyone else until you are deliberating in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. I realize you are sequestered. We've taken away all of those things, but I'm just going to keep reading through this. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses.
You don't even get your phone back overnight. That sucks.
Do not listen to any conversation about this case.
I think.
Do not
Are they
research any
sequestered in a hotel?
information that you personally think might be
Presumably.
helpful in understanding the issues
Will
presented.
be the alternative.
Do not investigate this case on your own or visit
Oh, they
the
have
scene
like
either
limited
in person or
sequestration.
by any electronic means.
Well,
Do
no,
not read any newspaper
not it.
reports or listen to any news
Yeah, I don't
reports
know how
on
that
radio,
works. Never mind.
television, over the internet,
I'm just yakking.
or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities. to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I know you're not going home. You're going to
you
another
don't have to
location,
go
but do
home,
not
but
discuss
you
this
can't
case among yourselves
stay
with any other juror
here.
until you are back in the jury deliberation room tomorrow. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any
I
manner.
haven't heard the record.
These rules are intended
Have we proven jurisdiction?
and impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are all excused for the
Look at
evening.
his
We'll see you back here
face.
tomorrow at 8:30.
Let him
And they
listen.
say Sandman's face was punchable.
Oh my goodness, this guy is hateful, isn't he? It's tough. He tests everybody's limits, doesn't he?
Wombat
Holy cow.
Mommy says, "Hey Nick, it's Wombat Mommy, not Wombat Tommy." Look, yes, you're right. I'm sorry, I read that way wrong. Thank you for clarifying. Oh boy. Is he going to bring up subject matter jurisdiction again?
Probably.
You know,
All right, thank you.
I know I've said this before, but
We'll see everyone
you can
tomorrow.
always bring up subject matter
3
jurisdiction. It's the only issue you don't have to preserve.
3 a.m. I trust that the jail
Justice
will
for
give you
Darrell, Reddit has
a
been
shower,
banned from
so
Reddit.
whether that's
I want to
Nice.
note that I'm up to 17 cents
I will
in
order that.
Rumble earnings. Thank you, chatters, for
3:30.
subscribing to my Rumble.
That's when we start court every morning, sir.
No, it hasn't been.
I feel you, Judge. Ugh.
He probably wants to.
Well, who doesn't, right?
She's not bad. She's not bad on the eyes. But having to listen, could you imagine? For the record, I want to tell you that he tried to touch the breast, but did not quite make it. For the record.
Oh God. Okay. So here's what I got to do, gentlemen. I have many chats to read through, and then I have to figure out what the rest of my night is going to be because this is late. What is
I'm
this?
going to bed immediately after this.
How did-
We're done.
What happened? Why are you
Hey.
here?
Because I'm done.
Who sent you here? How'd you get in?
You texted me earlier. Don't you remember?
It was me.
Yeah,
Oh.
me and you texted each other at the same time. I sent you my link.
Oh yeah. That's right.
Yeah.
Okay. I was
Thanks
gonna
for
throw.
caring. I thought you were a friend.
I was gonna throw myself out of the stream, I guess. How you
Oh,
doing, man? How's your?
doing all right. That was a. Yeah, he's all chuckly and he's.
I think he's at that point of accepting his fate. Like he
Yeah.
knows what's going to happen. So now
Mhm.
he's just playing a game.
He
Yeah.
does, but he's a master selfish son of a bitch manipulator.
Yeah. The one thing I just wanted to say is when I was on my stream when he mentioned it, he's like, you guys, nobody in this county wants to be in your shoes. I'm like, I guarantee you I could have held a raffle for jury spots, like $100 a ticket, and I'd run out of tickets.
Yeah. Oh yeah. Okay. So interesting updates on the Reddit. The Reddit has been banned. r/Justice for Darrell, which is lame that Reddit is doing that. Although what they were doing was potentially unlawful activity. I don't know if it was all just a prank. Not really. If there was
No.
any legitimacy to it, it would have actually been unlawful. But the other problem that they've got is apparently one of the last posts I saw from the guy was that they had already discovered that he lived within like a 300-mile radius of the courthouse or something,
Oof.
which is a pretty big radius. So that's but yeah, that'd be pretty funny. But no, it's all That was such an obvious prank, and it was so irritating that it got the time of day.
Unbelievable that the judge brought that in. You know, no, very disappointed. The prosecution is the star. The judge failed, and you know, and I respect her for she's probably a great judge in most cases. She was the wrong judge for this case.
Yeah, who knows what she's like elsewhere, but yeah, this has been a bad showing. And again, she's fine with the legal issues, with keeping the record, or with getting enough on the record to justify her stuff, but she's gone way overboard. Like, she's not at risk of causing a mistrial. That's what I'm saying. But she's gone way beyond what she needed to do.
Yeah,
and she should have controlled her courtroom.
Yeah, I just think for her the biggest, it wasn't necessarily just getting overturned, but being in the community and you're the reason why it came back. Like that, I think that's an issue too.
Yeah,
for her.
Yeah. Okay, so what I need to do is read chats, wrap up the stream, and I have to decide what to do tonight. I don't know if I'm going to do another Rumble live stream tonight, since we're going to be back tomorrow. Presumably for jury watch, which I thought this thing was going to be done tonight. I thought there was no way it was going to go into Wednesday. But so we'll do that. I might do a Twitch live stream tonight, or I might do a locals live stream tonight. We'll see. Looks like I'm going to get done here about the time my kids are in bed. So that's nice. Thanks, Darrell. Oh gosh, I don't want whatever this is. But yeah, I have to help out with some stuff. Lady Rackets is working on a new video, and we're going to make sure and help her out.
Hey, Lady Rackets is beautiful. I saw her channel on the other channel. She's a beautiful woman. How did you score that? How long have you been married?
Well, thank you. Also, jerk. Just kidding. 18 years, man.
Congratulations.
Thank you.
She's beautiful, man. I'll tell you.
I know.
I'm like, a whole nother thing. Boy, I'll tell you, every once in a while, we schlubs get lucky, don't we?
More often than not. More often than not.
I'm lucky. I've been married 24 years.
Okay, Darrell. Well, congrats. That's a long time.
I'm an unlucky son of a bitch.
Damn.
Lucky in love, right? Bad. You bet you're good in cards.
Let's see. Hold on one second. Okay, let me read through these chats, and then we'll see what happens after that. Darrell says, what a pointless, spineless, incapable law holder of a judge. She can't even rule her own court. Whoever gets her next should recuse her immediately because she has no balls at all. Well, I don't think that's actually going to be a problem. Again, unless you're dealing with another mass homicide sovereign.
Yes.
Nothing to lose.
Yeah. Anyways, Nick, I just wanted to say hi. And yeah, fingers crossed, like tomorrow morning, I think they're probably going to come in right away and just finish it off.
It really should be fast.
Them rewatching that video, those grannies getting ping-ponged off the hood, I think probably...
Yeah. That'll do it pretty quick.
Mm-hmm. So, anyways, night, everybody.
Later, buddy.
Yep,
see ya.
Oh, that was quick. Bye, Sean.
Yep. See you, Steve. See you, Kurt.
Yep.
Mull the Dull says, Your Honor, I call for occupants of interplanetary most extraordinary craft. I think you're going to be okay, lady.
Oh, kids.
My daughter is complaining she had to practice violin. Now her wrist hurts, apparently.
Oh, how many kids do you have?
5.
Wow, 5. Holy cow. I've got 1. And he's off to college. I'm suffering from empty nester. People ask me, why am I doing this stuff? It's because I don't have my life.
Suddenly you have
son
time.
went to college. I got time.
Voyager 8294, please let the judge at sentencing give the "and I hope you die in prison as well" speech. Wait, where is that? I've got it right here. This one.
I hope you die in prison as well.
Oh boy, that's a judge. Holy cow.
That was a brutal case. It was a woman who stabbed her boyfriend to death. And then she sat there and tried to make it out like it was accidental or something. And she stabbed him like 60 times. and had
The
like
first 10 were accidental.
yeah, it was bad. It was a really bad case.
I think I'm gonna go ahead and sign off myself. But if you're watching tomorrow, I'll pop on with you for some of it at least. So send me a link.
Sounds good. We'll do.
Respect,
All right, I'll talk to you
Kurt,
later.
man. You're the man.
All right, talk to you later. Bye.
Peace, Kurt. Guys, make sure to check out Uncivil Law and Potentially Criminal on YouTube, of course. Kurt, you're still here.
I know I'm working on it.
Like, did he think he left because he left his other one? I don't know what happened. There we go. Okay, yeah. Please make sure to check out Uncivil Law and Potentially Criminal on YouTube channels. I don't know if they have Rumble channels, but you can check them out and check for them there. But definitely, they're on YouTube, and both good dudes who I like very much. Horror Amarada says, "I honked, so you must have quit." That was kind of the theory. Vibe AI, I understand feelings myself. I know I'm good enough. I'm smart enough, and you effers are gonna like me. Hold on, I just had to make sure my kid was gone. You fuckers are gonna like me. God damn it! Now let me out of here. Redone says you can hate
You
this.
do have there is a line here. So we recognize that in the brain, you recognize there is a line. The children are not around.
Oh yeah,
I'm
absolutely.
just noting for the record.
My show is very much an adult show, and my children are not allowed to watch it.
Okay.
So, Redone, Red One 777 says you can hate this figgity faggot all day or all you want, but you cannot deny he brought this cum guzzler judge to her knee and made her suck his dick and hair balls. Oh wow, that was a lot. Blue-eyed Roof Korean says Pinochet here again. While you are slowly taking to my way of thinking, please don't brush off jury nullification. We may need it in the future to deal with new U.S. laws influenced by globalists. Oh no, I've never had I think jury nullification is an important power of the jury and have forever. But you can't, the courts don't let you advocate for it. I mean, that's the rule. Whether or not that power is there is different.
We didn't get into this. And that's my one of my little notes here, but we didn't get into this. But jury nullification is a result of the power of the jury to decide facts. It is not lawful, but it is within the power. That's what she was trying to explain. I would recommend the State of Wisconsin versus Bajorkis, 163 Wisconsin 2nd 949. If you want to read about the difference between the power of the jury and the right to inform them about their power. So that is clear, very clear, crystal clear in Wisconsin law about that he does not have the right, but he got away with it. He told him he got away with it because the judge let it. And so another win for the Mr. Brooks by this judge. But the fact is that it was not lawful. And there you go.
Let's see. Blue-eyed Roof Korean says, while the concept of nullification shouldn't be wasted on Brooks, someday someone might need nullification to forgive taking out someone like Bill Gates for his $87,000 IRS or some Pfizer executives. Well, hopefully we don't come to that day personally. But yeah, hopefully the people just go ahead and fix the issues without violence. That's what I always advocate for. Shawnianism says, I wonder if Brooks could to us the names of any of the people that died that day. Oh, if he could like say it, if he knows any of them, probably not. But who knows?
He doesn't care. He's self-centered. He doesn't care. He only cares about himself. Those are just pawns within his big game of chess that is him. His whole world is his own ego, and the rest of the world means nothing to him.
Let's see. Sammy Sand says, if there was issues with the car and it was an accident, why not say this from the start? Why play the stupid game with jurisdictions and pretending you're not the person charged? Well, okay. The second one is because it's from the sovereign citizen playbook to cause a disruption that might lead to a mistrial. I mean, that's the goal. Someone like this, by the way, a mistrial would not really benefit Darrell Brooks. It would harm the state only. Right. But this is a guy that would not be like, well, we're not going to retry him after a mistrial. They would
well, it depends. If they got like a conviction, it got him life in prison and he got some kind of error, they're not going to retry him because he got life in prison. The object is to get it to the jury and get him the life in prison sentence and be done with him. That's the whole point of this whole process. It's due process. He's given the due process. Get him in front of the jury, get him into prison, and then be done with him and forget about him forever.
Right. But if there was some issue in this case that caused a mistrial, sometimes the state chooses not to retry the case. And that's kind of one of the advantages of a mistrial is if the state doesn't find that they can either prove their case or it's not worth it or whatever, they won't go through it again. On a case like Darrell Brooks, you've got 6 dead people in a public attack. The state of Wisconsin will retry him until a guilty verdict sticks or until he's found not guilty.
I had a case when I was prosecuting in Flagler County, Florida, where we had a DUI, and it was a 3rd DUI, which made it a felony. And we tried that case 3 times. We had 2 mistrials, and the 3rd time we nailed him. So, and that's on a misdemeanor DUI. And so, you think that they get a mistrial, they're not going to retry this case? I don't think so. I mean, this case, they're going to prosecute him until they had no other option. That the only escape for this guy is to get a not guilty beyond a reasonable doubt by a jury of his peers, and that ain't happening.
Cledge Fenrir, he thinks he should have taken a left at Albuquerque. Blackjack 21, does anybody have a time count? Project Calm, the jury is thinking of how to best break apart the guilty packet so they can fill it in as quickly as possible. Well, apparently not. Apparently there's some level of time. Let's see. Catrux 88, Brooks would have been an excellent politician. Nothing but talk, talk, talk. Too bad he never made it that far and all we got was a music video. Project Calm, you can be upset, but this worked in like 30 of his cases in Milwaukee. Yeah, very possible. But it depends on the level of the criminal act. I mean, if it's some misdemeanor or whatever, sometimes this is the problem with what perpetuates the sovereign citizen mentality is that if they pull this nonsense enough and they slip through the cracks on something that is not critical, then they think they win, and they think, and someone goes, oh. And it perpetuates the legend that this stuff is valid.
You know what? It always bothers me. It's like, how is it that these sovereign citizen folks place their entire being and faith into this stupid document? It's like, why don't you place your faith in something else? It's like they are so certain of this idiocy. Why aren't you certain in like something else? Why, how is it that this little bit of like evil is so attractive to this pathological type person? It's a bizarre thing. I mean, he is so certain he's right.
I think it's simple, actually. So we've got how do I word this? We've got a case of an abuser who abuses power. I mean, that's what he wants. He wants to have power and abuse power, lord it over people. And it makes perfect sense with the idea that there's a set of magic words that can be invoked to have power over what presumably should have power over you. You can have power over a judge and a court simply through mastering this easy set of tricks, right? That's why it's attractive to people who value that power. And I think abusers, that's right in there.
But it's so irrational because the fact is that after 25 or 30 years of sovereign citizen stuff, none of them have been successful. It's a failure across the board. So rationally, there is no reward in placing your faith in this ideology. It is irrational, but it's an odd psychological phenomenon that it's over my head. I don't understand it because I've dealt with the sovereign citizens. I've had 3 sovereign citizen clients, and it's bizarre. I don't know, but I'm glad that maybe this one positive thing of this trial is that the wider public gets to see this sovereign citizen stuff for what it is, and maybe some life will be saved by seeing this guy because these people are very dangerous.
I doubt it.
I don't know.
I don't think This guy's not saving any life.
Cynic. All right,
Um,
go ahead.
Randomus Maximus, there's been zero apologies from Brooks this whole trial. I haven't heard a single I'm sorry from him, even during his closing. Well, and if your theory is that you're not guilty, saying you're sorry on the stand during the pendency of the trial is not the best idea. That's actually a sentencing hearing thing where you show remorse. Actually, I have problems with judges who expect people to show remorse for their crimes during a trial, where like it's like, well, but that's kind of an admission of guilt, and that doesn't strengthen your case in any way. But so I have an issue with that. I don't like that judges are like, not once during this trial did you say I'm sorry I did it. It's like, well, I pled not guilty, Your Honor. Like that was
Well, and
kind of the
exactly in
idea.
the real world of law, which we deal in, not this case, but there is an issue about holding somebody's lack of agreeing, lack of acceptance of responsibility as an admission or some sort of aggravator for sentencing, when in fact I don't think that's proper, because somebody's lack of admission, they say I am not guilty, and they go all the way to their sentence and say, well, the jury said you were guilty. Well, to hell with the jury, I'm not guilty. And to hold that against somebody at sentencing,
Yeah.
that's a problem. And so it shouldn't be held against him that he maintains his innocence. But this guy's going away from life. It doesn't matter. But in a general matter, it should not be held against the defendant that he maintains his innocence.
Jay West says, what's the over under on how much time he takes the jury to decide? Longer than I thought. We're in the over.
Yeah, they're coming back tomorrow.
The Pronato, how long will deliberations take? My guess is however long it takes someone to write guilty 76 times. Cat Rux 88, Steve's the best. Roy Rat, Nick's Alexa has been listening to Nick's show this whole time. Fact. We're already dead by the bot army, and we didn't even know it. Domo arigato, my Roboto overlords. No, I don't have an Alexa in this office. I always say stuff to get you guys in trouble. Project Calm, wait, now they have power over him, just like that. Ornithology Mudbone, this is the worst intro to a 90s rap song ever. Jesus Christ. Try Hard 7. Ultimate humiliation for a black man to plead for his life in front of an all-white jury. Also, I believe the judge has rape fantasies about Darrell Brooks. SRen 30, do you watch the 2012 interview of Brooks in jail talking about meth? It's less than 3 minutes long. I did not. Someone mentioned it. I'm not going to watch it right now, but maybe tomorrow. We
Talking
can do
about
stuff
meth
like that.
as METH.
Yeah, methamphetamines. Judy Brady, 1945. The jury comes back in 5 minutes with a verdict. Lol. Nope. Kept going. John Beck says, lol, Steve is on fire. Disopt. I think chat should have the ability to force rackets to shoot Heaven Hill for a price. Ugh. Blue-Eyed Roof Korean says Boston Massacre trial, where John Adams defended the British troops under the claim of self-defense, was almost sent to England. For transparency, Adams had to sway the Attorney General Sewall to try the case in Boston.
That's a great, I'll tell you, if anybody wants to know about what true lawyering is, John Quincy Adams was defending the British troops. That was a phenomenal story. My friend Phil Arroyo, he's a private practice defense attorney in Orlando. That's one of his favorite stories about how John Quincy Adams defended those British troops against the charges of the colonialists. If anybody wants to look back in history, highly recommend that for great lawyering.
Let's see. Wow. Sorry. What's happening to Chrissy Mayer is insane.
Who?
Barb loves Chrissy Mayer. She's a friend of mine, and YouTube is treating her very poorly right now.
Screw YouTube.
Yeah. Well, the problem is, I think you were away when I was talking about this. She's got a big 48-hour stream coming up on Thursday, or she did, and she just got a 7-day strike on a video that's 5 months old and is all over the internet. Like, there are tons of channels with that video still up, and they're not getting strikes because there's nothing in there that violates the terms of service. So she's invested, I don't know how much money into getting this stream ready. I mean, we're talking, she's from like New York, and she's going to be down in Florida, renting a big house out. A whole bunch of people are coming. I was invited to go, but couldn't make it. And now it can't happen. It's nuts. Barb Loves Alaska says, will the jury go into deliberations tonight? And will there be a jury watch tonight? Yes, there was, and there will be a jury watch tomorrow. Raris says, Nick, any books, resources you recommend for learning more about the history of the U.S. court system? No, I don't have any
Yes.
recommendations off the top of my head. But
I
Steve
do.
does.
Hey, boom.
Oh, your book.
Look at this. I got my book in. Did I show you this?
Yes, you did.
Okay, yeah, I got my book in, and there is a special bonus chapter. See there, I found the opportunity to grift.
There you go.
And
There
that
you
is, I have a bonus chapter on originalism, you know, because originalism is the U.S. Supreme Court's modus operandi for interpreting constitutional issues. And a late edition of my book is a primer on interpreting constitutional law based on originalist content. So this book has a chapter on guiding you how to discuss originalism and how to explore American constitutional history from a kind of a originalist perspective. So go to crimelaw.net and buy my book, which just came in. Look at that, autographed.
There you go.
Everything. In fact, I just got the second shipment, so I have all my books as of tonight. I have all my books that I've ordered sitting out on my front porch, and I have to sign them and unbox them and ship them out. Oh my God. But anyway, so
Mofarex says, if he had only read the rest of his daughter's letter, she authored the perfect closing argument. Blue-eyed Roof Korean says, I know Binger did interviews. Would you ever consider interviewing this prosecutor? Oh, it'd be hard to listen to her. Would appeal take effect? Wait, would appeal affect what she can say? I mean, not dramatically. Would be interesting to get her professional take on this whole dumpster fire.
Her rebuttal closing was perfect. I mean, I must say, I salute that. That was exactly the way you could do a rebuttal. I mean, she was to the point, short, sweet, and slammed him. That was, I mean, the prosecution, I hope that they do this on all their cases because that was a great prosecution.
Blackjack 21, he's skeptical of the Tumblr. Irreverent bastards, and so I clothe my naked villainy in old odd ends, stolen forth from holy writ, and seem a saint when most I play the devil. There you go. Is that I've seen that line. What is that from? Irreverent bastards. Let's see. Okay, I'm gonna just Google it because I don't want to try and think through my literature brain right now. That is it's Shakespeare, of course. Is it from The Tempest or something? No, Richard. It's from whatchamacallit? It's King Richard. What's fucking play is that from? I can't remember. Oh, from King Richard III. Duh. It's the play. Sorry. Okay. And I think it's quoted in V for Vendetta also. Yeah.
Yeah, but I mean, come on. Shakespeare is the root of all great English literature.
You've got to read Ilium and Olympus. Do you read sci-fi books?
Yes. Oh, give me a recommendation.
Here, Dan Simmons, Ilium and Olympus, 2 different books. And if you like Shakespeare, it's great. It's great for a lot of stuff. Mario Kart the 13th, Your Honor, I'm going to inform the jury of their powers of the N-word. Protocon says, Nick, you are a terrible influence on Steve. That's true. Roy Rat
What was that? I missed that one. That one went by. What did it say?
It said, I'm a terrible influence on you.
No, see, the thing is, this people think I'm innocent. I was in a fraternity. I'm as bad. I've just moved further beyond that. It's a choice. It's not a. I am as evil and corrupt and debauchery as the rest of the world.
Oh boy.
And as drunk, boy, I'll tell you, 3 drinks. We're at the limit. I don't know if I'm the
4
3
drinks.
or 4, but we are beyond.
Drinks. It was 4. I'm 99% sure on that.
I've lost track.
Roy Rat says, Mr. Rekieta, do you know any criminal psychologists? It would be cool to have one of them on as a regular guest.
It would be.
I don't know any psychologists who are criminals, but no. I'm trying. I know a couple different psychologists. I don't know if they're particularly criminal psychologists. Used to have a guy who would come on, and I could bring him back on another time, but Eric, I think Eric was his name. I might be mixing him up right now. My brain is broken, But he came on a couple times during like Kim Potter. He came on during Kim Potter. He's a nice guy. Victoria 99654 says, thanks for doing streaming. Oh, you're welcome. Principled Potato, question from jury. How exactly do we ensure this man is hung? Well, you got to pull his pants down for that. The John Beck says, what book is this, Steve? Sorry if I forgot. I don't know what book they're referring to. That was a while back. Blue-Eyed Roof Korean says, when you tear out a man's tongue, you are not proving him a liar. You're only telling the world that you fear what he might say. G.R.R. Martin talking about Alex Jones. Para Grunt says, hopefully his argument about not being a murderer will move the jury to nullify. He goes back home to Milwaukee, Merck's a crackhead, and we get to see him again with Borowski and a ball gag.
Hey, how is it that the chat knows that I was Sigma Nu?
I don't know.
That's crazy.
The internet, man. You gotta be careful.
PHANGG. Steven was a Sigma Nu. How the hell did they know I was a snake?
I never questioned
that is
the
impressive.
chat.
I'm telling you, the chat is impressive. I don't understand how they know that, but yes, I was a Sigma Nu.
Kreese says, as a first-time live viewer looking to see your reaction to a live verdict, you talking over it really just sounded like am static. I was confused. Not a shit talk. This hopefully you get from a true. I don't know what you mean by that. The verdict didn't come in today, so I couldn't have talked over it. I'm not quite sure what happened. No one says, I like you, but not enough to give you 90%. Maybe if you were less gay. Wilcox MD says, Waukesha is also known as Shawtown. Sin Digital Art. Huion is Huion Table, which is a drawing table company, and Huion Hanatober is their 31 days prompt list October haunted Halloween event. Oh, okay. Got it. Bobby Johnson. Nick, you need to stream the train wreck of the Fetterman Oz debate. Is that done? Space Allen says, Steve, how do you think his appeal will go? What grounds, etc.?
Yeah, well, we've addressed this quite a bit. There's no grounds for appeal. Now, you know, we've talked about theoretical appeals and theoretical merit points. Now, if you got a public defender and he's excluded, the public defender is going to look at this record and they're going to say, theoretically, there's some issue, maybe. They're either going to Anders brief it, which I would do probably at this point, or they're going to merit these stupid issues about exclusion from the courtroom. And the court is either going to PCA, it means affirm it without opinion, affirmed, boom, rubber stamp, or they're going to say they're going to create additional powers for the judge. The judge was correct. We've recognized Allen, and we are saying in Wisconsin that you have additional powers, that this additional powers includes putting him in another courtroom and shutting him down. They're going to expand the power of the judge to control her courtroom and make that explicit so that future judges don't have this problem of having to deal with undefined law. So there's no appellate issue in this case that I see at this point.
There you go. The chat is asking for my what I would do for a closing argument for Darrell Brooks. I'm not. I'll think about it. Maybe we'll do that tomorrow. I do think he could have delivered a better closing argument and focused entirely on the intent issue. Because again, that's the issue he needs to get rid of. The prosecutor did a fantastic job, though, laying out all of the intent. He would need to address those things. But I mean, to me, that's where his hope is. And instead,
and defendants dump all over public defenders for saying you need to plea. Right. But I mean, this is exactly the kind of case that you want to plea and you reserve your sentencing, your intent and issues for mitigation, because there's no question that he did this. Right. So now the issue is, well, does he get the ultimate penalty or not? And it's like, well, public defender, you're not fighting for me. Well, what are you fighting? What exactly are you fighting? Are you fighting the facts? I mean, this is
well, he didn't care about the public defender. They're gone.
I know, but any defense attorney, it's like, well, you're not representing me because you're not fighting for my rights. Well, what am I fighting for? I mean, people get confused about what the role of the defense attorney and defense attorneys. You're there to lie for me, and that's not my role. My role is to make sure your rights are protected. and to get you the best deal and to advocate for your interests, but it's not to lie for you.
Right. And we can't.
Can't lie.
Can't do that. Vibe AI, holy crap, dude. Here's to your dad, man. What a life and what a service to his family and country. May he rest in peace and find his brethren waiting for him. Cheers. Rainman 432, just so YouTube can suck it and collect their 30% of zero. Hail to Skins. Pope Nick walks away from LawTube to become the Buddha of lawful LawTube. Crafty, dude. Crafty. Tor Theo. They had to wait and listen to this shit from like 8 or 9 to 6:30 p.m. and then given a mountain of paperwork to do in 1 hour and a half. I fully understand.
Right.
Darmouth.
That's right.
Nick, will you do anything for when your Rumble reaches 100K? I don't know. We're getting there. We're at 88.9 thousand right now.
Wow.
So we're
Good
getting
job.
we're getting up there. There's a lot of people though on Rumble. There's a lot more than it seems because I've seen some channels with I think over 1 million subscribers. So we've got a lot of people to rope into this disaster.
And did I tell you that I've got a Rumble channel?
Yes, it's linked in the description of the video. People can check it out.
But the cool thing is that one of the things is I did my book summaries, and the other thing you said is like, Gosney, they'll love to see you play music and play your guitar, right?
Yeah.
So I'm doing a lot of like guitar playing on my video on my Rumble channel, and it's funny because I got a lot more views on those issues. You said like the people want to see that, so I've been doing some of that based on your recommendation. And it's a lot of mix. I've got some great interviews. I'm proud of my interviews, but I also have the music playing. And so it's because of you that I'm doing that. But a lot of people are saying, we don't want to see you play guitar. Rush 2112. Who wants to see that?
Surveyor 8587 says, Steve, I was going to guess lambda.
Oh,
Il Sarto. Have you ever heard of Ernie Wayne, Turtlegate, the natural man? Probably just as crazy, but yes, I have actually. But his sovereign citizen arguments seem more credible. And I think they've worked for him in some regard. Yeah, I've seen them. He's not charged with murder. Blue-Eyed Roof Korean says 11 sovereign citizens held up Route 95 in Massachusetts on July 4th, 2021 for hours. The Massachusetts Attorney General running for governor hates their AR-15s with a passion, but is yet to prosecute them due to race. Officer Maggot, newly minted Orlando resident, getting my BS in criminology from UMass this December. Just bought a copy. I fancy myself a constitutional originalist. 1776 will commence again.
Bought a copy of what?
Your book.
Oh, man, that's the man. Let's see there. Orlando, Florida man. Buy my book. Awesome.
Tortheo says, did I miss my earlier rant? I was talking about how the jury dealt with this from 8 to 9 to 6:30. We're given 72 charges. No wonder they checked out at 8. No, I just read it. I just hadn't gotten to it yet. Save the Kirby says, does Steve's dark humor know the difference between a Jew joke and a Holocaust joke? One is 6 million times funnier than the other. Oh my God. Oh, jeez.
Boy, that's dark, but I appreciate the insane dark humor there.
Ken Jennings says, curious about Darrell Brooks' mental health diagnoses and explanations of his behaviors during trial. Check out episode 56 and 57 of Ken's Counseling Couch to get an in-depth analysis of Darrell Brooks by 2 master's-level therapists and Aidan Paladin, a popular social psychology YouTuber with a graduate degree in her field.
Read that again. I want to watch that. What is that again?
I'll send you the link.
Okay.
This is my man Kiwi Farms Ken Jennings, and whoops, I'll get it to you.
No problem.
I'll email it to you. Jadine says, why can't I quit you? Well, there's a lot of reasons, but we don't need to go into them in public. In Affy says, be sure to check out the Megan Fox stream with Law of Self-Defense, Andrew Bronca today. No drama, but a really great talk. I bet it was. I bet it was good. Let's see. Next, Matt Calthon says, buddy of mine caught his wife cheating. Any chance you know a divorce lawyer in southern Minnesota around Austin, and any advice for him? Okay, here's my first advice, which I know a bunch of people are going to hate, but before you go running to a divorce attorney, make sure that's the actual proper thing to do, which is that's a tough pill for some people to swallow, because for some, that can be an unforgivable breach of the marital agreement, and for others, it's not. So make sure you're in the right camp on that one. And if it is, I have some recommendations, but none in that area. I don't really know any lawyers down in the Austin area. So, you know, there's a lot of family law practitioners everywhere, though. People I know are all around here. Spatula Guy says, I prefer corporal Klinger punishment. Oh, man, my pizza got here. I can't wait. Very excited for pizza. D.H. Annenson says, hey, Nick, you have a doppelganger. Don't know his name, but it's the motivational speaker who has no limbs. Search that and you'll find him. Yeah, I've seen him. I know. That actually is me. I just have a green screen on my arms and legs. Mafarex says, I think she might be effing with him out of revenge. She knows what's coming down. Next, we got Jay Schwalbach says, it's the court scene from Idiocracy in reverse. Jadine says, Nick, you $2 strip mall lawyer, your grift is a thing of wonder. Oh, thank you. Thank you. Let's see.
Sorry, that would hit me. All right.
Oceanic says, would you and Steve be willing to have a stream sometime to review the Sovereign Citizen PDF he's reading from and make fun of it? I would.
I'd be game for that. You schedule it. You tell me. Once we're done with this trial, I don't know when I'm coming back. So,
well, whenever you have time, you're welcome. So.
I know, but I only like to be on when I have something actually to add.
Right. Well, I mean, that would be something to add, of course.
Okay, but that's a good idea, actually.
Whodunitry says, fuck the judge. People should be praising the bailiff for his patience.
Yeah, that's true.
Whoever's got their hand on the buzzer for Darrell Brooks's leg, that man's a saint. All day, just. Ben SC just ordered Steve's book and sub to his channel. Very cool. Very cool. Thank you. Brodo Baggins says, Nick, I wanted to ask what's the difference between an appointed judge and elected judge, and which is this judge? This judge is both. But the difference being some states have appointed judges and other states elect their judges. In this case, when there's in cases of elected judges, when there is a vacancy prior to the election, either from death or retirement, the governor has the authority to appoint a judge to finish out the term of the previous judge, and then an election will be held. So that's what happened here. Scott Walker appointed her as a judge, and then she won re-election when that came around. Judges win incumbency elections something like 99% of the time, because there really isn't much campaigning around judicial elections. There's a lot of restrictions that are state by state. Some states don't even let them say if they're Republican or Democrats, for example. Lots of them have money restrictions as well that are much more strict than any other races, because they're trying to keep the idea of neutrality in the mind of the justice system, even though, like, let's be honest, everybody has political opinions that pretending that they don't exist actually annoys me. But that's the way they do it. So she was an appointed judge who won re-election, but some states actually just appoint judges, and that's up to the states to determine how they do it. So Just Listed says, not sure what this does, but troll my Instagram at my Placer County home. There you go. You can check out that Instagram. Matt from Tennessee, it's nice to see DAs using VLC instead of Windows Media Player. Yeah, VLC is way better. Way more control over the video. Terra74, Nick, been watching the Emergency Act here in Canada. I have learned I'm a badass for possessing illegal paraphernalia, jerry cans of diesel. Also, feels or violence worthy of rifle butts to the ribs or horse hooves to the head. Oh, Canada. Gross. I could not imagine being in Canada. It's beautiful, but gosh, the government is going just down the tank.
You know, I'll tell you, next time that Quebec wants to secede from the rest of Canada, I think because the rest of the English-speaking folks need to say, we're for it.
Yeah.
Because, I mean, last time, the only reason that they didn't secede is because the English-speaking, the non-Quebecans were like, well, we want to keep Canada together, don't you know? But boy, I'll tell you, if it came up for election now, if I was a English-speaking Canadian, I'd be like, the hell with you, Frenchies. We're going our own way,
Nighthawk Studio says, oh, great and valiant knows Pope. When will we get a painting stream to see what you're working on? Griff for the plastic crack, please. The next one is on Az's channel, and I don't know when that'll be, but hopefully soon. I could use one. John Boy Mag says, Rekieta Law, why you rep your YouTube page on your Instagram? You should rep this locals. I should. I just haven't updated anything anywhere at all lately. Unrelaxed says Darrell Brooks is the Lord of Energy Vampires. Jensen Zeiger, just so you know, there will be a 30-minute to 1 hour heads up to a verdict. Judge wants people to be able to make it in person. The consultant tells Steve, as long as LB doesn't look good, then he can drink more. If the thought of LB squeezing his head between her thighs turns him on, then it's time to stop drinking. Wow.
Who's LB?
We're not going to get into that. Unrelaxed says Gosney's next book should be dating tips. Legardicus, great. The internet retarded so hard the judge had to debate it. As we know from our interactions with Brooks, she seems to feel obligated to address Spurgery. That's that Reddit post. Yeah, she should not.
That was the most
not.
stupid thing I've ever seen. I mean, that was, I started out the judge and I was like, this judge is an idiot. And then as it went on, I'm like, well, there's a strategy here and I'm justifying her, but she went out with a blaze of this idiocy. I must say my opinion went like this, because that Reddit post discussion, and the fact is that she ultimately had to go with the nuclear option with him. She could have done that up front and we would have been spared weeks of idiocy. But instead, she tried to smooth and I can talk him in and I can be nice. And he ended up winning and she kicked him out anyway. And so we're there anyway. So the issue's already there.
Yep.
Ugh. Sad.
Yep. Just a complete waste of energy and time. Nate 490 says, cheers, Pope. Ooh. With an Isaac Bowman Pioneer Spirit. That looks good. Port barrel finish. Yum. They sent a picture of their whiskey.
See, I'm just slow. This is the thing you probably like. It's probably one thing you like me about, because I'm like, I don't get these things as quick.
You couldn't see the picture is the thing.
Oh, okay. I see.
I could have pulled it up on stream, but I'm trying to wrap up here because it's 9:00 and I would like to take a little bit of a breather before my nighttime stream, wherever that ends up being. Matt from Tennessee, don't fold, be bold, buy gold. Boomstick dude sent Rumble, a locals chat says, Rackets, let Steve know I just ordered his book and look forward to reading it.
Oh,
there you go. Very
thank
cool.
you, sir. And I'm sending them out. Like this week, I'm going to be shipping them out. So thank you all for buying my book at crimelaw.net.
DJ Laser sent a picture of Brooks with a stupid look on his face, says, did I do that? And then Paragrunt sent another one, same face. It says, so what about subject matter jurisdiction? It's his stupid smug face where he's like this right at the end. Oh, God, I could have punched him.
Gosh.
Not a robot. Here's the real question, Gaylord. Are you going to flack out on international shipment? Not all these mongoloids who support you reside in the communist states of Maryland. No, I'm not. I know it's going to cost me a lot. So I'm not going to flake out on international shipment. I'm, like I said, working with the manufacturer on shipping right now, but we're going to be doing it. This is going to be a very, very expensive gift, and it's all for the Rumble or for the locals community. So Royal Plague says, look at the post above, Judge Mommy without the robe in a green dress. Oh, no. Stop. I actually don't know where that is, where you sent that, so I can't see that picture. M4A now says, one drink Gosney is a legend.
One drink. I'm way beyond one drink. I don't know. I'm gonna have to watch this back and see if that I'm even coherent, because I'm not sure.
You're doing fine. Ddon65 says Chrissy Mayer's Twitter is blowing up. Everyone, please tweet if you haven't. Yeah, what is happening to her? Seriously, it's insane. This is not a terms of service violation. EA Cowden says, I would say half a day for deliberations just because of the sheer amount of paperwork.
Right.
Roxev says it's a good thing he's religious because he's going to be on his knees a lot in prison. Ajo Nutso says, I think the man behind Brooks in the puffy coat is the same guy who was hired as private security for the family during Kyle Rittenhouse's trial. Anyone else recognize him too? Someone else did say that.
That's odd. That's a strange thing. I don't know what that was.
Lagardicus says, color of law. I'm suddenly having flashbacks to Mountain Jews, martial law, and the good old days of laughing at entertaining pro se morons. Yeah, well, there's more of that to come too. Although, I need to have Melinda on so she can blame me for her husband's death. Algebra says, Rekieta Law, what color is the law? Black. Like my soul.
Souls of black. Testament, man. You got it.
Marhot 56 is insane. Now the DA is telling the judge what to do. Yeah, this judge gets caught in a feedback loop with Brooks, and I think she's addicted to the argument. It's weird.
Yeah, there's a pathology between both Brooks and the judge. He has got her number, and boy, she's got her weakness, and she's playing into it. I don't know. I mean, we're all imperfect, but boy, this is something to be studied.
Darrell, I got your number. That's his next song. Matt himself says, for what reasons are you raising jury nullification? To let them know. What do you want to let them know? Because it benefits me. Oh, sorry, you are arguing it. She kept making this distinction between argument and he's like, but I'm not going to argue it. If you inform them during your argument, it is an argument. That's done. You cannot do it. Fire PA 498. Contrast this to the elected DA in the Rittenhouse trial, Nick, who didn't want to be anywhere near Binger. Yeah, that guy could smell the stinker of a case against Rittenhouse. I'm convinced of that. He knew he would lose, and if he lost, it would look really bad. John Boy, because that guy was very, very left. The DA in Kenosha.
I don't know the politics of this prosecutor. Do you?
No.
Yeah.
Let's see. Jolene says, well, for one, I'm 12 beers deep, Steven, you amateur.
Well, this is not beer. This is like hard liquor. This is a sidecar, which is, I told you, it's 1/3 Cointreau, 1/3 Fundador brandy, and 1/3 Rose's sweet and sour. That's what a sidecar is. So it's sweet, but it's not lightweight.
Let's see. Okay, I have to read that later. John Boy Mag says 760 plus in chat. Oh yeah, the locals chat is it's something else. Sheepsidian says, this is why women shouldn't be given any kind of leadership. They talk too much. Save the Kirby's, Steve, and maybe Nick. Check out Austin Death Machine, thrash metal with songs and lyrics entirely from ANHULD movies. My favorite is Get to the Chopper. Oh, Arnold movies. My favorite is Get to the Chopper. Okay.
I'm looking at it, man. Death Machine. Yeah, I got it. I love the music suggestions, by the way.
Let's see. Oh my God. Darrell says, would you have Chrissy on because of what's going on? Yeah, I'll reach out to her and see if she'll come on for a night show or something to talk about this. Absolutely would have Chrissy on. She has my full support. I don't know what more I can do. I can't tweet. That's the thing that makes me mad because my Twitter is banned. I can't.
See, it doesn't make me mad at all because I don't have Twitter, nor have I ever been on, nor do I want to have Twitter. I've heard about the toxic world that is Twitter.
Yeah, Twitter's terrible, but when my friends get banned from YouTube, the only way to get that resolved is on Twitter. And so I can't like tweet out in support of her and try and get Team YouTube on the bus, so to speak. That's what I'm talking about. Terra 74 says Brooks should have used media reports as his defense. They started out with the car that ran through the parade, avoiding the person behind the wheel. And then a couple over on Odyssey here. The Drunken Rocky says, if the windows have tint, you must acquit. Mr. One Ball Whale, this guy is a riot. I hope he rots. I don't really want a channel, says, how the heck is she this patient with him? Very good question. Ancient King, why doesn't the corrupt system want jury nullification? I wonder. I'm not going to get into it. Ralph Akun says he stand his grounds. Jay Winkler, Nick, I got news for you. That means you're gay. Glowing One says, you guys are going to commit insurrection at the ballot and racist Nazis need to be stopped. Okay. Nate Higgers says, when the man for the McDonald's asked and had the mayonnaise and the employees went and they put on the side burger and not when how when the picture was taken, it was mayonnaise and the McDonald's.
What? The incoherence.
Sci-Fi Audio Library says 4 Boxcar Steve is best Steve. Jay Winkler, I got news for you. Means you're gay. Steven in Uncivil Law, you're super gay. Glowing One says, nice job, 4chans. You anons fucking did it. Jack Crow says, caw, caw, caw. A retro gamer Darrell Brooks is why the white man used to wipe black people. Oh, wow. America Inc. music for some based metal. Listen to us, America Inc.
Hold on. You got to repeat. I'm taking stock of all music recommendations. Say it again.
America Inc. like Incorporated, INC.
Okay.
Witch Hunt out this Halloween. And then here's a link to it. I'll share it in the private chat so you can pull it up. There you go. And gosh, I think that's about it. Doug B2 says, how do you think his life might have turned out if you ever learned to shut up while other people are talking? Better. Jadine says, look at that glass, please. What glass, Jadine? What are you talking about? Let's see. Are you talking about this? What even is this? I can't even see it. Okay, never mind. I don't know what you're talking about. Matt himself says, Clay N. I'll speak for all the recipients. Thank you, sir, for the gift and all the nights of laughs and occasionally some great wonders of pure wisdom. Thank you. Well, let's get the gift out to people first. It's not going to go. Whew. Jadine says, that being said, love you, Steve. And I think we're done. I think that's it. Oh my goodness.
Really? That's it?
Yeah, that's it. Okay, guys, I got to shut this stream down. Steve, thank you so much for joining me. Gosney's sorority girl glass.
What?
Oh, they're talking about your martini glass, I think.
Oh, well, I get accused of drinking girly drinks, and I do like street. I know I do like sweet, but this is definitely. But my wife is the lightweight. I'll tell you, she drinks half a martini, and she's like, I got to go to the hospital. So it depends on who you're going against. I know I can't hang with you, but I can. I think I did my damage with the high alcohol content. I don't know, 3 or 4 or whatever the hell it is tonight. But hey, thank you for the invite, Nick. And it's been a pleasure. Maybe we'll catch up tomorrow to do the jury watch. But
I'll send you a link if you're available.
But I've like I said, I've got 80 hours to burn between now and the end of the week or the end of the year. Shit. But
all right, guys.
Anyway, thank you.
Yeah, man, my pleasure, and thanks for joining, guys. I'll announce on Locals what I'm doing next as soon as I figure it out. I hope you guys have a good night. Peace.
He drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Darrell. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits blow as the ones who get unemployed. So pour out a glass for the T-post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out an odd bag of Balmore and Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Painting tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what